Behind every crime lies a story waiting to be uncovered, from chilling mysteries to untold truth. This is where the darkness comes to light.
Green bars lights up the air, faces tense as stories tear, truth and lies like a tango dance. Justice here takes no chance. Gavel strikes, hearts beat fast. Witness takes and shadows cast. Whispers loud like wildfire spread. In this game, none's ahead.
Hello, good morning, everybody. Still coming to you with a very cold, a bad cold. I today my headache is not as bad as it's been, but I just want to say that I'm very snotty, so that's why I don't have any camera on today. Um, so I because I need a tissue every 5 seconds. I decided not to have a camera because I would have to turn off the camera every 5 seconds to be able to do what I need to do. But good morning, Toxic. Good morning, Lois. Good morning, Paula. Good morning, everybody. It is Thursday. It is a brilliant day. Today's going to be the day we kind of finally hear the cross examination. Um, from the prosecution to Zachary Hughes after a very spicy day yesterday. I mean, I had to rewatch the stream after I went to bed because I last night it was not a good night for me, and it was not a good night for a lot of people. For Zachary, it was not a good night, and for John Mello. I've heard and I've seen that was definitely not a good night for those two. So Zachary, after yesterday, after his explosions in court, he got it was already in held in jail anyway. So the what happened? So it's just like now he has to serve 6 months no matter what happens in this. Um. Oh, like if I'm sure it is gonna be good because I hope like I'm not gonna say anything because I was hoping in a certain person's trial that the name shall not mention, Colin Griffith. I thought that the prosecutor was gonna get spicy, and he got mild, not even worth the spiciness. There was almost no spiciness, but um I thought of going live a little bit earlier too, so we could do like a kind of mini recap of the testimony of Zachary Hughes. So that we have that we can do before we actually go live. Um, so what is happening? So Zachary used testified to analyzing Christina Parcell, arriving with a box of roses to the house, and he went into a very detailed a current of events to how he did it, and then he said twice that John Mello offered money for him to unalive Christina Parcell, 5K in one occasion and 10K in another. And then that he said that Mello told him where everyone in the house would be the day of the unaliving, and that also beforehand he told Zachary. And this is one thing, like now doing a bit of a side thing that I am thinking, right? Zachary said that he was manipulated by his sister Grace, right? So you would think that if someone was manipulating him, he would notice because he already went through the experience, right? But yet he let the John Mello manipulate him to the highest things, or maybe it was easier to do it because he's already been manipulated once and he did not see that coming from. Hello, good morning, Case One. Today you're not late. Today you are right on time. Now I'm joking. You always right on time. Court has not even started. So they are in court. The judge and the attorneys and everyone, they are in court, but they are hashing out the jury instructions. So they're talking about all of that. Obviously, because it's outside of the presence of the jury, we're not privy to it. Good morning, Maria. Buenos dias. Welcome in. Hello, hun. Well, it's good to see you. um Sorry, still not camera today, but I my cold is on phase 2 of my cold, but still, yeah, fighting a horrible cold. But then, um, where was I? And we're doing a recap of the testimony of Zachary Hughes yesterday. So he told the jury that he felt relieved after the unaliving because Christina's daughter would be no longer be S8. So, oh no, it's okay, Maria. I know. I am so sorry. This trial, but you can always, like watching recap and get our reactions live ish. So yeah. Oh, you watched that? Awesome! Because I've got permissions from the creator that recorded this or got the footage to use it, and I was gonna plan for to show you guys anyway as well. But we can see it because I've watched a little bit, but not the whole of it because I had to recap so much out of it. So how do you not notice that John Mello was manipulated? That is where I have a problem with testimony, all that and all that info we and I understand that, and I absolutely agree with you. How did they not see the manipulation coming from him, since he's already been manipulated before by his sister? And I'm doing air quotes, and also for the simple fact that um the whole, I don't know why the state did not said hearsay once about this whole testimony, but probably because he's the defendant, he can in a way. I don't know. So I was gonna plan to play the hearing, the one hearing from I was gonna say, I'm so sorry. I was gonna say the bond hearing from case one. No, it's not the bond hearing for case one. My apologies. Is the bond hearing from John Mello? My brain, it's just all a big mush up there. So I'm gonna just share that. And again, apologies, case one. It's not your bond hearing. It's John Mello's one. So let me just set that up because I definitely was not ready. So we're just gonna play that and then we can discuss it. Hopefully the sound will be fine. Let me put headphones on and check that out.
I see you. I'm just curious. Oh, okay. I just never heard of you before, so that's. Okay. I'm taking notes for my brain. All right, here we go. All right, are you Mr. Mello?
Yes, sir.
Mr. Mello, I'm Judge O'Brien. I'm going to read you your rights. You have the right to remain silent. You have the right and obligation to be present at your trial. If you fail to show up for your trial, they'll place failure to appear charges against you, and you could face an additional 1 to 5 years in jail. You have the right to a trial by jury. You have the right to an attorney. If you cannot afford an attorney, one can be provided for you through the public defender's office. If the charges that are placed on you are discharged, dismissed, not prosecuted, or if you're found not guilty, you have the right to have your record expunged or wiped clean from these charges. Now, you're being charged with a criminal offense, and if you were found guilty, you are facing serious consequences, which may include the payment of a fine, the loss of your driver's license, and the possibility of a jail sentence. In addition, you may face increased penalties for later convictions, the loss of your right to possess firearms or ammunition, and your immigration status could be affected. You have important constitutional rights, including the right to representation by an attorney, but you may lose those rights or waive them if you do not act to protect those rights. You have the right to hire an attorney to represent you in every case. If you cannot afford an attorney, you may be eligible for a free attorney. If you want a determination made as to whether you are qualified for a free lawyer, then it is your obligation to be screened at the location identified in paragraph 5C of the bond checklist form that I'm going to give you today. If you do not hire an attorney or go to be screened, then you may be found to have waived your right to an attorney at your trial. You also have the right to represent yourself. However, you should be aware that self-representation can be dangerous. For example, there may be certain factual or legal defenses to your charge that you are not aware of. or legal issues related to the conduct of your trial or guilty plea that an attorney would know how to preserve for an appeal. If you exercise your right to proceed without a lawyer, then you are responsible for complying with all applicable rules of court, including rules of evidence, procedural rules, and proper behavior before the judge and jury. If convicted on the charges filed against you and ordered to pay a fine, you may request a reasonable scheduled payment plan to pay that fine. It is your obligation to keep up with your trial date and to obtain an attorney, either by hiring one or by being screened and found eligible for a court-appointed attorney prior to your trial date. If you do not appear at your trial with your attorney, you may be deemed to have waived your right to have an attorney represent you. And finally, you are required to keep the court notified of any changes of your address until the completion of your case. Do you understand so far, sir?
Yes, sir.
All right. Mr. Mello, you're being charged with solicitation to commit a felony and accessory before the fact of murder. These are both general sessions charges, which means you have an additional right. You have the right of a preliminary hearing. The preliminary hearing is an evidence hearing where the state has to show that they have the evidence to take you to court. If you want that hearing, take the form I'm going to give you and fill it out. You can mail it or take it to the address on the form, or you can fill it out tonight and give it back to me. But you only have a total of 10 days to get that form turned in. Otherwise, you lose your right to that hearing. Now, accessory before the fact to a felony is a violent crime in South Carolina. Based on the nature of these charges and the situation involved in these cases, this case, I am going to no bond you, and I'm going to send you to the circuit court for a bond hearing. Your next court date will be sometime in the next 30 days. I can't tell you if it could be 3 days from now or 30 days from now, because that'll have to be scheduled by the solicitor's office. But at that point in time, it'll be up to them to decide as to whether to grant you a bond or to keep you in jail until your court date. Do you have any questions?
I don't think so, thank you.
All right, sir, sit tight right there. I've got some papers for you to sign. And also, when you finish that, sir, just sit tight for a moment, okay? All right, Mr. Mello, one more thing. It's my understanding that Tina Parcell is in the courtroom. Tina, as I understand it, you're the sister of the victim. Is that correct, ma'am? Would you like to say anything to the court in reference to this proceeding? Please, go ahead.
Well, just remember to do this. Every 1,224 days for this. I wish you could tell you it felt really good, John, but it's not going to feel good yet. I did it every day of this college. One witness to what you all have done. Every day of this college. Every day out of this college. My family, your family.
Sorry, recapping to see if it was the daughter. No, I don't think so. I think it's just someone pretty.
24 days for this. I wish you could tell you it felt really good, John, but it's not going to feel good yet. I did it every day of this college. One witness to what you all have done. Every day of this college. Every day out of this college. My family, your family. You did this to your family. Your child has to know that you did this to her family. I don't know where I would be in this college, but I assure you, if I had all capable, I would be there every day. When you are convicted, I will be there at every parole hearing. Everyone. You will never get rid of me. And that is your own fault. You did this to yourself. So I have your own. Thank you.
Thank you, Ms. Parcell. I appreciate you coming. Mr. Mello, do you have any questions before we end this?
Nothing.
All right, sir, you're free to go with the officer.
Hang on, we have another angle. We did this. The sound might be better. Let's watch. We have some time to watch it.
Okay. I'm taking notes from my brain. All right, here we go. All right, are you Mr. Mello?
Yes, sir.
Mr. Mello, I'm Judge O'Brien. I'm going to read you your rights. You have the right to remain silent. You have the right and obligation to be present at your trial. If you fail to show up for your trial, if you fail to show up for your trial, they'll place failure to appear charges against you, and you could face an additional 1 to 5 years in jail. You have the right to a trial by jury. You have the right to an attorney. If you cannot afford an attorney, one can be provided for you through the public defender's office. If the charges that are placed on you are discharged, dismissed, not prosecuted, or if you're found not guilty, you have the right to have your record expunged or wiped clean from these charges. Now, you're being charged with a criminal offense, and if you were found guilty, you are facing serious consequences, which may include the payment of a fine, the loss of your driver's license, and the possibility of a jail sentence. In addition, you may face increased penalties for later convictions, the loss of your right to possess firearms or ammunition, and your immigration status could be affected. You have important constitutional rights, including the right to representation by an attorney, but you may lose those rights or waive them if you do not act to protect those rights. You have the right to hire an attorney to represent you in every case. If you cannot afford an attorney, you may be eligible for a free attorney. If you want a determination made as to whether you are qualified for a free lawyer, then it is your obligation to be screened at the location identified in paragraph 5C of the bond checklist form that I'm going to give you today. If you do not hire an attorney or go to be screened, then you may be found to have waived your right to an attorney at your trial. You also have the right to represent yourself. However, you should be aware that self-representation can be dangerous. For example, there may be certain factual or legal defenses to your charge that you are not aware of, or legal issues related to the conduct of your trial or guilty plea that an attorney would know how to preserve for an appeal. If you exercise your right to proceed without a lawyer, then you are responsible for complying with all applicable rules of court, including rules of evidence, procedural rules, and proper behavior before the judge and jury. If convicted on the charges filed against you and ordered to pay a fine, you may request a reasonable scheduled payment plan to pay that fine. It is your obligation to keep up with your trial date and to obtain an attorney, either by hiring one or by being screened and found eligible for a court-appointed attorney prior to your trial date. If you do not appear at your trial with your attorney, you may be deemed to have waived your right to have an attorney represent you. And finally, you are required to keep the court notified of any changes of your address until the completion of your case. Do you understand so far, sir?
Yes, sir.
All right. Mr. Mello, you're being charged with solicitation to commit a felony and accessory before the fact of murder. These are both general sessions charges, which means you have an additional right. You have the right of a preliminary hearing. The preliminary hearing is an evidence hearing where the state has to show that they have the evidence to take you to court. If you want that hearing, take the form I'm going to give you and fill it out. You can mail it or take it to the address on the form, or you can fill it out tonight and give it back to me. But you only have a total of 10 days to get that form turned in. Otherwise, you lose your right to that hearing. Now, accessory before the fact to a felony is a violent crime in South Carolina. Based on the nature of these charges and the situation involved in these cases, this case, I am going to no bond you, and I'm going to send you to the circuit court for a bond hearing. Your next court date will be sometime in the next 30 days. I can't tell you if it'll be 3 days from now or 30 days from now, because that'll have to be scheduled by the solicitor's office. But at that point in time, it'll be up to them to decide as to whether to grant you a bond or to keep you in jail until your court date. Do you have any questions?
I don't think so, thank you.
All right, sir, sit tight right there. I've got some papers for you to sign.
Right, let's skip the paper signers again, see if we can listen to the sister better. That's why I wanted, because the sound is a lot better.
As I understand it, you're the sister of the victim. Is that correct, ma'am? Would you like to say anything to the court in reference to this proceeding? Please, go ahead.
About Christina, maybe she deserves to be here for this. We have waited 1,224 days for this. And I wish I could tell you it felt really good, John, but it's not going to feel good yet. I've been at every day of this trial. One witness to what you all have done. Everything in this trial, everything out of this trial, with my family, with your family. You did this to your family. Your child has to know that you did this to her family. I don't know where I would be when you go to trial, but I assure you, if I am at all capable, I will be there every day. When you are convicted, I will be there at every parole hearing. Everyone. You will never get rid of me. And that is your own fault. You did this to yourself. So I have your, thank you.
Thank you, Ms. Purcell. I appreciate you coming. Mr. Mello, do you have any questions before we end this?
Nothing.
All right, sir, you're free to go with the officer.
Thank you.
So that was the bond hearing for Mr. John Mello yesterday. So which he doesn't get one. He doesn't get a bond hearing because the judge said no. And he's not getting a bond here because probably he has very easy ways to get away from the country and just just get a notification of a case that I'm following and I'm working on. The Lucy Letby case. I'm still working on that one. It's so much information that is crazy. Oh, actually, sorry, I forgot to do something on here because before toxic kills me. No, I'm joking, and alives me. I turned off the reaction. Sorry, I've done them now. So court is in about 5 minutes, I think, hopefully, because jury is going to come in, or they said the jury was going to come in about half 10. Was it a half 10? Yes, half 10, which it was a half 10 or a 10. I'm confused. No, half 10, but because it was a half an hour delayed. Yeah. Okay. Oh no. So it just got a notification that court has not even has started yet on the live thing. So it was supposed to begin at half 10, like we were just saying, and it hasn't even begun when. Yeah, the thing is, like, the sister has the right to, like, she was upset, and I don't blame her. I mean, it caused a lot of pain and suffering to the whole family, and she's absolutely right to be angry and to um absolutely go off. But I mean, that's her life now, and sadly she's gonna have to live this for the rest of her life, as long as John Mello is alive, as long as she's gonna have to deal with this situation. And then the daughter is gonna have a lot of marks, because now I don't know if I believe that, like, Christina was not the best parent because no one is perfect. And also that she's probably was in websites that she shouldn't be. And she had worked previously as something that the lady of the night. I'm not saying that. But now abusing, it's a bit too far. And we only have two people saying that. I've only heard Zachary and Mello saying that. Right? We know that Bradley Post is in jail, is in prison for that, but he hasn't squeaked or said anything about Christina. So all we know is John Mello and Zachary's side of things, and you can take their word as two pennies. So I kind of feel bad for him, but I kind of don't. He's a grown up. He made a decision himself of letting be manipulated yet again by a second person, and by a second person, if the Grace sister thing is actually truth, because I don't believe a word almost that Zach says. But then again, he let himself be found in this situation again. So yeah. So I don't know. I think Mello was the vindictive person, is the vindictive type of person. You're not mine, but then you're not going to be anyone else's type. He was not happy, probably, that Christina was with somebody else. So he orchestrated this whole thing and sadly made Christina not be part of this life anymore. And that is the sad thing, that now there is a kid, a 13-year-old in South Carolina, that's lost basically both of their parents and almost all her family. All she has is her aunt. And she is going to be traumatized, sadly, for quite some time, and even it's going to impact the rest of her life. And that is absolutely sad and gut wrenching part of things. Because it is not fair. And hello, Nightbot. Welcome in. Good morning. Finally, good for you to wake up and join us. Oh yeah, he is. I mean, like, and the thing is, the fact that the sister was a little bit snarky or spicy at the bond hearing yesterday, of or and the friend that was helping placing the Dr. Pepper in. Tell him off, Lois. Tell him off right there. Well done. Really, really well done. Um, so the fact that the friend of the sister was placing the Dr. Pepper right there where you could see, just to spite him, because apparently he hates Dr. Pepper. He doesn't really like it. So it was just the perfect thing to do. Like, literally, you could see her on this last footage that we saw, like, literally putting the the Dr. Pepper in place, so he could see it and he could literally, like, that was funny. You're not the exception to the rules. We all have to obey by the same rules, Nightbot. Still. So that I absolutely love that part. I mean, it was the breaking news. I think yesterday it was. Why do I always have to miss everything that is spicy? Why? Why? Every single time. I think was when the last trial, and I think Zio talked about this the other last night. Um, uh naughty night, but that anything that spicy happens, like, for example, even last week, when was last week on the Megan Boswell, we had the ME talking about the she did the mic drop moment, getting out of the stand. I wasn't here yesterday when all this spiciness was happening. I wasn't here. So I think we know the common factor: if I'm not here, spicy things will happen, because then it's just the old plain boring chord. Joking. So it's just like, I just found it funny that very spicy thing happens when I'm not here, so I have to live more often. Is that what we are saying? No, I'm joking. I'm not gonna live often, only on Wednesday nights. So yeah. I mean, it's absolutely crazy. I was actually talking to a friend today at work, and she was like, because she's been busy because her husband just had surgery, so she hasn't been able to tune in to the court streams. So she was asking, "Oh, so which cases are you following now?" And I did a brief resume of this case to her, and her jaw was almost literally on the floor. She was like, "I need to rewatch it." And I was like, "We can rewatch it at speed watch, because the thing is," and I explained the jury situation and everything, that um you're gonna have to catch up to a lot, because the judge has decided that when the jury's not present, you know, we cannot see it, so you can skip quite a lot of bits and pieces, and they're short days. um so yeah. No, I haven't said anything about the stickers, Nightbot, but we thought I was not going to say anything about the stickers. Now I have to talk about the stickers, Nightbot. So I was just talking to her, and I think she's gonna be watching, because that's this one is one of to watch. Um, why then talk about it, Nightbot? 1 second, give me 1 second. Like, yeah. Good morning, Ivamos. Buenos dias. Sorry, I was just telling Nightbot off because well, now the cat is out of the bag, quite literally. So he was talking about the stickers. We had some stickers made for the channel, and I was gonna use the stickers as the game prize for the verdict game that we play in this in the channel. I want to show you guys the stickers, but I haven't taken pictures of them or anything. So I'm gonna ask Nightbot now that to do that, to take the pictures of the stickers, and then I can show you guys. I mean, I'm gonna use them to send out to as the price, but if you guys want it, I can send to you as well, if you want, because I know sometimes like winning the verdict game, it's not hard, it's not impossible, it's very doable, but it's just, yeah, if you want to just reach out to me. You guys know where to find me. You can find me in Discord literally most of the time, half there. I'm always there. Just reach out to me there. My name there is the same as here. So I'm gonna take some pictures of the, sorry, I needed to refresh the feed of the stickers so I can show you guys, because I am now excited for you guys to see the stickers, and then see what you guys can win, or if you want the stickers I can just send them, but don't go at the same time, because yeah, no, I'm joking, postages should be fine, but this one is a little bit light, dark. Let me turn on an extra light just to send. Just trying to take the pictures as quick as I can before. Well, we have plenty of time because we are on that half an hour delay. It's not like court. Um, Oh, okay. So court is delayed because, well, they haven't said the reason why court is delayed, but there has been a snowstorm in South Carolina, so I am assuming that is why. There might be some jurors that are stuck in the snow, or transport might be harder or anything, so they are uh maybe waiting on someone or some jurors to come in to for the court to start. So hang on. So I just have one more picture to take, and then I can show you the stickers. So bear with me a moment, because I'm literally just finishing them now. Okay. And now I'm just gonna send the pictures to my computer, and then we can look at it. I hope you guys like it, because now I'm like, let's send it. He's taking the bike to court. Well, he's in jail right now, so I don't think he can really take the bike. But that could be that would be funny. Okay, so here we go. Just light them up. So I'm gonna stop sharing that, and I'm gonna show the first sticker. Ooh. So I just got word from the court, so half an hour from now, that Zach is on cross examination. So sorry, I need to share this. Hang on. So this is the first sticker that is made. That one was actually Nightbot's design. I really like the little. Well, all of them were your design, but my idea. So it's just a little rabbit. It's really cute. I like it. So that is the first one. I think I can close it safely, and then need to go grab the next one. The next one is coming up. 1 second. Okay, so that is the second one. Oh, can you guys see? Yes, it's a little bit more like darker in a way, but I like it. It's actually quite cool. So now I'm gonna put the other one after that one. So this, I wish there was a better way to do this instead of having to click one by one. So this is like the channel one, and it has our channel logo, and then the congratulations on winning the judgment game that has Nightbot as call it now. And so that is the other one. Sorry about the reflection. The reflection is not part of the stick. It's just the way I took the picture. So don't worry, you're not gonna get the reflection sticker one. Yeah, so it's like that is the that one, and then there is the final one for now. I mean, we can add stickers. We're gonna be like swapping it out, changing it up, and have several variants. So this is the last one. So this apparently is supposed to be me. I don't know the resemblance, because I don't think I have blonde hair, highlights, or yeah, but I like that one too. It's, I think, supposed to be me, apparently, by how Nightbot perceives me, I guess. It's very cute. Yeah. So yeah, so those are the stickers that we have right now. Um just if you want them, just reach out. And yeah. Um yeah, it's a circular badge like one. So there is some movement in court. So huh? Hang on, what? Sorry. Um so I'm just getting updates from, all my days. I'm not gonna spoil for you guys, but okay, like, oh. Thank you very much. In case when I have very big eyes, don't I? On the stick. Okay, on the stick. Oh, you are hilarious. A good thing that I saw that on the sticker. So, so that's hilarious. There is, I don't even know what to say. Do you guys want to know? Do you guys want to wait half an hour to find out what's happening in court? Because I know, I I don't know what you want me to tell you. Okay. So, Cross started, right? They asked one question, because is court mandatory case one. The judge has the man said that they had to have a half an hour delay by the court, and only show when they are on the record, and when the jury is not there, they cannot show anything else. So that's why this case has been like this. So, Cross, one question was, when you dragged Christina after you went alive to her, did you grab her by the arms or by the ankles? Zach doesn't remember, and that was all. The defense has rested. That was the whole cross of that case. Are you serious? So the whole cross was one question. Um and yet again we've been let down by the prosecution. Like, because I was expecting way more than that. I was expecting way more than this. Cuz that was a big bolo of nothing. I They might be playing it safe because they don't know if, like, Zach is, oh, feed is up, and of course they have that. Feed is up, so yay, we are moving. So I just, I know why this trial is too much. I know. I was like, holy candle on a stick. I mean, I bet you guys better play the verdict game, because we might be watching closings today. We might be on verdict watch today, and I was not ready for that. I need to set up verdict watch. Um, so that is interesting. That we might be on verdict watch. Oh my days! This is wild. I was not prepared for this. I thought that the cross was gonna be spicy, that we were gonna hear more than we actually did. Um, and this is all we get. Is this all we get? Honestly, I mean, it's absolutely. I don't know which one to do. Hang on, I'll do this one because sorry, just swapping something here. Uh, but I was like, I don't understand. I absolutely don't understand that. Um, how the only thing that they do is a cross. It's one question. I just oh okay. Hang on. I need a pen, my paper. I need the paper to write down people's guesses if you are. So, well, case one, you have until the end of closings to play. So you don't have to play right now. You have until the end of closings to play, and you can change until then. So, 2 to 3 hours. I've got yours, Toxic. Thank you. I mean, you have until the end of closings to play. If you want to change it up until then, also you can do that. That is not a problem. Absolutely. It's just after the closings finish, the close the game is closed as well. Sorry, I just decided to change feeds because yeah. So uh yes, awesome. 1 to 3 hours. Wow, that's brave, Lois. That is absolutely brave. I need to open the Google form. Um, well, I hope the internet now it's more stable than before because we actually finally you are okay. I all right. No, absolutely no problem. Case one, we'll be here anyway. So, um, what was I gonna say? Oh, the internet. Yes, the internet should be a little bit better because we actually they're actually finally done with the internet and we've got the new one in. And why is it this not working? Oh, okay. Sorry, I just saw I'm looking at the submissions for the verdict game, and I just saw that's awesome. Um, you are very daring, Lois. I just saw yours. It is well. I mean, I don't know. I am on the guilty side, but on the length, I do wish you would gonna. Yep, Lois the Great. Sorry, that was what I was laughing about. I did not know if you wanted me to say it or not. Um, sorry, I just need to keep my throat hydrated today because the throat is gonna be the one next, and I need my voice. But I did not expect this trial to finish. I mean, there is a potential trial we can start tomorrow already because I've been scouring the world of YouTubes and the world of true crime, and there is a potential trial we can start that think started yesterday. I think it started today. It's actually no, it started actually quite a few days, but it's short days, which is appears. I don't know. I need to do some more investigation. Um, oh, I am so anxious too, Lois. I don't know what is gonna happen. Oh no. It's kind of probably a bit more waiting than um actually listening to cross or anything because I know I wish I could spit it up but I can't. But yeah, it's gonna be more waiting. Um Definitely. The thing is, this trial that is started like 1, 2, 3 days. I don't know because it's just short length. I need to ask Nightbot for a favor. 1 second. Give me 1 second. Box. So sorry, Nightbot is just doing a favor for us. I know it is. I am a bit disappointed because I was so looking forward to this cross, and I had so many hopes and dreams, and I wanted spiciness. I was born for spiciness. I want spiciness. But no. Now we're gonna have to endure the disappointment of that cross, and hopefully that they actually gonna bring it home. I just don't understand. Um oh, so it's Lois, I let's hope so. But I don't think so. I am sorry. I don't want to break your hopes and your dreams too. Um but hopefully they will bring it for closings. I mean, they have to. It's man, they have to to bring it for openings. It's absolutely gut wrenching is if they don't. Um, because I want spiciness. I think we all want spiciness, right? So I think we are due some spiciness, and yeah, it's just not so. Oh, hang on. I was not even live on the feed. But we did not miss anything, so don't worry. Sorry. It just yeah, I okay. I doesn't as just trying to show to find some information on something while I'm talking and while I'm doing something, but it's not working out very well. I might have to do it later. But I wanted to see if we could start our new trial while we were on deliberations, like normally we do. Um, I don't know what they could have asked, but could have asked more questions. Well, not about this past because that's not important, but just to reiterate again that Ian lived her. Because I mean, if he's so open about it, just go over it again and ask the questions, even though but then that the thing that could be that could be yeah, that could be just a way for Zach to say again about yes, I see something. So I don't know. Yeah, probably. Yeah. Um I think he slept a lot through it, and he might have slept too much on it, but yeah, I don't know. Thank you, Nightbot, for that. I appreciate you. Um, but it's just crazy that how can that be that's how's like they lost such a big opportunity to do yeah, to do things, but no, they did not. Um, so if you guys, by the way, have any if you want to suggest a trial or something to follow, just please feel free to do. Feel free to reach out to me. I'll put a link on the chat for my email so you can reach about a trial that you want us to follow, consider, or something. So there's the email you can use to yeah to suggest a trial or something, or even just, doesn't matter if it is a big case, small case, little case. If it is in the eastern side of things, of like the eastern part of America, that would be amazing because of the difference of the hours and everything. But if it's not, well, we can definitely see something else. um well, see it and maybe just do it on a catch up or something. But yeah, so that could be an option. I was just trying to look for if there's something, anything out there, um that we could, because the one that I was looking, that I think started a couple of days ago. Nightbot had a look at it, and I think he thinks it's only 2/3 of it, and that is not good. I don't want to only having a small part of it. That is no point of watching it because we're losing half of the information. Sorry, 1 second. Apparently, I'm needed. Then again, I need to do more research on that case, because it seems it is the whole trial, but um it's like it starts very, very in funny ways, so I don't know, and I don't know how. I need more information. I need to dig more. I need to work my magic on the keyboard and just search about it. And if I knew the name of the person, I would say, but I don't even know because it's not on the um on it. Oh, okay. I think I find it. So I think we can start finding some information about this case, and I can do, because now I can actually be doing other things, talking to you guys, watching court, and actually doing some research in the background, because the internet is capable to handle that. Okay. So yeah. And oh, sorry, toxic. As like, the thing is, I was expecting more spiciness, and definitely the attorney do something about it, and actually not just talk about one thing, ask one question, and then just give up and carry on. I thought that he was actually going to do something about it. And but now he's just decided to ask one question. Like, probably yes, there's no like point to ask anything else, because there is dangerous that he can go down again the road of saying what he shouldn't say. And yeah, probably was just being cautious, but uh, so yeah, so probably was just that. Let me see. Um okay, so well, I can keep you guys updated to what is happening, but I don't want to spoil too much because then it misses the fun. It spoils the fun, I think. What do you think? Do you guys want me to say things, or do you want me to be, well, talking about random stuff while I'm doing other information? Because there is still, okay, yeah. I don't know. Well, it depends. It depends if it is spicy, if it is not spicy, if it is just thing. And I need to move my screen. I think I put the screen a bit too far away. Um And now I cannot see what I'm looking at. I have to put the zoom percentage at like 150 to be able to watch. Now there was like there isn't well, I wouldn't call spicy. I would call the normal issues that are going on in court when they are just about to go to closings. So it's not per se spiciness, but just normal, I think, um th- situations that is happening. So um yeah, so I don't know, it's just this weird, and I don't like being, I hope when there is a verdict, right, um they don't do this thing of being half an hour on delay, because that is one thing that I'm not gonna do. If there is a verdict, I am gonna wait until the verdict is um read, and that is read to it, because I don't want to spoil it, I think. I don't know, it's just probably, yeah, I'm gonna wait until the verdict is read. But I am not gonna count that half an hour if the verdict is only read with the half an hour delay. I am not gonna count that half an hour into the verdict game, because it would not be fair. I don't think it would be fair to count that half an hour, because you're not playing with that in mind, and I don't want that to be part of the verdict game. So it's just pretty simple, the length that they have been deliberating. So yeah, so that's, it's not gonna come in into the verdict game, so it's gonna be the raw time. And but hang on, I need to think, because the thing is, if we are counting the time as soon as I get the notification that they have gone into deliberations, right? Um, yeah, okay. Sorry, I was just trying to figure it out in my mind how we would gonna go um to count. So as soon as I get the notification that the jury has gone to deliberate, I will start the clock of the deliberations, and then we go by what it is there. Do you guys think that's fair? So I know pickles. I was like, I think work. No, I'm joking. Work doesn't need to get out of the way. Is, I think it is. You need to have like earbuds inside of your ear so you can always listen. I'm joking. By the way, how are you feeling today? I did ask you earlier, but I think you must have left. But how are you today? Are you feeling any better, pickles? I certainly hope so. Um, so it's just okay, thank you. So that's what we're gonna do. As soon as I get a notification that says that the jury has been sent to deliberate, I will be starting the clock. So that's what's gonna happen with the with that, so we can keep honest and fair for all. Sorry, just a drink break. So I am just, oh, okay. No, it's fine. Fair enough. We'll keep you entertained in chat. Um, if you can't hear it, and yeah, not on busy days. Yeah, but sadly, this week has been a busy week, hasn't it? Apparently, so it's so I need, I'm trying to do some research at the same time that I'm talking. It's kind of not going very well, because I'm paying attention more to you guys than the research, which is good. I am not complaining, but this is not the case that I'm looking for. uh we might not have the case then, because if I can't find it, because I might have to go and listen to it. Hey, diamond painting, yeah. Yeah, fair enough. Yeah, that's absolutely fine. And we'll try to keep you informed in chat, or if there's something very spicy, I will DM you anyway. Um, Are you still doing the mushroom painting? Was it mushroom paint, diamond painting, Toxic? I find it relaxing, but I'm finding no time for it. Um, I need to find more information about this case because I can't find it. I can't find anything on the docket to where apparently his it is happening. Um, so I cannot find when actually started or where I can find a whole um. I think he started Wednesday, so today's Thursday. So you might have started yesterday. Okay, I need to do more research on this one. Um, so oh, okay. Oh, hot air balloons. Nice. I would love to go on a hot air balloon trip. I think I would be scared because I don't like heights, but that would have been fun. A hot air balloon trip. I'm not saying anything not but no, I'm joking. um Oh, awesome. You need to start sharing pictures of them, Toxic. Maybe you could do a channel on Discord about about diamond painting, about arts and crafts so that people could like share stuff there because the subjects that we cover are so hard and like people could share that stuff. Maybe it's an idea. I don't want to put you on the spot, please. I'm sorry. Um did not meant to put you on the spot there. Um Oh, that is awesome. Is that okay if I share it? Okay. I am um so yeah, so it's like I want to see the your guys' crafts and everything. I want to, yeah, arts and crafts, like a channel arts and crafts type thing. That could be really good. People could just post the stuff that they are doing and that they like and they you know interested. Even if like for example, definitely not true crime. Oh, okay. I can show it. I was just waiting on your confirmation to from you to absolutely share it. So I'm just getting it ready and I need the headphones. Where did I put my I put my headphones away so I can keep an eye out on the feed while we are waiting because they should be back. They should be starting any moment now. So oh, hang on. Share screen. There we go. And it should be on your screens right about now. That looks so awesome. Toxic. That absolutely looks amazing. That is cool. Oh, is it? That is cool. So I need to find a hobby section on the Discord. So I know it is. You are so talented, Toxic. That is awesome. Well done, darling. It's amazing. Sorry, I have so many tabs open right now. I need to find the correct one. There we go. Oh, I think we might be going live soon because they took their banners out. So, oh, hang on. I need to take mine. Trying to close this. So, yeah, so we should be going back in court anytime now. They should be starting the court. So, I know. I'm already I'm really ready for this, and I need to do some investigation on this case because it's it's now interesting me this case. But I cannot find any information whatsoever about it. So, which is gonna. Oh, I have sound. Here we go.
Good morning, ladies and gentlemen. Thank you. I see everybody right here safely. We're going to continue with the case. Cross-examination. Mr. Hughes. I will remind you that you're still on track.
I understand. And it states Exhibit 66 up there on the overhead. Mr. Hughes, when you dragged Christina Parcell across the floor of the front room where you killed her, did you drag her by her arm or by her ankle?
I don't remember for certain, but I think by the ankle.
That's all the questions I need to ask this, Your Honor.
Any limited redirect?
No redirect, Your Honor.
Mr. Hughes, you can say. Any other witness? Defense going to call any other witnesses?
Your Honor,
And I am aware that you wanted to put additional problems in.
yes, not at this time.
Okay. All right. Ladies and gentlemen, I'm going to ask you to go back to your jury room, and I'm going to be taking up a few matters, hopefully very quickly. And be back with you.
Well, that was it. I'm sorry, but why? So, court was in session for like 5 minutes. That was absolutely it. Now, defense has rested. We are back waiting for them to come back again. We waited a long time for that. That took 5 whole seconds. And now what's happening now that we did not get to see was the JOA, the judgmental of acquittal, that the defense is arguing for direct verdict on the harassment only. And well, we're not gonna see it anyway, so that was the night. So yeah, I think definitely we all need our favorite snackles for sure, because I would be throwing them away right now at the TV, computer, whatever device you are using. I would be throwing it because that was a big old waste of time. So so it's just like now we're on break, and are you? Oh my days. Guys, you're not gonna believe this. You are not going to believe this trial is gonna take the award for more breaks, postponings, and everything. So court is on a break until 1:30 Eastern. We are literally on break now already until 1:30 Eastern. This is absolutely crazy. So I know, it's oh my days. I don't even know what to say because there is nothing really that I can say. I think um this is crazy. Um yeah, big wah, wah, wah. Definitely a big one because that was a big of nothing. And now we're back and waiting. They will be back at 1:30 Eastern, which means 2 Eastern for us. And yeah, so what we're gonna do is I'm trying to find something for us to watch. So I think we're gonna do some card hopping. I know, absolutely. I absolutely agree. Um Lois, essentially, literally, the jury has come in this morning, right? In the snow day, they came in, they listened to not even 5 minutes of testimony, which was one question, and then now they're out until 1:30. That's a big waste of time. I'm sorry, but I find that absolutely crazy and disrespectful in regards of the time of the jury, and it's just wild. I mean, well, yeah, Paula, you missed it. You missed. Well, yeah, you missed nothing. Prosecution had one question, and that was it. That's literally it. The defense has arrested. Um, oh, I cannot believe this. This is absolutely a joke. Um, because one question why couldn't they ask the one question yesterday if that's all they had? Why wasting so much time for what? No, Paula, I am sorry. I wish I was joking. I wish I was like, haha, April Fools. Yeah, no, it's true. They had one question, one whole question. That's all they had. And now we are like here seated waiting until until 2 p.m. Eastern. I don't even have appropriate. Yeah, they are paid by the hour, but still, like, I would prefer probably be with my family. Um, you know, be with my family or work that probably I can earn more than I'm earning as a jury than wasting my time doing nothing. So as like this is our apps, I feel, and I, in my opinion, my humble opinion, guys, I feel that this is a big disrespect about the for the jury, because they're literally, it's like a yo-yo. They're in and out, in and out, in and out. I know In and Out, it's a burger place in America, and I want to try it, and I hope one day I will try it. But it's just crazy. It's just a big massive disrespect to the jury and to their time and to everybody else as well. uh, and they just like, I know that, like, for example, I don't know if you guys remember, but the judge in the Zachary Young CNN defamation case we followed absolutely would not take this. And yes, Paul, it did rest. They did rest the case. The GOA motion was denied. That's what's happening right now, and now they are broken until 2 p.m. Eastern, and that's what I just don't understand. It's how can it? Sorry, I'm really upset because it's just a big massive waste of time. In my opinion, not like probably not us, because we are here for do we want to follow it and everything, but for the jury, I'm trying to see this as a juror. uh, I think that is a big massive disrespect and a big massive waste of their time. So yeah, I think you're gonna be able to catch us up. I think we are just gonna do some court hopping until there is any movement or anything. Yeah, because again, I'm gonna put the oh my god, we are back somehow.
Welcome back. Just be patient and understand there are procedures that have to go in, and I'm sorry that I have to send y'all in and out, okay? All right, anything further?
Nothing further, the defense rests.
Defense rest. Okay, ladies and gentlemen, you can go back to the jury room.
Hey, you smiled. Oh, sorry, you heard that. See what I mean? See, do you guys see what I mean? So they literally went in, the defense rested, and they were out. That is I don't understand. Let's just court hop, before I get even more upset and mad, and let's watch our favorite judge, win our favorite judge.
All right, thanks. Oh, it happens. Trust me, I've been there. All right, is there any amendments on the indictment for the state? Ending in 7/3? Yes.
No objection, Your Honor.
All right, do you understand that's a substantive change to the indictment?
Nothing.
All right, do you have any objection to proceeding with the state amending the indictment?
No.
All right, then the request to, and I'm assuming counsel, you have no objection?
I have no objection,
All
Judge.
right, then the state's request will be granted, and thank you. All right, after reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are. We'll wait PSI, Judge.
Anything you wish to say on behalf of your client?
No, Judge, just the fact he does have new family support. He's married. His wife has been in court every day that he's been in court. I think she'll do a good job of keeping him in line. And he understands that probation is probably his last chance to avoid going to prison. Is that correct?
All right.
9 years clean and doing good for 9 years. So I've been doing my best, but I did fall off the wagon one time, and I promise that it'll never happen again.
Okay. Eight. Do you have any children?
I got one boy,
Age?
5.
Does he live with you?
Yeah.
When's the last time you had employment?
I have employment still. I have my own, I own my own Brothers Home Improvement. So we do anything from home improvements to like lawn to repairs to stuff like that. And I have 4 brothers, and we all work together.
All right, the court is going to find you guilty, sentence you to 2 years in the state jail facility, suspended and probated for 4 years. There's a $2,000 fine that will be probated. Restitution, if any, to the Dollar General. And that's the store located at 114 Goliad Road. And there's to be no contact with any Dollar General. Regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days. There's to be no employment as a home health care provider or in the medical field or with minors. Field visits 1 time per month for 6 months. 200 hours of community service restitution. I'm going to order the theft course, CATS 1 and 2. Once he completes that, 100 hours of community service will be deemed satisfied. I'm going to order parenting classes. Once he completes that, the remaining 100 hours will be deemed satisfied. There's to be a TAP evaluation out of custody. Follow TAP recommendations. Probation Is there anything else? 2 years suspended and probated for 4. All right, is there anything else you need from the court to be successful?
No,
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
it is.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal.
Okay.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. In this court, to be successful on probation, communication is key. If you have an issue, let probation know. If you feel they're not addressing it, you're going to always come back to the court. Do you understand?
Thank you so much.
All right, good luck to you.
Thank you so much.
Good luck.
Over here. Yeah. Tell them I haven't had a chance to go to the, but I'll take care of it today.
Okay.
Oh, you know what? Yeah, just ask them to leave their number with you.
I have it.
All right, thank you. And tell them I will call them.
Okay.
Thank you. Yes.
Judge, Mr. Mendez Trevino is here. He has an accompanying case in County Court 4. That's the only court he's been to. It's his first time in the 27th, so they went to the wrong court, but they checked in this morning before 9, showing, telling them.
All right, if you ask the clerk to pull the file. It's up there, Judge.
Aaron Mendez Trevino.
Aaron Joseph Mendez Trevino. Hello.
Hi, how you doing?
I'm doing okay. So you need to make sure that you come to district courts first, okay?
Yes, ma'am.
All right, so where are we on discovery?
We went over that today, Judge. It's our first setting. I'm double checking. We have everything. We're also in discussions about a possible ETD. And so all of that's going to be exchanged before the next thing.
All right, Ms. Ferguson, I need a 30-day reset.
Yes, ma'am. It'll be on March 24th.
That works.
All right, just sign the reset form. Once you sign the reset form, you're excused. Thank you for addressing appropriate report. You're welcome.
Judge, may I approach the bench?
I call the cases in order.
Okay.
Yes. What page is Trevino on?
He's on page 5.
Thank you. Jorge Guevara.
I have not been able to locate him. He's not present this morning.
All
He's not
right,
out there either. Judge.
thank you. All right, court is calling 2024 CR 012217 State versus Jorge Alberto Cuellar Guevara. Could I have parties announced for the record for the state?
Yes.
Defense?
Orlando Castellano.
All right, this hearing was scheduled at 9 a.m. It is now 10:58 a.m. The defendant never answered docket call. Deputy Laura, did you make an announcement for the defendant?
Yes, Your Honor, he is not out.
All right, defense, have you had any contact with your client?
I have not, Judge.
All right, state.
State requested a bond forfeiture, Your Honor, or judgment.
All right, the court will grant the state's motion for a bond forfeiture. Your client will be remanded without bond. If your client makes an appearance, the court will reconsider.
Thank you, Judge.
Thank you.
And Judge, he's on a PR bond.
Oh, he's on a PR bond?
Yes, ma'am.
A PR bond for this offense? Okay.
Yes.
We're back on the record. The court will issue a judge's warrant and remain without bond. Charles Claycomb. Court is calling 2024 CR 009592, State of Texas versus Charles Claycomb. Could I have parties announced for the record?
Dwight Chumley for the defense.
And are you Mr. Claycomb?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Are there any applications in this case?
No.
Mr. Claycomb, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
I do, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, sorry.
Oh, that's a problem. State, are you proceeding on the indictment as presented?
Yes.
All right. Mr. Claycomb, did you review the document entitled Court Admonishments with your attorney? Did you understand it?
Yes.
All right, you're charged with theft of property, $2,500, less than $2,500 with 2 or more previous convictions of a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
I do, Your Honor.
Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case?
I will, Your Honor.
Did you understand that?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does, yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Mr. Claycomb, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 15 months in the state jail facility. State will take in consideration 2025 PF 02867. Did you understand that to be the plea?
Part of it, yes, ma'am.
Well, when you say part of it, what do you mean?
I meant that extra part, yes, ma'am, that they was gonna be put on there also.
Yes.
Yeah.
So did you understand that to be the entirety of your plea bargain agreement? Counsel, is that the plea?
Yes.
State, is that the plea?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, there being such motions.
No, ma'am.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence?
No objections, Judge.
State you may be excused. Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, I did.
No.
Oh, yes. Yes, he did. Yes, I did. I'm sorry.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. And I'm sorry, what was your plea, counsel?
Guilty.
Guilty?
Your Honor, I would, on behalf of my client, he asked me to share this with you tonight. He is very remorseful. He suffers from addiction. He has HIV because of his drug use. He is 62. And he just wants you to know doesn't want to be a thief. He just found himself in a very bad cycle.
All right, so Mr. Claycomb, you're gonna have to make sure you change things. Otherwise, you're gonna find yourself spending a lot of time in the prison or a lot of time in someone's jail. There are plenty of places that can help you if you want the help, but if you don't reach out, nobody will know your problems, right? Okay? All right, so the court will find you guilty, sentence you to 15 months in the state jail facility, give you credit for any time served. I'm going to take in consideration 2025 PF 02867, and I'll recommend the therapeutic community for you to help with any issues that may need to be addressed. I do not have the jurisdiction or authority to force them to place you in the program, but what I can say is it's going to be in the judgment, and you'll need to request it as well. You understand?
I think so. Yes.
All right. And when you are released from the state jail facility, if you cannot find a place for treatment with your medical issues or with your drug addictions, if I'm still here, you can come back here and I will pick up the phone and get you the help you need. You understand? All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you, Mr. Claycomb.
Thank you, Your Honor.
You're welcome.
And Judge, how many years do you-
Mhm.
how many years do you-
15
15
months.
15 months.
Vanessa Portelis.
I think about you every time I see one of those commercials for Verbo.
Oh, yeah.
You know the ones I'm talking about?
Yes.
It's a good commercial.
Oh, it is. Let me see. All right, so where are we on discovery?
Judge, this is our first appearance
Mhm.
post indictment. Ms. Portalis wants an opportunity to come to my office and review the discovery so that we can fashion a way forward in her case.
All right, state on Portelis, you'll need to be prepared to tender an offer at the next setting. All right, and Ms. Ferguson, I need a 30-day reset.
I can do that one on March 23rd.
March when?
The 23rd?
All right, so it'll be March 23rd. Once you sign the reset form, you're excused. Thank you.
Thank you, Judge. May I be excused once we do
Yes.
the reset form?
Yes.
Thank you, Judge.
Sorry, Judge, I meant March 24th. But the 23rd is a Sunday.
Well, I mean, they can be here on a Sunday.
I'm on pass.
Ma'am, you can have a seat. He'll take it to you in just a few moments. He's just a few minutes.
That's a Monday.
Dylan Jacob Skinner.
Thank you so much.
Thank you.
Morning.
Good morning.
Good morning. Yes.
So we have an agreement, we have signed the paperwork, it says, when that, sign an application.
Mhm.
The complainant, who's Dylan's mother, wants to make a victim impact statement at the time.
All right, so I'll take the plea and then we can reset it for that.
That's fine. Judge.
Okay, we could do it that way. Yeah, we have the
Sure.
paperwork, please.
Okay,
Thank you.
all right, thank you. They have paperwork on that case.
Yes.
Nilda Cabello?
Honor,
Yes.
I represent her. I got her appointed about 3 weeks ago, no contact. She's not here today and she has an active warrant.
All right, let me see if the active warrant is on this case.
I believe so, post indictment.
All right, let me see.
A lot of verified, she had a warrant. Yes, Judge.
On this one?
On this case, sir.
And she's not here, Judge. Nor in the hallway anyway. Let me just verify that.
Yes, because I don't see it on the system that I'm looking at. Just one second.
Thank you. Yes, yes, I see you. Yes, it's an active.
All right, is that what's showing on your system?
Yes, ma'am.
All right, you are excused.
Thank you, Honor.
Okay. Which do you see like that little lock? It's a little lock on the left hand side.
I looked for it. I'll double check. I'm going in now.
I can get that from you. So sure.
And which side is the lock supposedly on?
On the left hand top where it says jail, there's like a little flag. It's a golden lock.
Oh, my lock is not golden.
Just hover over it and it should show you. It's on the summary tab.
Oh, that's where I am.
Oh, yeah.
All right, we'll see whenever she gets picked up. Thank you. And what page is she on?
She's on page 6 at the top.
All right, thank you.
Yeah. Yes.
Can I just come back?
Can you come back on at 1:30, Judge?
For who?
Kyle Stone?
Are they not ready on him or?
I'm
running around, Your Honor.
Sure.
All right,
No
thank you, Judge. I'll be
problem.
back
Yes.
this afternoon.
All right, thank you. And Norma, on that last case, do a remand without bond. Alexandria Alvarez. Hi. All right, so we're supposed to be here today for contested?
Yes. But
All right, so I have a motion to withdraw. Why? Why is there a request that the motion be withdrawn?
Violation allegations, and Ms. Alvarez will agree to the amended conditions.
She has completed the parenting class that was a subject of one of the violations.
All right, so what is going to happen with this case? I don't like for cases to end up somewhere else. So the new number 1 allegation that was in the motion to revoke, what's happening with that case?
Happening with your pending cases in Guadalupe County. When's your next court date on those? Next court date is March 6th.
All right. So you all are leaving that case out there to be handled by someone else?
I am not retained on that case. She does have a court-appointed attorney on the Guadalupe County charges.
All right, and what conditions are being, what is she being alternate amended to?
So my understanding is that she is to take a theft level 2 course along with the moral recognition therapy.
All right, thank you. Yes?
Those are just the recommendations from the probation officer judge.
All right, so why are we recommending that?
So give me just a moment.
Is it based upon the new number 1?
Yes, sir.
Okay, all right, then the court will sign the motion to withdraw. Is there anything else?
Nothing further.
All right, do you have any questions about anything? You seem a little bit confused.
No, I'm sorry, no.
No problem.
I mean, I'm very thankful that's happening. So, Judge, do you want the amended conditions?
Well, the alternate amendment, the moral recognition therapy, she can do one or the other. Either you can do the theft course or you can do the MRT.
So that option remains open to her. It's not set.
Oh, right now. It's going to be set right now.
Oh,
So
okay. So which one would you rather take?
the MRT is to help you with your thought process, basically something that we all should have learned to choose right as opposed to wrong. For example, if you see money on a counter and you know it's not yours, yeah, you should pick it up and try to find the rightful owner or turn it in to the right person. MRT will help you determine that. As opposed to picking it up, keeping it, putting it in your pocket and hoping nobody will ever know that you took it.
Let's do that.
All right, so Ms. Abrams, just alter amend conditions to include MRT for the burglary. That's, I guess, in misdemeanor court. They'll probably address the theft course with that.
Judge, on both of her cases here, we want the MRT.
Yes.
Thank you.
And who's this?
Excuse me. Thank you.
Thank you. All right. Thank you.
All right.
You just need to remain here for conditions.
Okay.
All right. Thank you.
Thank you.
Here on Benito Vasquez.
This is not the case. It's not over.
Benito Vasquez.
Moving to another court real quick, but that defendant took off.
Okay, well, we'll take it up when he comes back. Daniel Montoya.
That's already engaged.
He's coming. He had to he was charging his leg monitor. So
So why was he late for court?
I don't know if he was late to court.
The lifetime, they decided
Oh.
to run it, I'm at the lifetime short to
Okay.
the program, or they decided to come whenever they wanted to.
Okay.
So I didn't know he was even late, so I
Oh, no,
wasn't
he was
here.
late.
Yeah, he gets a ride from Lifetime. Nobody can go pick him up. Just part of the program that he's in.
All right, today's plea deadline date.
Yes, Your Honor, today we did receive another offer and we countered on that offer. And we would just like additional time, Your Honor, because it may involve him going to prison, and he's in this really good program, which he finishes March 17th. 17th, correct?
Yes, ma'am.
Okay.
All right, Norma,
Yes, ma'am.
recall this for February 24th. That's the final plea deadline date. It will not be extended any further. All right, thank you. Once you sign the reset form, you're excused.
Hey, Carl.
Good morning. I'm ready on issue for Ruger. I want to read all our. Thank you.
Yes. Better help when the ones I'm finished with, I will just put them down.
Oh, no, she's putting them in a box.
Oh,
You can track with them.
Is on we can just go on. So I need to make sure that that trip so she's going to the jail right now. The bites are all
Jaya in the back. Jaya or Jaya? Jaya.
Yeah, I'm sorry.
The other clerk.
All right, thank you.
All right, who's the officer on this? So, what is your name? All right, it's all true and correct in the universal knowledge. So when you sign, you need to also print your name. Yeah.
Oh, yeah. Oh, I'll Yes, sir. Are you ready on that? I'll leave it right there. She'll get with you in just a few minutes.
Yes.
Thank you. Bye, Arlene.
Just make sure everything is signed before you leave. Thank you. Ulysses Benitez. Court is calling 2024 CR 010834 State versus Ulysses Gloria Benitez. Could I have parties announced for the record for the state?
Your Honor.
Defense?
Carlos Martinez for the defendant, Your Honor.
And are you Mr. Benitez?
Yes, ma'am.
Counsel, you received all discovery. Did you review it with your client?
Yes, I did, Your Honor.
A court will find that the state is in compliance with discovery. Probation, this is an application. Mr. Benitez, did you review the document entitled Application for Deferred Adjudication? Anything else? All right, thank you. With
Yes.
your attorney, did you understand it and sign it?
Yes, ma'am.
All right, off the record for a moment. So I know this is the trial court certification of defendant's rights to appeal. It'll need to be in English.
I have it. It's supposed to be there.
Okay.
I usually do both from on the subcon.
Ah, all right, thank you. All right. Mr. Benitez, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
I do, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented? Mr. Benitez, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand your charge by indictment with possession, manufacture and delivery of controlled substance, penalty group 1, 4,200 grams, that's a first degree felony. Range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand that the court would grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to life in prison and up to a $10,000 fine.
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, he has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, he does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
In my opinion, he was, Your Honor, and he is.
Mr. Benitez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
No, ma'am.
All right, counsel, did you have a chance to speak to an immigration attorney or have your client speak to an immigration attorney?
Yes, Your Honor, we've done both. I did, and then they did appoint Tulos. And he spoke to him last week, and he did provide a letter. And then he fully understands. Under Padilla, Judge, I'm obligated to tell him about his immigration warnings and possible consequences before he enters the plea, which I have, Judge.
All right. Mr. Benitez, do you understand the impact a plea in this case will have on your immigration status?
Yes, ma'am.
Do you understand by entering into a plea on this case, you will be deported?
Yes, ma'am.
And do you understand that you will be denied naturalization?
Yes, ma'am.
And do you understand that you will be denied re-entry into the States?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 10 years in the prison. There's a $2,000 fine. State is silent on your application for deferred adjudication. State recommends community supervision. They're taking in consideration 2024 PF 24733. And there's to be restitution to SAPD for drug testing. Did you understand that to be the plea? Defense is at the plea?
Yes.
State is at the plea? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
None.
Outside the agreement, the state is requesting that your community supervision be for a term of 10 years. There'll be a TAP evaluation and 250 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Ma'am.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Defense has no objections, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Do you wish to proceed with sentencing?
I would prefer, Your Honor.
All right. Is there anything you wish to say but in regards to the application for deferred?
Your Honor, I have spoken to the mom and the brother. He comes from a good family. He's just, and after talking to my client, Judge, he's worked all his life. So he says, it was lapse in judgment, some easy money, but they'll never happen again. I've learned my lesson. He says all the right things, and his mom is devastated over this because he's got several brothers, Judge, that are hard workers also and have never gotten it.
All right, this is what the court is going to do. The court will deny your application for deferred adjudication. The court will find you guilty, sentence you to 10 years in the prison, suspended and probated for 10 years, taking consideration 2024 PF 24733. There's to be restitution to SAPD for drug testing. There's to be no re-entry into the United States. There's to be regular reporting by Zoom or in person, regular random UAs. There's a $2,000 fine that will be probated. Do you understand you're not allowed to come back to the United States?
Yes, ma'am.
If you come back to the United States, that will be a violation of your probation and you're facing 10 years in the prison if you do that. Do you understand?
Yes, ma'am.
Probation, he's not allowed re-entry back in the United States. Are any other conditions needed? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
You're welcome. Thank you.
Those were the best cough drops that I've been.
Oh, if you need any more, we have some.
It's I was doing this and those are a lot.
Ah,
Thank you, Judge.
you're welcome.
You have a good one.
All right, you too. State on Benitez, do you have the case to be taken in consideration? All right, thank you. Yes.
Yeah,
Mhm.
I'm back.
Sorry, Judge, when's he sentenced?
Yes.
Oh.
Yeah. Yes.
Got him back on Benito Vasquez, Your Honor. You had called his case. I turned around, he wasn't in the courtroom. I went out in the hallway to check on him. He's gone. And so this is not a compliance hearing now.
All right. Let me.
I talked to him earlier in the morning. He was gonna make a call to his wife and come back to the courtroom, and I haven't seen him since. Your Honor.
All right. Well, I will make a ruling. Just one moment. All right. So on this one, I'm going to issue a judge's warrant. And your client will be remanded without bond.
Benito Vasquez, Benito Vasquez.
All right. Thank you.
Excuse me.
Yes. Benito Vasquez?
So you just called that one, Judge called it.
Oh, no, that was a different Benito's Vasquez. That was Ulysses.
No, Mr. Collins, you told him he can leave it on.
Oh, that is this one. Ah, okay, thank you.
I think the other one's beneath this. I put it there.
Okay, that's that one. All right, and let me see what page he is on. He's taking up a lot of the docket.
On page 7.
All right, thank you.
And page 8.
Didn't I complete Alexandria Alvarez?
They wanted to reapproach on that, Judge.
Yes, Alexandria Alvarez.
And Judge, according to Yaya, they're asking for the GPS to be removed today, but there's no paperwork stating that.
Okay. All right, so once the motion is filed, I'll take it up. So
Okay.
whenever you all file that motion, I'll hear it.
Well,
Oh,
it's
the
part of
GPS.
the bond. And that's my understanding is that with the altered and amended conditions that cancels it out, doesn't it? And then she's free to have it
Not
removed.
necessarily. I'll need to see the paperwork on that. I don't have any paperwork with regards to that being a condition of bond. If you have them pull it
That
out,
was
review.
something that you had imposed when she had come to turn herself in on the 6th. And
Yeah,
then we had,
no, if you all will have the clerk
okay,
pull the order, I'll review it.
all right.
Okay.
The order from the last time that she
Yes.
was modified to tracking only.
Yes.
Okay.
All right, Dylan Skinner.
Okay, which would be up here, ask the clerk in the back.
Dylan Skinner? Who's the attorney for Dylan Skinner? All right, court is calling 2024 CR 011052, State versus Dylan Skinner. Can I have parties announced for the record for the state? Defense?
Brian Kimbrough for Mr. Skinner.
And are you Dylan Skinner? Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Are there any applications?
No.
All right, Mr. Skinner, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
I did.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Skinner, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with aggravated assault with a deadly weapon? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to enter into a plea and give up those rights in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I did.
Mr. Skinner, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
No.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishment is to be assessed at 4 years in the prison. There's a $1,500 fine, affirmative finding of deadly weapon. There are no applications. The state is taking in consideration 2024 CC 739463. There's an affirmative finding of family violence, and there's to be no contact with Dusty Skinner. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition? Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent? Did you understand that to be your plea? Defense, is that the plea?
That is.
State, is that the plea? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? You're gonna need to speak up. Counselor, have there been any such motion?
No.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
No
Any
objection.
objections? Did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Can you repeat that?
I'm so sorry. Did you understand you have a right to jury trial?
I do.
All right, so that would mean that 12 people would sit in the box and they make a determination on whether you're guilty or not guilty if they could come to a decision. Do you understand that? Do you understand that if you were in a jury trial, the state could not force you to testify? That's your right. You don't have to testify. Did you understand that? Did you understand that the state would call witnesses? And those witnesses, if your attorney chose to or you chose to, could be questioned by you or your attorney. Do you understand that? All right. By entering this plea bargain agreement, you're giving up those rights. Did you understand that? So today, with regards to these stipulations, the state is not bringing any witnesses in. They're asking the court to just review the police reports and witnesses' statements and make a decision on whether or not there's sufficient evidence to find you guilty. Do you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right. And whenever you need me to slow down, just let me know, okay?
It was just that one that you said.
All right. But if you ever need me to slow down, just say it. Let me just tell you, a court reporter would appreciate it if somebody says, slow down, judge.
Right.
All right. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. And off the record, counsel, I know that you and the state had come to an agreement that the complainant wished to give a victim impact. All right, is she able to zoom in? All right.
And if the court would give us just a moment, we could see if that would be possible.
Are you okay with them
We could
checking?
do it this morning, yes.
Yes, all right. If you can see if she can zoom in. All right, thank you. Jason Moore? Court is calling 2025 CR 0000924 State versus Jason Moore. Could I have parties announced for the record for the state? Defense?
Deborah,
And are you Mr. Moore?
Yes, ma'am.
Probation, this is an application. Did you review? Counsel, I'm sorry, counsel, have you received all discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Moore, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it and sign it? Did you review the true bill of indictment with your attorney?
Yes.
Did you understand it? Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, sir.
Mr. Moore, did you review the court admonishments and defendant's waivers and affidavit of admonitions with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with assault on a peace officer as a second-degree felony? Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state should call, and the right to remain silent. Do you understand?
Yes.
By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine. Did you understand? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Moore, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, sir.
According to the plea, there's a $1,000 fine and the state recommends deferred adjudication. Did you understand that to be the plea? Defense, is that the plea?
Yes, Your Honor.
State, is that the plea? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Have there been any such motion?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 3 years. There be a TAP evaluation, community service hours, mental health assessment, no harmful or injurious contact with Barbara Dunkel. Did you understand those were recommendations from the state and the court does not have to follow those recommendations? Then to the offenses charged, how do you plead?
No comment.
State any evidence?
No objection.
All right, state you may be excused. Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Please, Your Honor, yes.
Anything you wish to say on behalf of your client?
We hope you follow the plea agreement, Your Honor. And he's been on med since he's been in jail, since November 1st.
All right, and who is Barbara
His
Dunkel?
mama.
No, I'm asking him.
I'm sorry.
All right, so why is there why is there a no harmful or injurious contact? Was there any type of case involving her?
Because I mean, I don't know what the living arrangements are, but the evidence I was stipulated to, I think, supports that, even though that case was just closed out.
All right, what are your living arrangements?
I currently live with my mom, taking care of her physically, and she's got a bad angle, bad head, so I kind of watch over her. If she's okay, take care of the house.
All right, isn't there a home health care provider to do that?
She didn't have me. She's actually trying to get surgery and everything.
All right, because I don't allow people to be home health care providers. So if you're trying to segue into being her home health care provider, it's not allowed in this court.
He's gonna get a job.
All right, so I'm asking.
I'm sorry.
So when's the last time you had employment?
Right before this.
Doing what?
Aircraft mechanic for civil service, United States Air Force.
So what happened on this day? Why did this all occur?
Can I answer?
I want to know from him. He's the one, you can answer if you're going to be on probation with him. So, all right, so what's going on that day?
I was just currently I had no sleep for a little while. I was on Ambien. It's a medication.
I know, I understand Ambien.
With my condition, I was.
So have you ever had any mental health diagnosis before?
I have. Yes.
All right, for what?
I worked.
All right. And do they have you on medication at the jail?
Yes.
And what is that?
Axel.
Mhm.
And a shot of, they call it Abilify.
All right. And do you have any type of case manager or somebody to help you continue with your medications if you're released from custody?
I was on medication before I came with the VA. I get the Veterans Affairs.
Okay. All right. And did anybody check to see if Veterans Treatment Court would accept him in their program?
No.
All right. Do you want to consider being under the umbrella of Veterans Treatment Court?
Many things.
And Norman, no more cases.
I'm satisfied right now with just the program. Yeah.
Do you know anything about the Veterans Treatment Court?
I do not.
All right. This is what the court is going to do. There's $1,000 fine that'll be probated. The court is going to sentence you to 4 years deferred adjudication.
Four, not three.
Oh, that's outside the agreement.
I know, but I'm just making sure you knew she recommended three.
Yes.
Okay.
All right. Ms. Abrams, can you see if somebody from Veterans Treatment Court can come up and speak to him? All right. So 4 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days of release, no employment as a home health care provider or with minors, field visits 1 time per month for 6 months, a referral to Center for Healthcare Services or the VA. There's been no harmful or injurious contact with Barbara Duckle. There is to be 60 sober meetings in 60 days.
With who?
They'll tell him.
Okay.
150 hours of community service restitution. Do you have any children?
Yes.
What are their ages?
17 and 20.
All right. And are there any minors living in the house with you and your mother?
No.
All right. So there'll be 150 hours community service restitution. I'm going to order anger management. Once he completes anger management, 100 hours will be deemed satisfied. Probation, is there anything else? Is there anything else you need from the court to be successful? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? Did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, we can go off the record. Somebody from Veterans Treatment Court will come up here and speak with you. Maybe you will decide after talking to them, you want to be considered for the Veterans Treatment Court. If you do, I'll grant your defense counsel motion for new trial if that's what you decide. Otherwise, they're going to come up here and they'll speak to you so they can make sure that you're connected with the VA. You understand?
Yes.
All right, good luck to you.
Thank you.
You're welcome.
Have a seat, sir.
All right, Dylan Skinner. Yes.
Yes, Your Honor. It seems that she is not, she has to write her statement, et cetera, et cetera. Also, if we could just reset the sentencing portion, he wants to make an apology to his mother. And he
All right,
do
we
that.
can recall it for the, Norman, can we recall this for the 24th or 25th? All right, we'll recall you for Monday.
Thank you, Your Honor.
Thank you. Yes. Okay.
Would you want to just do a program or?
Yes. Yes. Timothy Gonzalez.
Okay. Thank you.
We're gonna do
Thank you.
Hello.
it.
All right, so they're dismissing your case. They say that is for insufficient evidence.
Thank you.
All right, thank you. Have a good day. Thank you for always dressing appropriately for court.
Timothy Gonzalez, correct?
Yes. Red wine, Angela Redwine. See, what did I say? People always think the inmates are, a great dating pool. I guess it's a great dating pool for them to be faithful to you, but.
What are you
I
talking
don't know.
about?
Well,
What is
no,
she talking-
somebody was still trying to talk to inmates. I don't know why. Yes.
Yes.
Can we have the case recalled for Monday?
Sure.
Okay.
All right, and could you let your client know not to be talking to people in the audience?
Okay.
All right.
Thank you, Judge. We'll be back on Monday.
All right.
Thank you. Appreciate it.
See, John, you were wondering, who was I talking about? It's your client. You're welcome. Matthew Boggs? Bags? All right, who's the attorney for Matthew Bags? All right, just have a seat. Your client's not here. I'm sorry, your attorney's not here.
Right there.
Bags.
Mr. Stenberg.
Mr. Shinberg, come up, they're calling your client.
Thank you.
Yeah, I've had the trouble all day with him.
Hello, are you all ready to proceed on this case? Are you ready to proceed on this case?
Oh, yeah. Yes.
All right, can I have a file stamp? For a motion to revoke? Court is calling 2024 CR 2163, State versus Matthew Bags. That party is announced for the record for the state.
Virginia for the state of Texas.
Defense.
Joe Stenberg?
And are you Mr. Bags?
Yes, ma'am.
Did you review the documents entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Are you the same Matthew Charles Bags who was placed on deferred adjudication in 2024 CR 2163 for the offense of repeated violation of court order or bond condition on June 11, 2024 for a term of 4 years? Is that you?
Yes, ma'am.
All right, state.
Yes, sir. So proceeding on state's first amended motion to enter adjudication of guilt. Violation condition number 1. On or about the 20th day of January 2025 in Bear County, Texas, the defendant Matthew Charles Bags committed the offense of violation of bond protective order, violation of condition number 1.
How do you plead to that? True or not true?
True.
Seeking waiver of other violation.
Any objection?
No,
Any
Your Honor.
objections to the waivers?
No.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 1? Court will find violation of condition number 1 true. Is there a proposed agreement?
There is, Your Honor, it is for 3 to do.
All right. So with regards to the condition, violation of condition number 1, who is the complainant in that? Is it the,
Same victim as in the current case.
all right. Anything you wish to say on behalf of your client?
He realized the error of his ways. And he accepts 3 years to do.
All right, here you go.
Thank you.
Is there anything you wish to say to the court?
I'm sorry.
All right. Court is finding violation of condition number 1 true. Court will find you guilty. Court is going to sentence you to 6 years in the prison. Give you credit for any time served. There's to be no contact with Rosalind Marie Fernandez. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing. When I say no contact, I mean no contact. You're an adult. You should understand you're not to have contact. You understand? All right, good luck to you.
I have no idea. She has to follow and she's going through whatever she does. Okay, I have no idea.
It's just like, okay, I think that's a way to figure it out.
We'll just wait. I mean,
What page is Boggs on? Our bags?
it's on page 11 at the bottom.
Thank you. Who is here on Renee Esparza?
Occupational license.
All right, so we're gonna have to have a hearing on this. Are you able to come back or be by Zoom this afternoon?
I think I have a plea at 1:30 and come out, but what time do you think?
Oh, just zoom in when you can zoom in. We'll be here.
Okay.
All right, and then if you want your client to be by Zoom, he can be by Zoom as well.
That'd be great.
All right,
Okay.
and Ms. Ferguson will give you the Zoom link.
All right, thank you.
Just take a photo of it. It's right there. The 824.
Kendall Smith?
President, Your Honor.
Think so.
Court is calling 2024 CR 012136, State of Texas versus Kendall Smith. Could I have parties announced for the record for the state?
Jason Deere here,
For the defense?
Renee Munoz for defense.
And are you Mr. Smith?
Yes, ma'am.
All right, counsel, have you received all discovery? Did
Yes.
you review it with your client?
Yes, Your Honor, that's correct.
Court will find that the state is in compliance with discovery. Are there any applications in this case?
No, Your Honor.
All right, Mr. Smith, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
You are.
Mr. Smith, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with the offense of possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
That is correct, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
In my opinion, he is competent and ready to proceed, Your Honor.
Mr. Smith, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 134 days in the Bexar County Jail under 1244. There's a $500 fine. And there are no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
That is correct, Your Honor.
State, is that the plea?
Judge, I wanted to know, for 74 days.
No, it's
That's 134.
134.
All right, thank you. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence.
No objection.
Right. Did you review the document entitled waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state would be presenting evidence in the form of witness statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
If we may, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, we're requesting that the court follow the negotiated plea agreements. My client is homeless. However, at this point, he is working a program through jail outreach at Haven for Hope. He's doing quite well there. He's addressing a lot of the issues that have caused him to be in front of the court today. So we're requesting respectfully that the court follow the negotiated plea agreement, Judge.
All right. And does he have any priors?
Prior offense to yes.
Okay. All right. And are these prior felony convictions?
No, misdemeanors.
Misdemeanors for what? All right. Let's go off the record for a moment.
The judge has come back with no audio, or did I? No, yeah. So she has to come back without audio. I think we can lip read or something. Um, just imagine what she's saying. I am back. I've been here. I just had food, but now that she is not saying anything or the audio is not back, I'm gonna give her a couple minutes and see what's happening. So right now we are waiting on the court to get back. They are supposed to get back in about 45 minutes from lunch, and well, they in real time they can come back in 45 minutes, but for us it's gonna be have to no 45 minutes, sorry, forget what I said. They are gonna come back in 15 minutes in real life, but in 45 minutes for us. So, yeah, don't forget that if you want to play the verdict game, to play it, there's still time. You can either type it your guess in chat and we'll try to catch it. If not, there is a form that's going to be on chat for you to fill it out and yeah, so we can get your verdict guess, so you can win the channel new stickers because the cat is out of the bag and the judges went away. Let's see if the audio is not back yet. So I'm just gonna fill it out. So while yeah, while she is not, otherwise we're gonna jump on to another one. whoever is on live. We might even jump on just to fill space to the Sementelli case. Even though we haven't been following, you guys did see a little bit with Zio yesterday, just to keep it going, and something happened. It's not like we watched. The thing is, I went a little bit of a break on paroles because I want to use most paroles just for deliberations, I guess. I don't know. It's just something to watch while we are, because I mean, I can talk, but it's not gonna be. You guys probably don't want to hear me talk that much anyway. But I was like, I've been trying to scour the internet for what is next, the next cases and everything. There's not much going on at the moment because the trial that I said that I wanted to keep an eye on, it seems a really good trial, but it doesn't, for some reason, it doesn't has any openings. It doesn't has anything else, so it's just a little bit weird how that they are live streaming that trial. It's just a small trial, so but I would want to watch that one. But if it doesn't has the whole thing, I don't want to go through watching a trial and then yeah. And then the thing is, I found the court docket and everything and the hearings and the scheduling, and they are on they were on yesterday and today. They won't be on tomorrow, and then they are going to break until the 10th of March. That's the next time they are going to come back. And I don't want to be in a big massive gap that we are not following any trial, and then we have to pause probably a trial that we'll be following at that time to carry on back to this one. It's just big of a jump around, and it's too much jump around for me that I like. So yeah. Uh, so we just right now. I was like, I don't know. Is the audio her audio coming back? The audio is not there, or is it me? Let me have a look if it is me. Like, who else of judges is live? Oh, Cedric Simpson is live. Let me see. Okay, it is not me. That her audio is not working, so I think we're just gonna jump to Cedric Simpson for now.
1:30, Judge Slay. Bond will continue. Thank you. On that case. Then on the other case, she's gonna plead. I don't think she sought advice or rights, but that's okay.
I'm sorry, Your Honor. Would the court consider allowing her to be screened for Brett's court and potentially letting that
First, and then adjourn this out. Got it. Okay, I thought.
That's what I intended as well. I didn't discuss, it would be a no contest plea, but I didn't send it to the court. So if we could have a pretrial date on that matter. And for the record, I did ask Ms. Naveen to sign with permission on the referral.
Got it.
And
Okay.
she did.
So, doing well. I have the.
It's gonna go on Monday.
It's a DV, 17th. Well, March 17th, you think be enough?
I think so.
Pretrial in this matter, March 17th, 2025, 1 p.m. All right, great.
Thank you.
Thank you.
Thank you, Your Honor.
We'll continue. Ms. Levine, you're still doing well, right?
Yes, sir, absolutely. Thank you.
All right, take care.
All righty, bye-bye.
Court calls the cases of People versus Nicole and Nelson.
Your Honor, Alexis Plumai appearing with and on behalf of Mr. Nelson. Mr. Nelson, could you just say your full name?
Nicole and Nelson.
And Your Honor, we are just requesting an adjournment. It's my understanding the people would need to discuss a potential offer with officers prior to being able to extend that. And Mr. Nelson, just so you know, I did get your updated contact information from your transitional housing manager. So I'll give you a call later today after court.
Okay, thank you.
Yep.
March 6, 2025, 9 a.m. or as your invite indicates, bond continued. Thank you.
All right, thank you.
Court calls case People versus Justin Nicholson.
Before you burn here, Chief Assistant Prosecutor appearing on behalf of the people.
Ryan Bowling on behalf of Mr. Nixon. State your name for the record.
Justin Nicholson.
Your Honor, we're asking for an adjournment so that I can present this Burton Harris with some mitigating information related to my client, and hopefully we can work out the agreement.
You seen this violation?
I did see it, Your Honor.
I took my test today.
Your Honor, he did go to community corrections today and did test. He enrolled in testing there. He indicates to me that when he posted bond and was released from the jail, he's not given a copy of the order. He wasn't aware of the testing requirement until I received the report and called him yesterday.
When did you test? I just tested
Today.
Hey. Are you checking?
I do have documentation from community corrections if the court wants to see it. I don't have a result, but I have documentation that he did go there today and enroll.
How much time did you need?
2 weeks should be sufficient, Your Honor.
Probable cause March 6, 2025, 9 p.m.
Thank you, Judge.
Thank you.
See ya. Here, I'll give you a note.
Do they have them? No, I'm good.
Thank you.
Bond continue. Court calls case People versus Matthew Olette. Maybe.
Allison Mueller, Assistant Public Defender, here on behalf of Matthew Olette. Is it Olette? Is that correct?
Olette.
Okay, could you go ahead and state your full name?
Matthew Olette.
Go ahead, Ken.
Your Honor, we'd be requesting an adjournment. I believe this is his first probable cause conference. We would like to negotiate with the prosecutor and are also waiting on some additional video discovery.
Probable cause conference March 6, 2025, 9 a.m. Bond continue.
Thank you.
Thank you, Your Honor.
Thank you. Court calls case People versus Antoine Patterson.
Attorney for the people. I'm Matthew Mansour, Assistant Public Defender, with and on behalf of Mr. Patterson, who is approaching my right. Mr. Patterson, can you state your name for the judge, please?
Antoine Patterson, Senior. You're requesting an adjournment.
Yes, please, Your Honor. I think we're missing some media discovery, so we're going to request that.
March 6, 2025, 9 a.m. Bond continue.
Thank you. Okay, yeah.
Court calls case People versus Crystal Pratt.
Assistant Public Defender Hannah Apple appearing on behalf of Ms. Pratt. I don't believe it's present. Your Honor, the court graciously granted an adjournment at the last date as she was referred for restorative justice. She was accepted into the program, but I have not been able to reach her in the last several weeks.
Bench warrant will issue for defendant's failure to appear. Bond 10,000 cash surety. That warrant will issue immediately. Court calls the case People versus Mark Richardson.
Brian Bowling on behalf of Mr. Richardson. Just state
Mark
your name.
Richardson.
Your Honor, Mr. Vangalil and I are working on resolving a discovery issue. I believe he was reaching out to the OIC to hopefully be able to obtain the materials that I'm looking for. So we just asked for an adjournment, a little bit of time.
March 6, 2025, 9 a.m. Or your invite indicates bond continue.
Thanks, Judge.
Thank you. Race people versus Devontre Scott. Said that name wrong. You know what I'm talking about.
Stephanie Cannon on behalf of Mr. Scott, who's appearing to my right. Mr. Scott, say your name for the court.
Savion Scott.
Victoria Parker, you're again appearing on behalf of the people.
All right, what are we doing?
Your Honor, Mr. Scott would like to have his preliminary exam.
All right, discovery all complete.
Yes, Your Honor, we have all necessary discovery, yes.
What's that mean?
I will check into it.
So, Your Honor, there is video, screenshots of a video. So we have the screenshots. I don't necessarily need the video in order to hold the preliminary exam, but we have the still shots from the video. I was just asking if we could possibly get the whole video, but I don't want to hold up the preliminary exam itself for that.
Did you check all 14?
Is the screenshot going to give you what you need? I mean, rather than the video, I mean.
Your Honor, I think for the purposes of a preliminary exam, yes. For the purposes of a trial, no.
It will not be adjourned for to get that video. You understand that? So if you think the video is going to show something different than the still shots, or that becomes an issue, I'm not adjourning or continuing it.
That's fine, Your Honor. As far as the preliminary exam go, we'll be fine.
Preliminary examination, will people have their witnesses available March 4th?
I don't see why we would not, Your Honor.
All right. Yeah, March 4th, 2025. 9 a.m. before me. And we'll continue.
Come on, you said 9 a.m.
Court calls the case, People versus Jermaine Shaw.
Stephanie Cannon on behalf of Mr. Shaw, Your Honor. Mr. Shaw was actually at the forensic center, according to Gina, or one of my colleagues. And so she had asked for, her notes say that this was supposed to be adjourned to 3-4. When I'm just asking for it to be adjourned to 3-4. Yes, and I do have the green sheet for him, Your Honor.
Well, first of all, we wouldn't. Well, it's set for competency. You're saying they're at the forensic center. I probably would think it probably would be, but.
This is according to Miss
Noveski.
Yeah. I keep on just calling.
I know.
I'm sorry.
I'll adjourn it to March 13th, 2025, 9 a.m. It would be likely that they would. Court calls the case, People versus Anthony Smith. Oh, here we go.
Anna Mackey on behalf of Mr. Smith. Your Honor, yesterday I called the Delana Center, who notified me that Mr. Smith does come there around 5 p.m. in the evenings. However, he was not there when I called, and said that during the day he goes to the First Church of Ann Arbor for a warming center. So I was unable to get a hold of Mr. Smith as he does not have a phone number himself and he is homeless.
So what are you requesting I do?
Oh, an adjournment, please, Your Honor. So we can try to get in contact with him and call the Delana Center again, and maybe he'll be there.
So what do you think I'm gonna do, Miss Mayor?
I think you will adjourn his matter.
Here's what we're gonna do. It's your bench warrant for failure to appear, bond to be setting him at a 10,000 cash surety. I, however, will not issue the warrant until the 24th.
Thank you, Your Honor.
Thank you.
Have a nice day.
You do the same. Court calls the case, People versus Brandon Smith.
Shalani for the people. Assistant Public Defender Chelsea Vergils with and on behalf of Brandon Smith. Mr. Smith, please state your name.
Brandon David Smith.
Thank you.
Your Honor, may I approach with counsel?
Yeah, come on.
Thank you, Your Honor.
Well, while they're talking about that stuff behind cameras, I'm still trying to research um, what is happening. Um, but well, like not what is happening because the thing is, I think we are not going to be in the deliberations today. Knowing this judge as he has, the deliberations is not gonna happen today. Um, so that's just my thinking. I think they are gonna do the openings, the closings from both sides. We're gonna go through that, and then is gonna call. I think it's gonna call it a day, and then just put them out. So court is going back now. So the live court, the yeah, the live court, the live court, absolutely. So um live court. So Zach apparently, sorry, I'm trying to get the thing. Zach is back in the courtroom. We are waiting on the judge and the jury for closings. I don't know. I mean, I don't think they are gonna deliberate today, but I could be wrong. And I mean, we'll be here for whatever
Record should
it's needed
reflect
to
we've had
be
a brief
here
or
for. I
defense
mean, if
conference in
we
this
stay
case.
here all night, we stay
Probable
here
cause
all
conference in
night.
this case,
We're
March
gonna
6,
we have
2025, 9 a.m. Bond continued. Thank you. Court calls case, People versus Eric Smith.
Public Defender Felon Nicholas Bukovich on behalf of Mrs. Smith, who should be appearing via Zoom.
Sir, you need to unmute and state your name.
Eric Smith.
Thank you. Yeah.
At the time, Your Honor, I will be requesting a mitigation evidence by the prosecution, so we're just waiting for a finalized offer.
March 6, 2025, 9 a.m. Bound continue.
Excuse me, Your Honor.
Yes, sir.
I have a doctor's appointment on the 6th and the 10th of March.
Oh, yes, I apologize.
March 13th, 2025, 9 a.m.
Thank you for catching that, Mr. Smith. I forgot about that.
Thank you, sir.
Thank you.
Have a great day. Court calls case, People versus. I said it at 9. Your counsel will let you know what block you're in.
Just like I did this time, Mr. Smith. I'll let you know, Zach, what time you're in.
Okay, thank you.
Court calls the case, People versus Julian Trabant.
That's a lot for the people.
Matthew Mansour, Assistant Public Defender, written on behalf of Mr. Tabron, who appears today via Zoom. Julian, can you state your
All right, guys. This is a warning. Live streaming for closings is only a 15-minute delay, so we will be back in about 10 minutes. So I will put the message out saying that it's only a 15-minute delay, the closings on the live stream. So I just got notice of that. So I'm just trying to text people things. So I just thought of letting you know so you can get ready for closings. We'll go back to court.
your name for the court, please?
Go. Thank you. I'll pass it. For calls case, people versus Vershawn Vincent.
Public Defender Hannah Apple appearing on behalf of Mr. Vincent, who should be appearing via Zoom.
Yeah, should be, but nah.
He's really not there? Come on.
You don't have, he's not waiting. He's not there.
Judge, he has a history of appearing via Zoom. He hasn't had any issues, and I had communications with him yesterday afternoon regarding, I would ask for consideration of an adjournment or to pass it so that I can have him appear.
This is Anderson, who passed this mess on to Mackey, who now Apple is starting. Find him. You have your client?
I do.
For calls case, people versus Louis Ferrell.
Assistant Blood Center, Daffy Lebo, Mr. Feraldi, who's approaching to my right. Mr. Feraldi, please step to the podium and say your name, sir.
Louis Feraldi? All right.
Thank you. And today we're going to be requesting an adjournment or to compile some mitigation information presented to Mr. Cook. Additionally, we're requesting a bond modification that Mr. Cook has advised me he does not object to, and that would be that Mr. Feraldi is permitted to travel out of state as needed for his employment as a salesperson.
I'll adjourn probable cause conference March 6, 2025, 9 a.m. And I'll indicate defendant may travel out of state for work purposes. You must have proof that that's what you're doing.
Your Honor, I would request a further out PCC date, just because I don't believe the mitigation information will be compiled by March 6th.
How much more time do they need?
If we could get at least 30 days, I think that would be sufficient.
You need to tell your mitigation people they need to work faster. I'll give you to the 13th.
Thank you, Your Honor.
So you may travel out of state for work purposes, sir.
Thank you, Your Honor.
Bond will otherwise continue. Thank you.
Have a good afternoon, Your Honor.
Clerk calls the case. People versus William Petke. Petke.
That's a lot of good people.
Just council just substituted today and it's not. Yeah.
Oh, sorry. State your name.
William Katke.
Do you know where Mr. Biello is?
I have obtained an attorney on my own yesterday who was here this morning, but he had a case somewhere else this afternoon. So he asked if I would request this be adjourned.
Did he check in with us this morning?
His office has been in contact with court here.
With who?
I'm not sure who they requested this be done, that my attorney could appear via Zoom, and that was, they said no to that, so.
And
I received the stipulation through the clerk's office. Did the court repeat the attorney's name? I didn't catch it.
Biello?
Biello?
Biilo? Or Bielo?
Thank you.
You have nothing?
They sent a request to review these to the clerk's office this morning at 10:40 a.m.
They did not get a response, and he's just not here. the adjournment, but I'm just gonna adjourn it out 1 week, so we can get this to February 27th, 2025, 9 AM, or as your invite indicates, he would get an invite indicating the time. And you can let your council know I'm directing that to be in person.
Understood.
Thank you.
Thank you.
March
Uh,
6th, Your Honor?
No, 27th next week.
Oh, thank you. I apologize.
Okay, thank you. Are you ready?
I think I saw him on Zoom. I see you. I have faith.
So since they have made me wait, I'm not calling them. We're calling case people versus Rashawn Vincent. See, you can play that game.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Vincent. Mr. Vincent, can you turn your camera on and state your name for the record?
And I will say, he usually is here.
Yeah, there he is.
Vincent, state your name. I think he can. Mr. Vincent, can you hear me? If you can hear me, wave your hand. Okay. He's something's wrong with his mic. You're asking for an adjournment anyway?
Yes, Your Honor.
Okay. Mr. Vincent, I had faith you'd show up. Everybody else didn't know. Hello?
Yeah, I'm here.
Okay, we got you. Okay. I'm going to adjourn this out to the 13th. March 13th, 2025, 9 AM, or as your invite indicates. Okay, Mr. Vincent?
Okay, thank you.
Bond continued. Thank you. Got to use one bench form sticker. One.
All right,
Only
so
one.
I am gonna swap to the feed, back to the feed. But I'm gonna mute the sound because I don't know what they are playing and I don't know if it's copyright or not. So, the sound is muted. Because I think they're playing some kind of music, so I don't want that. Like, because I don't know if it's like copyrighted or not. But the court should be back soon. I'm just doing one test. 1 second. So yeah, so I'm just gonna talk a little bit. Yeah, that's the the well, Court TV one. It is very good one, definitely very good. I need to move myself back up. It's not letting me. Come on, I need to move me. Um, it is a very good one. By the way, Lewis, do you have any trial on your mind that you want us to follow next? Because I am trying to find something, but I can't. The one that I was talking earlier, I cannot find almost any information on, and like I was saying earlier, it was gonna have too much of big of a break between, so we can afford. And then there's another one that I got myself really interested into, but I shouldn't have because it's in California, and that the time zone of that it's yeah, no bueno for me, unless that is the only thing going on and we will be on permanent rewatch. We can do that and be permanent on rewatch on that one, because it's a former judge that's gonna go on trial. I really want to watch, but um yeah, but the time zone for me and with work, it sadly it won't work. So, California. I'm gonna just read a snippet. It's a California judge who allegedly pulled a pew pew from his ankle holster and unalived his wife will have his day in court. Opening statements are slated for Wednesday in the unaliving trial at Orange County Superior Court Judge Jeffrey Ferguson. It sounds very interesting. It is. I want to watch, but it's just the time zone. So, what do you guys think? Would you guys be up for watching a catch up trial? It is almost a live one, but it's a catch up. It's going to be catch up trial because so we would technically start that one in a week's time. Um, if nothing else appears. I mean, if we are scouring the Oh no, we're not done today. This is just me talking. State closing statements are supposed to start in about a minute because from the person that is in on court little lies and alibis. She said pretty lies, not little pretty lies and alibis. She said that this closing statements delays only 15 minutes. So that should be any moment now because yeah, they should start any moment. The statements. Let me see if the other one it is already up. So I'm just gonna like you know how I am. I like to jump the gun and like this one is almost finished. I just want to finish it all. Okay, the other feed has not come back yet, so that will be fine. So yeah, so I just wanted to kind of know what we're doing. I like to know what I'm doing, but I haven't there is a couple trials on my radar, but I don't know about feeds. um so yeah, so I was just like going with the flow and everything, but I like to plan, I guess. um so I think closings are about to start. Um, so let me have a look if this one started. No, sorry, I keep swapping between feeds, but I'm sure when one starts, the other one will start too. So there's two trials that I have in my radar at the moment. One is from Florida, which would be amazing because it's in our time zone. The other one is from California, which is completely outside of our time zone, which we would be completely on catch up. I don't not, but it is a very interesting one. I mean, it's not every day that a former judge goes on trial for unaliving his wife. So that one I'm sure is going to be pretty good, but it's just the time zone of it. So if we watch that one, we'll watch permanently on catch up. But let's I'm gonna not try to jump the gun, but who thinks that we're gonna have a verdict today? I don't think we are. I still haven't decided how long my deliberations are gonna be. I think I'm gonna say my deliberations gonna be between between 3 and 5. I'm gonna be brave and be between 3 and 5 hours of deliberations, and I don't think. Yeah, I don't think we're gonna have a verdict today. I mean, tomorrow, yes, for sure. Um, Today, not seeing. I mean, because then the thing is, I don't know how late the judge is gonna keep the jury. Depends on the weather. Because if it is really a bad storm, and so let me see, Green Greenville, South Carolina. Um, yeah, exactly. There's like too many delays, nonsenses, and there's also the weather. So if the weather like, oh, hang on, I am hearing noise. the feed has changed, so we should be back soon, very soon for closings. I don't think that there is no prediction of snow anyway, I think, for Greenville. So sorry, I was hearing like voices in the background and it's my own voice. And I'm like, hang on. Oh, hang on. There is. Why is my feeds not working? There we go. Hang on, I'm having an issue, which is not surprised. Bear with me a moment. Oh, come
things. I will give you a bit of a caveat that this is a little bit of a unique case in that you rarely have the defendant testifying and admitting to the entire crime during the trial. So in that respect, my closing argument may be a little different or maybe a little abnormal than our normal way we do things, but I'm going to do my best. I first want to thank you for your service. It's been a long 2 weeks. Y'all have been extremely attentive. You've paid attention. You've listened to the judge. And to be frankly, I couldn't ask for a better jury, and I appreciate your service. On behalf of my co-counsel, Mr. Jake Hoferth, Investigator Jared Sparkman, and Master Deputy Blake Wolf, we thank you for your service. Now, I told you in my opening statements that once you see and hear all the testimony in this trial, and I did not know that the defendant was going to testify, you're going to find that Zach Hughes, I don't know if you remember what I said, is a cold-blooded killer. And I submit that the state, and along with the testimony of Zach Hughes, we did in fact prove all of that beyond a reasonable doubt. Zach Hughes is a cold-blooded killer. Zach Hughes is an admitted cold-blooded killer. And keep in mind, he solved John Mello's problems. So the judge is going to instruct you on the law, and just as we're going to abide by his rulings, you must abide by his instructions. Remember I told you he's the referee, calls balls and strikes, and he also tells us what the rules are, what the law is. Y'all took an oath way long ago than you can probably remember, back in last week on Monday, a week ago. And you said you would take an oath, you would adhere to his instructions, you would do your duty as jurors, and I have no doubt in my mind you would absolutely do that. Now, before Zach Hughes admitted to the murder of Christina Parcell, state called approximately 32 witnesses. We submitted close to 200 exhibits. If you put all this on a hard drive, it's a little over 4 terabytes of information. Woo-hoo. And all of that taken together, it's a lot of evidence to digest. Now, with the admission of Zach Hughes to a lot of the state's case, the questions you were presented with at the beginning of the case really are answered. Regardless of what he may believe in his head, his actions are what matter in this courtroom. Actions speak louder than words. And boy, do we have a lot of cold, calculated, horrific actions in this case. Now, ladies and gentlemen, you must find the facts based on the evidence in this trial and solely based on the evidence presented at this trial inside this courtroom. And it's undisputed that Zach Hughes planned, he lay and waited, he broke into Christina Parcell's home with a .22 and a knife, some roses. She had just returned home from an interview, from her last interview with Vet Tech. Zach Hughes, a person she had never met. She had never met him. Beat her with a gun, brutally stabbed her 35 times, severing her jugular vein and her carotid artery. Now, as we go through the evidence and we look at some of the different things, I'm going to ask you to keep in mind the charges that you're actually looking at. So the first charge I'm explaining is the harassment charge. And there's two harassment. There's harassment and there's conspiracy to commit harassment. The only difference is the conspiracy requires two or more people joining and to commit the harassment. So harassment is just a pattern of intentional, substantial, and unreasonable intrusion into the private life of a targeted person that serves no legitimate purpose and cause that person and would cause a reasonable person in his position to suffer mental or emotional distress. That's related to all those photos and those documents that you saw mailed out. I think there's 7 envelopes full of photos and other documents. You heard testimony about what was in those. Some of them are in evidence. Some were just described because those were pictures of Christina Parcell without any clothes on. So we didn't introduce those so as not to embarrass her or her family. Burglary first. A person is guilty of burglary first if he enters a dwelling without consent and with the intent to commit a crime. And to remind you, the judge is going to tell you the law is, what it is. I'm just trying to give you an outline so you can keep that in mind as we're going through this evidence. And they enter without consent and are armed with a deadly weapon or cause physical injury. Well, those things all already appeared in this case. Zach Hughes went in under a ruse of roses, according to his own testimony, but he went in directly with the intent to commit harm, and he had weapons on him. And then you've got murder. You also have possession of the weapon during the commission of a violent crime. That is, if you used a weapon and you murder somebody, that is the possession of the weapon during that commission of a violent crime. But you have murder, which is the killing of any person with malice aforethought. Malice aforethought. And you're going to hear those words a lot in the judge's instructions. But malice is ill will towards another person, the intentional doing of a wrong act with the intent to inflict injury. And I think I said early on, ladies and gentlemen, it was a depraved heart, an angry heart with the intent to harm somebody. And there's also express malice, meaning it's expressed. It's right there in front of you. And it's shown when there are words of hatred or when someone prepares to do the act. They prepare to go in there. It's called premeditation is what you'll hear the judge charge you. Premeditation is preparing to go and harm somebody, like lying in wait, like buying weapons beforehand, by concealing your identity, going in there. Those kinds of things are premeditation, things that you do in preparation of the violent act. And if you find those things, and you find the state proved those beyond a reasonable doubt, then you can find the defendant guilty. So before we get in, let's start with a little background now. You know the players, you know everybody involved in here, you know the victim. You've heard a lot about the victim, Christina Parcell. You've heard a lot about John Mello. You've heard a lot about Zach Hughes. And you've heard a lot about Christina Parcell and John Mello's daughter. So the background, and we're talking the time frame from 2020, October 2020-ish, to October 13th, 2021. So we're roughly a time span of 1 year. And what happens throughout that year that leads up to the murder of Christina Parcell? Zach Hughes never talked to Christina Parcell. He didn't know Christina Parcell. He never met Christina Parcell. And everything he knew about Christina Parcell, even according to his own testimony, was told to him by John Mello or shown to him in certain evidence. John Mello was in a nasty custody battle with Christina Parcell. We all know that. He was on his 4th round of custody disputes with Christina Parcell. Keep in mind, and according to the guardian ad litem, the prior 3 were just as nasty, but they'd always been settled where John Mello would have significant custody of their daughter. But in April of 2021, that changed. The tide changed for John Mello because he took Aida out of the country in violation of that order, according to the Italian courts. And he took her to Italy. And Christina Parcell didn't even know about that until she saw a social media post where she realizes my daughter's out of the country, I can't see or talk to her, and she's with her father. Thus, the continuation of this nasty child custody dispute. And then from October to April, Aida was living in Italy with little or no contact with Christina. So what did Christina do? She did what any mother would do, is she tried to get the return of her daughter. So she went through this process, and it was explained by Christina's sister, Tina Parcell, as well as the guardian ad litem, Vanessa Cormelo. She filed under what's called the Hague Convention, and she asked to have her daughter returned to her. She actually flew to Italy twice to have these hearings in Italy. And she was successful. She won that particular battle in this myriad of battles of child custody that have been going on between these two individuals. And so in April of 2021, that really set off John Mello. He was unhappy. And we know the things, and we're going to talk about the things that he did starting that day through the WhatsApps, through the harassment letters, everything else, to solve that custody dispute problem. And that's where this case really, really began. That is when things turned not in favor of Christina Parcell. She lost her life as a result. So what is the relationship between Zach Hughes and John Mello? All right, so where did they all come into this mass of characters? Well, according to Zach, he met John on the streets of Greenville about August of 2020, and he was with Aida, and Zach played a very likable classical music piece that John Mello and Aida liked. And that's how they met. So they met that one time. That was one of the few times that Zach Hughes actually met Aida Mello. And he talked about, they went on about 4 or 5, maybe 6 occasions where they were hanging out. They got some tacos one night. They saw a museum. But Aida Mello didn't know Zach Hughes. She didn't know who he was. She's a 9-year-old little girl who heard him play a piano piece, who's a friend of her dad's. And that's all the time they ever spent together. That's it. In August until October, John Mello left for Italy. And with him went Aida. So Zach Hughes never spent any more time with Aida, what little time he did during that small time, ever, never again. Now, he may have seen her on a FaceTime while he's talking to her dad. He may have seen her or seen videos of that, which he testified to. But Zach acted on this stand as if he could see into her soul. He could see into her eyes. He knew how she was feeling. He could tell that she gained weight and why she gained weight at a certain particular time in her life, in her adolescent life. He is drawing those conclusions on a little bit of information and nothing but whatever John Mello is feeding him. So, what's their first thing? Aida's back with her mother. She, in May, begins living at Cambridge with her aunt, Tina Parcell, and that's where they're living there. John Mello's in Italy, and Zach Hughes and John Mello decide, well, you know what we're going to do? Let's embarrass Christina Parcell. Let's make her life look bad. Let's make her look like a prostitute. That'll help me get custody of her. That'll help me with the guardian ad litem. And so John Mello, according to Bevel, Detective Bevel, who testified, had photos, and according to the evidence right here, he had photos of Christina Parcell. And those photos were taken when she was much younger. And those photos are taken between two consensual adults engaging in what acts that two consensual adults can do. And that's it. And then he took those photos and he used them as a weapon. And he tried to make her look like a prostitute. Because that's what John Mello continually told Zach Hughes, according to his own testimony, Alex Field's affidavit. Let's make her look like a prostitute and let's send them around to a neighborhood. Well, they sent them to a neighborhood where Brad Post lived. They didn't even send them to Canebrake. And we know this because in these WhatsApps, they talk about it specifically. They talk about, may I present to you my daughter's mother, Christina, Caroline Warren, escort. And we know there's a bunch of attachments that we can't see because Zach Hughes deleted these on October 13th. And when we retrieve them from WhatsApp, they're deleted. So you have to see us, investigators department, manipulating these WhatsApps. And then they sent them that way. And then Zach Hughes receives them. He gets them. And he sees an email that was sent to him as well. This email is very important. And he prepares all these packages to Brad Post, to Mr. Bradley Post. These are all his P.O. box. Brad Post. Cigar bar, where Brad Post hangs out. Misspells Mr. Post one time in the WhatsApps. Misspells it here, P-O-A-S-T, which is why we know it. But Zach Hughes admitted it. But this email here purports to come from Mullen Investigations. Mullen Investigations at protonmail.com. And it's cut out. And you've got this photo of Christina Parcell, and you've got another photo of Christina Parcell back there, which is the same ones that are in here. But there's no URL with Bella Donjon right here. And this is the escort site, and it says Caroline Warren. She became a member, Caroline Warren, in 2009. Well, this is 2021. And apparently this Mullen Investigations on May 16th found these photos attached to this website, except the photos don't have anything attached to the website. It's just a square of an escort site of Caroline Warren. Well, I don't know who that is. I know this. I know Caroline Warren. I know Mullen Investigations, John Mello. Vanessa Carmelo testified to it. She received emails from Mullen Investigations, and she received lots of emails from people purporting to be John Mello. So Zach Hughes went to the trouble of preparing all these envelopes, manipulating all the items, the photos, the escort, and putting it together. And he wanted to make sure we knew it was her. And so we would add a cover letter. You can see the cover letter that he would do. He had to add a cover letter to make sure you knew exactly who that was, that it was Christina Parcell that was engaging in prostitution. And he sent them out to shame her, to make fun of her. There's WhatsApps in there saying, we're going to ruin her day. And Zach Hughes did it the same way he committed this murder. He used his bike, he avoided cameras, tried to find a location, and he didn't know that we could track his phone. And so we know he was in Greenville when he mailed those in June and July, and he was in Tennessee when the other two were mailed. So we know he did all that. But the big point of the harassment is not that that's bad to do somebody. It's really what Tina Parcell referred to as revenge porn. South Carolina does not have a statute for revenge porn. We have harassment. And that's exactly what that is. But he's really doing it, one, to make her look bad, to make her look like a prostitute. But he's also trying to do it to gain a strategic advantage in this custody battle. And it doesn't work. He even sends one to the guardian ad litem. What does the guardian ad litem do? She investigates everything. But Brad Post put a lot of work. Zach Hughes put a lot of work into that. It's a lot of work finding all those envelopes. To somebody he doesn't even know, he's never met, never talked to. Now, John Mello, I would say he's pretty much a liar. He dated Christina back in 05 and 06 and had their daughter in 2012. And of course, this custody battle. And if you want to look about the character and who John Mello is, I refer you back to Vanessa Cormelow's testimony. She testified that John Mello would do horrific things in relation to this custody battle. To her, to a lawyer who's representing a little girl as a guardian ad litem who's practicing law for 26 years, he would accuse her of horrific things, according to her. He would accuse her of trafficking children in Spartanburg. He would post things on social media ridiculing her. And that's how John Mello operated. That's how he operated. He used deceit by using fake emails. He used threats to try to get what he wanted. Mullen investigation. He sent those to Vanessa Cormellow. He sent an email pertaining to be a lawyer named Sophia Carlucci, according to Vanessa Cormellow. And she knew it was John Mello writing it because she's read so many emails from him, they matched up. So he's trying to gain a strategic advantage. John Mello and Zach Hughes were trying to harm Christina because John Mello had a custody problem. And the only way to solve it was murder. So Zach visits John for 3 weeks in June in Italy. So he met him for 5 times between August and October of 2020. They're having lots of conversations on the WhatsApp, and he's in 3 weeks in June in Italy. And it was a pretty important moment when Zach Hughes said, John Mello offered me $5,000 to kill Christina Parcell. John Mello offered me $10,000 to kill Christina Parcell. Now, of course, Zach said he wouldn't take that money. He would just do it for free. Because killing Christina Parcell is the right thing to do. So I submit that's when the plot to murder Christina Parcell began. That's kind of when this evolved. And I think they started with the photos, which were in June and July, but that wasn't going to carry any weight with anything. Interesting that a struggling pianist turned down $10,000. Do it for free. Especially of a person he's never met on behalf of a little girl he barely knows. Now, much of what Zach Hughes said, I believe, on that stand was true. I think a lot of it was a bunch of self-serving, narcissistic junk. Zach Hughes is trying to portray himself on that stand as a hero instead of the cold-blooded killer that he is. Ladies and gentlemen, we judge the defendant by their actions, not by their excuses or their words. Actions speak much louder than any self-serving lies from a sadistic, pathological killer like Zach Hughes. He murdered Christina Parcell, mother to Aida, sister to Tina Parcell, and daughter to Erica and Tim Parcell. Now, I've talked a lot about Vanessa Cormellow because she's a key witness, because that is the dispute that we're having, the custody battle. And she's in charge of making recommendations about who should get custody. Her job is to investigate the custodians. She stated that she investigated every allegation which were at Christina, which was involved in prostitution and drugs. She stated she would investigate every allegation, hire private investigators, put trackers on cars, meet with potential custodians, have home visits, and talk with the child constantly. So she's doing everything that she can possibly do. She even had allegations like Alex Fields. There's an affidavit that the defense submitted on Alex Fields, where he says that he was propositioned by Christina Parcell for sex and offered to sell him drugs. And he put in an affidavit. This was after John Mello put on Craigslist, "Do you have any information about Christina Parcell that I know about? I'd like to know anything about." Who responds to a Craigslist ad about somebody and then sets an example of what they did at a bar? And for what purpose? Maybe it's true. Maybe it's not true. I have no idea. That's what Alex Fields says. Really doesn't matter. While the defense wants to impugn the integrity of Christina Parcell as a justification for committing murder, so be it. If doing bad things means anyone can break into my house and stab me 35 times without retribution, then two things will happen. There'll be a lot of people stabbed to death, and I'll be out of a job, because all we'll have is vigilante justice in our system. But again, these are allegations that John Mello is making. He's looking for any dirt on Christina Parcell. Again, these are all allegations. Well, let's come to October. Vanessa Cormelo was getting close to making her decision. Who's going to get custody? Her investigation revealed that before Christina's murder, she would write a favorable report for Christina Parcell and a bad one. That's what Vanessa Cormelo said. In addition, it was almost 6 months since Aida had come home, and that's important. 6 months. Someone can file to terminate the parental rights of another. We were about to be 6 months. Zach Hughes said October was the time that he felt it was the time to kill her. Just felt it in his heart and his mind. And he tried on the 12th, did it on the 13th. That is important because it was getting close. John Mello's getting a bad report, and things aren't going to go his way. So he's got a problem. Now, if Christina Parcell is no longer around, he's the last man standing. He's going to get custody. So Zach admittedly decides to murder Christina Parcell. That was his intent. He bought a gun and a knife about a month before. It was weighing on his soul. Custody dispute's not going well. And so he entered into a lot of planning going into this murder. A ton of planning. And the state presented all of this evidence to you before he testified. But we know that Zach Hughes on the 12th was up at the Mountain House because his phone showed that he was up there. And while up there, he had his truck. And we know he put his bike in the back of the truck. And we know he parked it somewhere. And we know that he decided to park somewhere near Canebrake and ride his bike in there. And we didn't know, but we know that he knew the schedule of Christina Parcell that day because he said John Mello told him. So he gets in his truck, and I would submit he arrives around 7:42-ish to somewhere wherever he parked. We never learned exactly where he parked near Canebrake, but we know he parked somewhere there, and he rode his bike. Because at 7:42, we know from his phone that he plugs it in and unlocks it. And that's the last activity on his phone at that time. So he parks, maybe he plans, he thinks, and he gets on his bike and he drives in. And we know he drives in because he passes Donna Gorman's house. And Donna Gorman was an early witness from the state. And she did an identification of Zach Hughes from that witness stand. State was not expecting that. We had never shown her a photo lineup. We'd shown her a photo of the bike, of Zach on the bike from the ring cameras. But she had never seen Zach in person. And so we just left it. Now, we did wait until about 3 years after the murder before Donna Gorman told us that information. That is true. Riley Stokes talked to her that day, and he didn't have a copy of it. Master Deputy Wolf talked to her on the 19th, and he didn't show her a copy of the person on the bike. And so there was so much chaos going on, so many officers moving in so many directions, trying to find the evidence to solve this murder. It was just overlooked. And so when we went and talked to her, this was her testimony. And that's what we presented to this jury. She was right. She was right. The DNA proved it. Zach Hughes proved it. So Donna Gorman sees him, and she says this around 8:15-ish when he goes by. And then he goes to Christina Parcell's house. And my opinion is that he went and he hid under the bottom of the house. His testimony was different. He says different. He says that he got there and went straight in, dropped his bike, and went to the front door. We have a difference. Maybe he's telling the truth. Maybe I'm wrong. At the end of the day, it doesn't really matter. But I submit that he went and he waited. He had an hour to wait. Of course, he had an hour drive from the Mountain House all the way to Canebrake. And you know what he could have done? He could have turned around. He could have done anything he wanted. He could have gone to the QT. He could have changed his mind. Had many opportunities to do that. He was committed. And so he went and he lied and he waited. And he waited for a time because he knew her schedule and he knew her car. He knew her address. That's in evidence. And he went and he decided to walk in the front door with roses as a ruse, according to his testimony, with a gun and a knife and a backpack, paint thinner so he could clean up afterwards, and he kills her. So let's see the moments before Christina Parcell is murdered. Zach Hughes, dressed as he said he was, gray sweatshirt, backpack, black pants, walks directly into that house. I can't see if he's carrying flowers. I know he was. I know he had flowers on him. And he walks in and he surprises Christina Parcell. Points a gun at her and hits her in the head with the gun. And then he stabs and he begins to stab and he begins to slash and he begins to slash and he begins to stab and slash. Now think of the force needed to stab someone in the chest, stab them in the back, all over the head. And finally, and through all the fighting and the stabbing and the pushing, while Christina is fighting for her life, he finds the vulnerable spots, stabs her in the jugular and the carotid artery, causing her to bleed out. With blunt force trauma to the head She has to be on the ground. Blood is everywhere, pulling around her dropped phone and the couch. But that's not enough. He drags her through her own blood to cover up the crime as he closes the curtains and locks the front door so he's not detected as droplets of blood fall from his blood-soaked clothes. She remains laying on that floor in her own blood with nothing but her blood-soaked scrubs and her wedding band that Brad Post gave her. But his sadistic actions are not over. I submit, ladies and gentlemen, those rose petals had a dual purpose. He may have used them as a ruse to get in and get inside the house so he could surprise Christina and gain that strategic advantage to murder her. But he also sprinkled them around. He sprinkled them around the house, on her purse, around, as some sort of sadistic, artistic sign that he thought was necessary. Then he had to keep in line with the allegations: prostitution and drugs. Put a bag of cocaine under a couch, under a chair, right down from her body. Killing her wasn't enough. Shaming her was the goal, too. This was not to save Aida. This was to help John Mello win his custody case. He never told us about the drugs either. Never mentioned those. So then the cover-up. So then, after you effectuate the crime, you commit it, then you got to clean up. You got to cover up. So he first had to cover up the scene. He had to worry about that DNA under her fingers. That DNA is key to this case. He had to wipe her fingers down with that paint thinner. He did not want to get caught. Pre-planned, and then really good exit strategy, cover up. Then he went back to the mountain house. Of course, we know he's there because his phone puts him there around 1:17. He connects to the Wind Wi-Fi. The Winds have a mountain house. He has access to it. Remember, it's real remote. I think Master Deputy Wolf said it's so remote you could walk around naked. Nobody would see you. Perfect place to clean up a crime scene like that. Can you imagine how soaked in blood his clothes were? Can you imagine how soaked in blood his car was? Can you imagine how soaked in blood his bike was? And he did. And he admitted it. Burned his clothes, ditched the knife and the gun in some pond, cleaned up everything, and he went back to Tyndall about his daily life. And that's what he said. I've mentioned Zach Hughes' testimony a lot. And I'm sorry that you had the unfortunate privilege of hearing the specific testimony of the killing of Christina Parcell by a cold-blooded, cold stone-faced killer trying to portray himself as a hero instead of the cold-blooded, calculating killer that he actually is. Only a person with a severely diminished sense of heroism, with a heart that is cold as ice, can portray that. The absurdity of many of his words And I'll reference a couple. I wanted to make her death quick and painless. This is what he said. When I was listening to that, it was hard for me to comprehend that someone is actually saying that at their trial to a jury. Do we say thank you? I appreciate it. Thank you for taking my pain into consideration as you murder me? What does that even mean? Well, I'll ask you this. Was it quick and painless when he hit her in the head with a gun? Was it quick and painless when he stabbed her the first time? Was it quick and painless when he stabbed her the second time? How about the 5th? The 10th? Maybe the 20th? He was being considerate. Maybe the 30th? How about the final 35th blow? And then, of course, I asked him one question. How'd you drag her body across the room? And he said, I don't really recall, but I think it was by her ankles. And he looked me in the eyes in a stone cold faced way. Told me the answer. Like he was proud of it. He said, I do not want anyone else to be involved. I waited till everyone was gone. Thanks. Appreciate that. Talking like he's doing us a favor. I wonder what would happen if a neighbor did come over. I wonder what would happen if Brad Post had showed up. I wonder what would happen if Tina Parcell had showed up. Would it be a double homicide? So we could escape and escape detection? And of course, he was so calculated, he got her schedule that day from John Mello. And then he said, I didn't want to get caught because they would connect me to John Mello. Oh, okay. So if you didn't get caught, you solved the custody problem. But if I did get caught, then I didn't solve the custody problem because then they would connect me to John Mello and he wouldn't get custody. Then he comes in here, testifies, connects John Mello. Doesn't make any sense. Now, he talked a good bit about his background. My understanding, he's a fantastic pianist, highly trained. But he went through his resume with an ego, letting you all know how great he really was. Military service. Playing these really difficult sonatas by Beethoven. I'm going to play all 16, never been done. But he described his sister Grace in great detail as well, for some reason. He said she was a horrific person when confronted with irrefutable evidence. She would go cold, stone-faced. She would manipulate and recruit others to do a terrible deed. If you trust Grace, you're only going to get hurt again. She was a vampire and would suck the blood right out of you. Maybe he's described himself. He said, I feel pity for her. He felt pity for Christina Parcell. How is that even possible of a human being? His heart is so mean, so depraved, that he viewed someone he'd never met and discussed the specific details of killing her, treating her like she was an elderly dog being sent to the vet to be euthanized. It doesn't get any meaner than that. Christina Parcell didn't have to die. Zach Hughes had a million opportunities to not do this. And if he did it to save Aida, there's a million ways to handle that. Vigilante justice is not allowed in this state. Vigilante justice isn't allowed anywhere. Regardless of what Zach Hughes had in his mind or what he thinks he had into his heart, he's lying to himself. Because all he had was hate and meanness, coldness. He brutally murdered Christina Parcell. So, ladies and gentlemen, it's been a long 2 weeks. I thank you for your service, and I thank you for listening to me. The evidence is absolutely overwhelming. I'm going to ask you to go back there and deliberate. I'm going to ask you to find Zach Hughes guilty of harassment, of burglary, of possession of a weapon during the commission of a violent crime, and murder. Thank you.
May I please report? Let me get a little bit more. I want to start with something that Mr. Wilkins said towards the beginning of his comments to you. He said, Zach Hughes solved John Mello's problems. Yesterday, Zach Hughes told you he solved Aida Mello's problems. That's what he told you yesterday. Ladies and gentlemen, you got to watch the state. You got to watch the evidence. Zach Hughes yesterday came in here and told you under oath that he killed Christina Parcell on October the 13th, 2021. He told you that. But contrary to what Mr. Wilkins just told you, killing somebody in and of itself is not a crime. Mr. Wilkins told you that he confessed to committing the crime. That is not the case. Yesterday, Zach Hughes told you that he killed Christina Parcell, but in doing that, he did not tell you or confess to any crime. And let me be clear, and let me tell you why I say that. Every crime, and the judge is going to tell you this in the instructions, every crime has two parts in general terms. The actus reus, which is the action, and the mens rea, which is what's in your mind, the intent that the state has to prove beyond a reasonable doubt. So it's very important that you understand this from the get-go. He did not confess to a crime yesterday. He confessed to killing Christina Parcell, but that in and of itself does not make him guilty of murder. That's very important. Okay? The first part of, or Mr. Wilkinson talked about how this case is unique. It is unique. And one of the unique parts about this case is that first part that I talked about, the actus reus, the action that's involved, there's very little dispute, if any. Zach admitted that he killed Christina Parcell, right? Where the dispute is, where the heart of this case is the evidence as to what was in Zach's heart, what was in Zach's mind. The state must prove to you beyond a reasonable doubt. It must be evidence that leaves you firmly convinced. It must be evidence that would cause you not to hesitate to act, right? That's what they have to do. So the heart of this whole case, Mr. Wilkinson can talk about the blood, he can talk about the scene, he can talk about all these things. But the heart of this case is the intent, is the mens rea. What have they proven about Zach's intent? All right, now, let's talk more about what the judge is going to charge on the law and what they have to prove about intent, about the mental side of this, right? Zach has been charged with murder. The state must prove beyond a reasonable doubt malice. That is the intent, the knowledge, the mental part of murder. The state must also prove burglary in the first degree, that when he entered that home, he intended to commit a crime. In this case, murder. He intended to commit the crime, which means there was a crime he committed. For harassment, the state must prove that he sent those mailers, which he admitted to doing. He sent those mailers without a legitimate purpose. And for the conspiracy, the state must prove that he formed an agreement to do something illegal. That is the mental component to this. And again, that's the heart of the case. And Mr. Wilkins, in his opening statement, said, we have to prove the state beyond a reasonable doubt an angry heart, that Zach was mad. That's where this case, that's where the heart of this case is. What was Zach thinking? What has the state been able to prove beyond a reasonable doubt about what was in his heart and what was in his mind? Now, you're going to hear, the judge is going to talk to you about different types of evidence you can consider. He's going to talk to you about circumstantial evidence, which is evidence that an arrangement of facts, when put together, that lead to other facts or conclusions. That's circumstantial evidence. Judge is also going to tell you about direct evidence. Direct evidence is evidence that comes from people who perceived what happened, who with their senses derived knowledge about what happened, right? That is direct evidence. The state has the burden of proof on the mental element, and the state is going to use circumstantial evidence. That's what they're going to use. We have no burden of proof whatsoever. We entered and are going to use both direct evidence and circumstantial evidence to explain what Zach's state of mind was on October the 13th, 2021. Now, what is the state going to do to try to prove what was in here, to try to establish the burden of the mental side? Again, it's more than just the acts. That's critically important. But what's the state going to use to prove the mental component to this? They're going to use the acts, and they're going to say, they're going to use the stab wounds, the photos. They're going to use all the actions that Zach testified to yesterday. That in and of itself is not a crime. And Mr. Wilkins, he talks about stab, and I wrote this down, stab, 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 slash, right? Got to watch. Got to be careful, right? This is a tragic case. Bottom line, someone died. The last thing I ever want to do is minimize the tragedy in this case. Not going to do it, all right? But when we come to talk to you about what happened, you have to have faith that what we are saying is balanced. Think about what Zach testified to and what Claire Rose testified to about Christina Parcell and what happened that day. All right. Stab, 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 slash, slash, slash. Claire Rose testified Christina Parcell was 163 pounds. Zach testified that he was 160 pounds. Claire Rose testified that there were, of the 35 wounds, the vast majority were incised wounds, superficial wounds, wounds that would have been consistent with a struggle. Zach told you that when he went inside, there was a struggle. He told you that they fell to the floor. He told you that when he got inside, his body would not do what he was telling it to do because he didn't want to do it. He did not want to have to do it. So let's talk about the circumstantial evidence that the state has offered as evidence to try to get you to understand what was in Zach's mind. The state talks about, in determining how much weight to give to their representations about their conclusions on the circumstantial evidence. Just think about this. Donna Gorman testified that 3 years after this happened, having never been shown a photo lineup, with Zach's face all over the television and the internet, that she says that she saw Zach. Now, here's what is most troublesome about this whole thing. She testified that she saw Zach at 8:15. That's what she testified to. She testified she saw Zach through 2 trees in her house, that he was wearing a hoodie, no evidence other than what she said about a hoodie. In fact, Zach said that he was wearing a hat or a smaller hat. There is no way that she could have seen Zach Hughes at 8:15, because by the state's own evidence, with the ring cameras, with investigator Sparkman, the state's own evidence, Zach didn't even get there until after 9 o'clock. So when he says, Donna Gorman, she saw him, it's impossible that she saw him the way she said, because she said 8:15 by their own admission, by their own evidence. Zach didn't even get there until after 9 o'clock. Think about that. In determining how much weight to give to their spin on the circumstantial evidence, think about investigator Sparkman, right? Called him as a witness and showed him reams of WhatsApp messages. These messages were garbled, but he had a unique skill. I don't know if he went to WhatsApp school, but he spoke fluent WhatsApp, right? And he was asked to decode all of these messages for you as though you couldn't have done it yourself. But what's the most interesting thing about what he said in the WhatsApp messages, there was one message that he was not able to decode, coincidentally. The message that had the words Aida and doomed. That was the only message he could not uncode for some reason. Think about that. In trying to determine how much weight to assign to the state's conclusions or their spin on the evidence, think about Vanessa Cormelo and what she testified to. Mr. Wilkins talked about how she was doing everything she could during this period to uncover it. Really interesting, and the judge is going to tell you this. You can determine or decide how much weight to give to testimony. You can give it a lot of weight, you can give it a little weight, you can give it no weight. I want you to think about how much weight to assign to the state's conclusions and that testimony, because I want to take you to one specific exchange between Jake Hofferth and Vanessa Cormelo. Jake Hofferth asked Ms. Cormelo, prior to October the 13th, 2021, and he said this, and they've said this throughout this entire case, prior to the murder of Christina Parcell, which is for you to decide and you to decide alone. Prior to October 13th, 2021, did you have a recommendation as to where Aida Mello should live? In other words, would you have had a recommendation as to whether or not she lived with her mother? And what was Vanessa Cormalo's answer to that. And you can hear this for yourself. At the time, I would have recommended the mom. At the time. There was no follow-up to talk about other times. Can you trust that evidence? Very important. That's the circumstantial evidence. Now, let's talk about the direct evidence that you received from Zach himself as to why he did what he did. He got on that stand, he told you. Let's talk about the direct evidence. He talked about what he knew. What he was told by John Mello. That was part of it. He talked about that. But contrary to what Mr. Wilkins said, he had a lot of other information besides just what John Mello told him. He had a deposition that Christina Parcell gave under oath in July of 2016. And you remember I asked him, after you read that deposition, what did you believe about Christina Parcell? What did you believe? He said he believed that she was engaged in prostitution. He said he believed that she had participated in a pornographic movie. He said that he believed that she had used drugs after reading that deposition. Another document that Zach got, Alex Fields' affidavit. Now, this is very important to consider about this. This entire case, the state has worked very hard to distance Christina Parcell from the escort website. And they've made these conclusions just because they want to. Despite the fact that there are website addresses on those photographs, they have insisted that those photographs were private photographs, were taken by John Mello and then somehow put on the internet by John Mello, that she had nothing to do with that, right? Think about this. And this is an evidence for you to consider. The Alex Fields affidavit, it has one page on the front, which is what he said, that they met randomly at Hall's in 2018, that she propositioned him for sex and drugs in exchange for money. He turned that down. But in the second page of the affidavit for Alex Fields, John Mello, in that advertisement, said, if you know this woman, her name is Christina Parcell, and then he puts the Caroline Warren alias in that ad. Right? Here's the question for you to consider. If he didn't think that she really and truly went by Caroline Warren online, why would he put Caroline Warren's name in an ad for people to respond to? Why would he include that if he did not think that may trigger someone who had seen her site? Why would he do that? I would submit to you, he put her name on that ad because she was Caroline Warren, and he was hopeful that someone who had seen the ad or used the ad would recognize the picture and contact him. That's the only reason why that makes sense. Let's talk about the other evidence, and let's talk about the elephant in the room. Let's just talk about it that Mr. Wilkins discussed. The planning, right? Let's talk about that. Zach was very honest when he testified about the planning. He told you in detail what he did. In a lot of cases, planning can be good evidence. In a lot of cases. As Mr. Wilkins said, this is a very unique case. And probably one of the most unique aspects about this case is that the person who Zach believed posed the danger was the mother to her own child. Think about that. This isn't where you're home and an intruder comes in, you don't know, it's a spur of the moment. This isn't a random interaction or difficulty. This is what Zach believed, this is a mother, the person who's charged with caring for your child, most importantly, the person of all on the whole planet who is supposed to be the most nurturing. This is the person who is doing this to the child. The person who lives with the child, the evidence was the person who shared a room with the child, the person who's with the child all the time. So in a situation like that, where you have a belief that's grounded on documents, that's grounded on information shared with you over many, many months, when you have that belief, how do you alleviate that threat, the threat from the mom, without thinking through how to do it? How do you do that? And so I would submit to you, ladies and gentlemen, that the planning in this case, unlike most any other case, doesn't show malice because the mom was the threat. The mom was the one who posed the danger. Mr. Wilkins talked a lot about, this was just interjecting the custody, just get John custody, get him custody, all right? If this was all about the custody, why would Zach have waited so long to do it? Right? Part of it, he was in a process. Part of it, he was working on this music project. But the other part is, Aida and John were separated for half a year. Right? If Zach wanted to fix it to solve John's problem, he would have done it much sooner. But the reason why it took so long is that Zach agonized over it. What do I do? Over time, he continued to get information. What do I do? He didn't want to do it. If he wanted to do it, he would have done it right away. And he told you that when he testified. He told you in detail about that day. He told you about it. About when he woke up, he drove to that location and he thought he was going to throw up. He told you about his hand shaking. He told you about when he got out and got on his bike, it was one pedal in front of the other, just trying to make it there. He told you about this, and you saw him testify. He's, contrary to what Mr. Wilkins said, he doesn't think he's a hero. He's never asked that. He did what he believed he had to do to save an innocent child. That's what he did. That's why it's more than just the action. He hasn't confessed to any crime. He told you what he did. And he told you the truth about what he did. If Mr. Wilkins talked about solving John's problem, right? And he intimated in his closing that an aspiring or starving, I can't remember what word he used, pianist would turn down $10,000. Interesting. As though to say he didn't turn it down. There's no evidence anywhere that John Mello ever paid him a dime to do this. None. You gotta watch the state, ladies and gentlemen. In the state's closing, lot of moral indignation. That, what do you mean try to be humane? Who can say that? How does that even mean, right? I was not in Zach's shoes. Nobody was in Zach's shoes but Zach. Nobody was. None of us has been in a circumstance where we have reason to believe an innocent child is being abused by her own mother, where her father is out of the country, the evidence is shown, with a warrant pending, can't come back, When you write an affidavit to try to put the authorities on notice as to what you believe is happening, when you call DSS and DSS does nothing, none of us have been presented with that circumstance. Mr. Wilkins said, we can't condone vigilante justice. That's what he said. He said, if you find him not guilty, I'm going to be out of a job. Right? It's really interesting. The state wants you to be a legislature and make decisions for the people of the state in law and order. But they don't want you to be a jury when it comes to deciding how the law applies to the facts. Because they just want you to assume he's already confessed to it, he's guilty of a crime. They use the word murder throughout, which is a legal phrase, which is an offense that you have to find. So they want you to speak for the people of the whole state, but they don't want you to really look at the evidence. And that's what we're asking for. That's just what we're asking for. Mr. Wilkins said he could have done other things. This didn't have to happen. Okay? The judge will not instruct you that Zach Hughes had a burden to exhaust all remedies, to try everything he could to do. He tried a lot. He wrote the affidavit, went to DSS, did a lot of different things. But there's absolutely no requirement. We have no burden whatsoever. Just to continue to remind you that. We have no burden whatsoever. The burden is on the state. And there's no burden whatsoever for me as Zach Hughes' representative to try to prove to you that he exhausted every remedy. That's just not what the law says, and you don't need to prove. You don't need to even consider that. The evidence is that Zach tried. And when everything failed, that's when he acted to do what he thought was right, and that is, and was, to save Aida Mello. Ladies and gentlemen, the state talked about the mailers, and I don't envy your task. I don't at all. It's a tall task. But I do think the mailers, this piece of the case is a little bit easier for you to resolve, and let me tell you why. The judge is going to tell you that for it to be harassment, a couple things have to happen. First, the person who was the target of the harassment, in this case Christina Parcell, who's alleged in the indictment, the state must prove beyond a reasonable doubt that she actually suffered mental distress, and that a reasonable person would have done so in that circumstance. But there has to be evidence that she actually suffered distress, mental distress. There is almost zero evidence that she actually experienced mental distress in this case, right? Let me talk more about that in specifics. There were at least 3 people who testified for the state who were with her when she gave the letters, those envelopes to law enforcement. At least 3 people: Brad Post, Dan Bevel, Mike Nicholson. Did any of those people testify that she was remotely upset? Any of those people say that she cried? Any of those people say that she was shaking? Any of those people say that she had made statements that led them to believe she was upset? Zero evidence that shows, or that even comes close to proving, that Christina Parcell was upset. And if anything, the evidence you've seen that has been introduced with nude photos of Christina Parcell online, with Alex Fields' affidavit, I think the evidence shows took a lot to get her upset or be in mental distress. So I would submit to you, ladies and gentlemen, on the harassment charge, that's something that you could go to initially and think about that evidence. And based on your recollection of the evidence, if you find that there's no evidence to prove beyond a reasonable doubt that she was in mental distress, then that's your answer on that charge right there. It's the state's burden of proof on each and every element. Ladies and gentlemen, in conclusion, the state has brought us here. And they brought the charges that you are to consider. They've decided what to charge, and they have brought us here on these specific charges. And the charge they brought, specifically the charge of murder, is among the most serious charges there is. Doesn't get any more serious than that. Murder, the charge of murder, in contrast to what the state's position is, requires more than the act of killing another person. It requires malice. Malice is defined, and the judge is going to define this for you, as evil, as hatred. In his opening statement, Mr. Wilkins told you an angry heart, mad. Ladies and gentlemen, I would submit to you that the evidence in this case has failed to show you that you should be firmly convinced that Zach Hughes had hatred. You can be shown pictures and talked all about the acts, but when it comes to what he was thinking, what the evidence shows that was in his heart, that evidence hasn't come close. Ladies and gentlemen, in hindsight, 3 years after this happened, it's very fair for you to say this didn't happen, or this didn't have to happen, or disagree, I wouldn't have done that. Some of you may say you would have, some of you may say you wouldn't. That's fair. Bottom line. Can't say otherwise. But no matter what your take on what he did, I think it's so important that we rely on your common sense. And that was one of the things that Mr. Wilkins talked about early on, that how important your common sense is that you bring with you. And so in closing, I'm going to ask that you use your common sense that you brought with you to the courthouse and just ask yourself, does a person who kills another person with the intent to save an innocent child, does that person have evil in their heart? Does that person have an angry heart? Ladies and gentlemen, I would suggest to you that your common sense would tell you no. And that person who killed another to save an innocent child is not a murderer. I would ask that you return a not guilty verdict. Thank you very much.
Please, court. Now the state has an opportunity to rebut, and I promise you, ladies and gentlemen, I'm going to be brief, so y'all can get to your deliberations. I do want to address a couple of issues. I want to make very clear, in this record, there is zero evidence of any kind of abuse. Not for a witness, not from any evidence. Mr. Mormon said you got to have some emotional distress from the harassment charges. Christina Parcell had a bunch of neighbors receive pictures of her without clothes on, private photos between her and John Mello. And so what did she do? Immediately, well, Brad Post corralled them all up, took some from neighbors so they didn't see them, and she went to the police. Going to the police without emotional distress, it's not something that you see very often. Mr. Mormon talked about not trying to minimize this case. Minimize the killing of Christina Parcell. Minimizing the heinousness of this crime while trying to impugn her character. He talked about malice. And he said that you got to have an angry heart. He kept referring to me. I said, an angry heart, malice. So you're mad at somebody. And I'll leave you with this. Ladies and gentlemen, regards to an angry heart, just because Zachary Hughes' heart is so cold and so dead that it can't be angry, that is not a defense. You prove it by his actions. Thank you.
Members of the jury, it is now my duty as the trial judge to instruct you on the law applicable to this case. And in that regard, it is your duty as jurors to accept and apply the law as I'm now stated to you. Furthermore, it is your exclusive duty to decide all the issues of fact in this case and determine the effect, the value, the weight, and the truth of the evidence. All the parties have the right to expect that you will carefully consider and evaluate the evidence and apply the law of the case to it so that in the end, all parties will receive a fair and an impartial trial. I remind you that during this trial, you and I have certain duties to perform. As the trial judge, it is my responsibility to preside over the trial of this case, and I also have the duty to rule on the admissibility of the evidence offered during this trial. You are to consider only the competent evidence before you. If there was any testimony ordered stricken from the record during this trial, you must disregard that testimony. And furthermore, you should not even mention or discuss any testimony that I've instructed you to disregard in the deliberation room. You are to consider only the testimony which has been presented from this witness stand, any exhibits which have been made a part of the record in this case, and any stipulations of counsel. I have the additional duty to charge you the law applicable to this case. As the presiding judge, I am the sole judge of the law of this case, and it is your duty as jurors to accept and apply the law as I now state it to you. If you already have any idea as to what the law is or what the law ought to be, and it does not agree with what I now tell you the law is, you must abandon this idea because you are sworn to accept the law and apply the law exactly as I state it to you. In every case tried in this court before a jury, the jury becomes the sole and exclusive judge of the facts in a case. A trial judge cannot intimate, state, comment on, or make any statement to a trial jury about the facts in a case. Since you, the jury, are the sole judge of the facts in this case, you are not to infer from what I have said during this process or during the progress of this trial in ruling upon the admissibility of evidence or otherwise, or anything that I say now during this course of this instruction to you, that I have any opinion about the facts in this case. The law does not allow me to have an opinion about the facts in this case. This is a matter solely for you, the jury, to determine. And as jurors, it is your duty to determine the effect, the value, the weight, and the truth of the evidence presented during this trial. The defendant is charged with the following: murder, possession of a weapon during the commission of a violent crime, burglary, first degree, conspiracy, and harassment, first degree. I remind you that the fact the defendant was arrested, charged, and indicted in this case is not evidence in this case and cannot be considered by you as evidence of guilt in this case, nor does it create any presumption or inference of guilt. These documents are simply the formal instruments which contain the charges made against the defendant. It is the formal documents by which this case is brought into this court. The indictments in this case allege several different offenses against the defendant. Each indictment charges a separate and distinct offense, and you must decide each indictment separately on the evidence and the law applicable to it, uninfluenced by your decision as to any other indictment. The defendant may be convicted or acquitted on any or all of the offenses charged. You will be asked to write a separate verdict of guilty or not guilty for each indictment. The defendant has pled not guilty to these indictments, and that plea puts the burden on the state to prove the defendant guilty. A person charged with committing a criminal offense in South Carolina is never required to prove himself innocent. I charge you that it is an important rule of the law that the defendant in a criminal trial, no matter what the seriousness of the charge may be, will always be presumed to be innocent of the crime for which the indictment was issued, unless guilt has been proven by evidence satisfying you of that guilt beyond a reasonable doubt. This presumption of innocence does not end when you begin your deliberations, but it accompanies the defendant throughout the trial until and unless you reach a verdict of guilt based on evidence satisfying you of that guilt beyond a reasonable doubt. The presumption of innocence is not mere legal theory, and it is not just a legal phrase. It is a substantial right to which every defendant is entitled unless you, the jury, are satisfied from the evidence of the defendant's guilt beyond a reasonable doubt. The state has the burden of proving the defendant guilty beyond a reasonable doubt, and some of you may have served as jurors in civil cases where you were told that it is only necessary to prove that a fact is more likely true than not true, such as by the greater weight or preponderance of the evidence. In criminal cases, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. A reasonable doubt is the kind of doubt that would make a reasonable person hesitate to act. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every possible doubt. If, based on your consideration of the evidence, you're firmly convinced that the defendant is guilty of the crime charged, you must find the defendant guilty. If, on the other hand, you think there's a real possibility that the defendant is not guilty, you must give the defendant the benefit of the doubt and find him not guilty. Facts and circumstance that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the accused. Facts in issue may be proved either by direct evidence or indirect evidence or circumstantial evidence. It is direct evidence if it proves a fact without an inference, and which in itself, if true, conclusively establishes that fact. Direct evidence is basically evidence you can see, observe, or hear with your senses. Circumstantial evidence means the proof of a chain of facts and circumstances indicating the existence of a fact. In other words, you may infer that a particular event occurred based on proof of circumstances warranting such an inference. It is not something that one observes, but from facts, one can draw a conclusion. Crimes may be proven by circumstantial evidence. The law makes no distinction between the weight or value to be given to either direct or circumstantial evidence. However, to the extent the state relies on circumstantial evidence, all of the circumstances must be consistent with each other, and when taken together, point conclusively to the guilt of the accused beyond a reasonable doubt. If these circumstances merely portray the defendant's behavior as suspicious, the proof has failed. The state has the burden of proving the defendant guilty beyond a reasonable doubt. The burden rests with the state, regardless of whether the state relies on direct evidence, circumstantial evidence, or some combination of the two. The following things are not evidence, and you must not consider them as evidence in deciding the facts of this case. 1, statements and arguments of the attorneys. 2, questions and objections of the attorney. And 3, testimony that I instruct you to disregard. While argument of counsel is a beneficial part of every trial, you should remember that the statements made by counsel are not evidence. In presenting arguments, counsel often refer to evidence. However, you should base your verdict on the evidence as you remember it. Therefore, if there are any conflicts between the recollection of counsel about the evidence and your own recollection, you should rely upon your own understanding of the evidence. Necessarily, you must determine the credibility of witnesses who have testified in this case. Credibility simply means believability. It becomes your duty as jurors to analyze and to evaluate the evidence and determine which evidence convinces you of its truth. In determining the believability of witnesses who have testified in this case, you may believe one witness over several witnesses or several witnesses over one witness. You may believe a part of the testimony of a witness and reject the remaining part of the testimony of that same witness. You may believe the testimony of a witness in its entirety or reject the testimony of a witness in its entirety. You may consider whether any witness has exhibited to you any interest, any bias, prejudice, or other motive in this case. You may also consider the appearance and manner of a witness while on the witness stand. The rules of evidence ordinarily do not permit witnesses to testify to opinions or conclusions, and an exception to this rule exists for witnesses we call expert witnesses. A witness who by education and experience has become expert in some art, science, profession, or calling may state an opinion as to relevant and material matter in which the witness claims to be an expert, and may also state the reasons for the opinion. You should consider any expert opinion received in evidence in this case, and like any other evidence, give it the weight you think it deserves. If you decide that the opinion of an expert witness is not based on sufficient education and experience, or if you conclude that the reasons given in support of the opinion are not sound, or that the opinion is outweighed by other evidence, you may disregard the opinion entirely. An expert witness's testimony is to be given no greater weight than that of other witnesses simply because the witness is an expert. Further, you are not required to accept an expert's opinion, even though it's not contradicted. There's been evidence presented that witnesses have made prior statements which are not consistent with the witness's present testimony. You may use this evidence to decide whether to believe the witness. You may also use evidence of the earlier contradictory statements to determine the truth of those statements. It is up for you to decide whether to believe the earlier statements or the testimony given at trial. If a witness is shown to have knowingly testified untruthfully concerning any material matter, you may consider this in determining whether to trust the witness's testimony as to other matters. You may reject all testimony of that witness or give all or part of the testimony the weight you think it deserves. In order to establish criminal liability, criminal intent is required. For example, the mental state required to be proven by the state for a particular crime might be purpose, intent, knowledge, recklessness, or criminal negligence. Criminal intent must be proven by the state beyond a reasonable doubt, and criminal intent is always a matter that must be determined by the jury from the circumstances surrounding the situation. There's no way to prove intent to a mathematical certainty. There's no way medical science can dissect a person's brain and determine what the person had in mind. So the law says that criminal intent may be inferred from the circumstances shown to have existed. And this is how you make a determination of whether or not the elements requiring intent was present. It is not necessary to establish intent by direct and positive evidence, but intent may be established by inference in the same way as any other fact, by taking into consideration the acts of the parties and all the facts and circumstances of the case. Criminal intent is a mental state, a conscious wrongdoing. It is up to you to determine what the defendant intended to do based on the circumstances shown to have existed. Criminal intent can arise from action or a failure to act. It may arise from negligence, recklessness, or an indifference to duty or to consequences that is considered by the law to be the equivalent of criminal intent. The defendant is charged with murder. The state must prove beyond a reasonable doubt that the defendant killed another person with malice aforethought. Malice is hatred, ill will, or hostility towards another person. It is the intentional doing of a wrongful act and with an intent to inflict an injury or under circumstances that the law will infer an evil intent. Malice aforethought does not require that malice exists for any particular length of time before the act is committed, but malice must exist in the mind of the defendant just before and at the time the act is committed. Therefore, there must be a combination of the previous evil intent and the act. Malice aforethought may be either expressed or inferred, and these terms express and inferred do not mean different kinds of malice, but merely the manner in which malice may be shown to exist. That is either by direct evidence or by inference from the facts and circumstances which are proved. Express malice is shown when a person speaks words which express hatred or ill will for another, or when the person prepared beforehand to do the act which was later accomplished. For example, any acts of preparation going to show that the deed was within the defendant's mind would be express malice. The defendant is charged with possession of a weapon during the commission of a violent crime, and the state must prove beyond a reasonable doubt that the defendant was in possession of a firearm or knife during the commission of a violent crime. A firearm means any machine gun, automatic rifle, revolver, pistol, or any weapon which is designed to or may be readily converted to expel a projectile. In order to find the defendant guilty of possession of a weapon during the commission of a violent crime, you must first find the defendant guilty of committing a violent crime. Murder is a violent crime. The state must prove beyond a reasonable doubt that the weapon furthered, advanced, or helped in the commission of the crime. The defendant is also charged with first-degree burglary. The state must first prove beyond a reasonable doubt that the defendant entered a dwelling without consent. A dwelling is any building or portion of a building in which a person ordinarily sleeps. A building is a dwelling even if the residents are temporarily absent from the building. In order to prove that the defendant entered the dwelling, the state does not have to show that the defendant's entire body entered the dwelling. The smallest entry is sufficient. It may be any part of the body, such as a hand or foot, or even an instrument, such as a hook or other instrument. In addition, the state does not have to prove that force was used to gain entry. If a person enters a building by using deception, artifice, trick, or misrepresentation to get consent to enter, this is an entry without consent. Next, the state must prove beyond a reasonable doubt that the defendant intended to commit a crime, either a felony or a misdemeanor, at the time of the entry. The mere entry into a dwelling without consent is not burglary. If the intent to commit a crime is formed after the entry, it is not burglary. On the other hand, if the defendant intended to commit a crime at the time of the entry, it is a burglary, even if the intent was abandoned after the entry. It does not matter that the intended crime was not completed. Intent may be shown by acts and conduct of the defendant and other circumstances from which you may naturally and reasonably infer intent. Finally, the state must prove beyond a reasonable doubt the existence of one of the following aggravating circumstances, such as 1, when entering while in the dwelling or in immediate flight, the defendant or an accomplice caused physical injury to anyone not participating in the crime. Or 2, when entering while in the dwelling or in immediate flight, the defendant or an accomplice used or threatened to use a dangerous object. Or 3, when entering while in the dwelling or in immediate flight, the defendant or an accomplice displayed what was or appeared to be a knife, pistol, revolver, rifle, shotgun, machine gun, or other firearm. Or 4, when entering while in the dwelling or in the immediate flight, the defendant or an accomplice was armed with a deadly weapon or explosive. A deadly weapon is any article, instrument, or substance which is likely to cause death or great bodily harm. Whether an instrument has been used as a deadly weapon depends on the facts and the circumstances of each case. The following are examples of instruments which may be deadly weapons: a pistol, a shotgun, a rifle, a dirk, a dagger, a knife, a slingshot, metal knuckles, a razor, gasoline, a firebomb, Molotov cocktail, and lighter fluid. A gun may be a deadly weapon, even if it is not operating. The defendant is charged with conspiracy. The state must prove beyond a reasonable doubt that the defendant combined with one or more persons for the purpose of committing an unlawful act or of committing a lawful act by unlawful means. There must be a mutual understanding, agreement, or common intention and plan. Mere passive knowledge of or consent to the criminal conduct of another is not enough to make a person a conspirator. There must be guilty knowledge and participation. Similarly, the mere fact that the defendant may have associated with another person or met with another person and discussed common aims and interests does not necessarily establish proof of the existence of a conspiracy or that the defendant was involved in a conspiracy. On the other hand, it is not necessary that the agreement be a formal one, that it be in writing, that the person hold a meeting and expressly state in the terms of the common plan, or that the agreement be stated in words between them. The agreement of a criminal conspiracy may come into being through an implied mutual understanding. The willful, intentional, and knowing adoption by 2 or more persons of a common plan is sufficient. No overt acts need to be shown to establish a conspiracy. A conspiracy may be shown by circumstantial evidence and the conduct of the parties. In order to convict the defendant of conspiracy, the state must prove beyond a reasonable doubt not only that the defendant knew of the unlawful conduct, but that the defendant agreed to combine with the other person for the purpose of accomplishing the unlawful conduct. The defendant is charged with harassment first degree. The state must prove beyond a reasonable doubt that the defendant engaged in a pattern of intentional, substantial, and unreasonable intrusion into the private life of a targeted person that served no legitimate purpose and caused the targeted person and would cause a reasonable person in the targeted person's position to suffer mental distress. Intentional means willful, intending the result which actually occurs, not accidentally or involuntary. Intent may be shown by acts and conduct of the defendant and other circumstances from which you may naturally and reasonably infer intent. The state may prove harassment first degree by showing that the defendant engaged in a pattern of 1, following the targeted person as the targeted person moved from location to location, 2, initiating, maintaining, or repeating visual, physical, or verbal contact after the defendant was notified that the contact was unwanted, 3, surveilling or the maintaining a presence near the targeted person's residence, place of work, school, or another place regularly occupied by the targeted person, or 4, committing vandalism and property damage. These are only examples of harassment first degree. You may find that other conduct of the defendant which caused the targeted person mental distress would be harassment first degree. A pattern means 2 or more acts occurring over a period of time, however short, evidencing a continuity of purpose. If you find the defendant not guilty of harassment first degree, you may consider whether the defendant is guilty of harassment second degree. A defendant is guilty of harassment in the second degree if the state proves beyond a reasonable doubt that the defendant engaged in a pattern of intentional, substantial, and unreasonable intrusion into the private life of the targeted person that served no legitimate purpose and caused the targeted person and would cause a reasonable person in the targeted person's position to suffer mental distress. Intentional means willful, intending the result which actually occurs, not accidentally or involuntarily. Intent may be shown by acts and conduct of the defendant and other circumstances from which you may naturally and reasonably infer intent. The state may prove harassment second degree by showing that the defendant engaged in a pattern of verbal, written, or electronic contact that is initiated, maintained, or repeated. These are only examples of harassment second degree. You may find that other conduct of the defendant which caused the targeted person mental distress would be harassment second degree. A pattern means two or more acts occurring over a period of time, however short, evidencing a continuity of purpose. Electronic contact means any transfer of signs, writings, images, sounds, data, intelligence, or information of any nature transmitted in whole or in part by any device, system, or mechanism, including, but not limited to, a wire, radio, computer, electromagnetic, photoelectric, or photo-optical system. In determining the guilt or innocence of the defendant, you cannot consider any possible penalty for any particular crime. The punishment for the crimes is a matter for me to determine and should never be considered by you in any way whatsoever in arriving at an impartial verdict as to the guilt or innocence of the defendant. Madam Foreperson, and ladies and gentlemen of the jury, I wish to express the hope that each of you will be mindful of the importance of your responsibility. You're not called upon to serve as jurors very often, and the proper performance of the duty requires each of you to reach the height of freeing your mind of all improper influences. As the presiding officer of this court, I am vitally concerned that whatever verdict you find will be the result of your going into the jury room and confining your consideration to the evidence and the law that you have heard in this courtroom, weighing it fairly and impartially, as I have every confidence you will do. Your verdict in this case cannot be based on sympathy, compassion, prejudice, or emotion, or some other consideration not found in the evidence. Remember, your verdict must be unanimous. I will now explain the verdict form and possible verdicts. There are 2 pages to the verdict form, and this will go back with you to your jury room. Once you have received that, you'll be instructed at that point to begin deliberation. There are 2 possible verdicts for each charge, which you may find in this case, and there's no significance whatsoever in the order in which I state these possible verdicts. It is simply that one must be stated first. Ladies and gentlemen, your verdict must be a unanimous one. Madam Foreperson, when the jury agrees on the verdict, you will write the verdict on this verdict form and then sign your name as Foreperson. Then knock on the jury room door and inform the bailiff that you have reached a verdict. At that time, we will receive you back into the courtroom. Madam Foreperson, if the jury has any questions, please write the questions on a piece of paper, not the verdict form, and give to the bailiff. Everyone needs to be present when deliberating. If one of you takes a restroom break, then the rest of you should pause deliberations until said person returns. I ask that you now return to your jury room, but do not begin deliberations until you are told by the clerk or the bailiff to do so. There are matters that I must discuss with the attorneys before you begin your deliberations, and if my 4 alternates will remain in the courtroom.
Right. So I started the clock 14 minutes ago, basically 15 minutes ago, because I don't think they're gonna tell us when they actually start deliberating. So I just put the clock on. So we'll go with that because that's the real time. Because obviously we are with the 15-minute delay from the courtroom. So they definitely started deliberating. So this is it. We are on verdict watch. The watch starts right here at, I want to do the calculations, but what time is it in South Carolina? My brain is like icky. We don't speak it. So 15 minutes ago was, oh man, maths, half past 3 in the afternoon. Deliberation started, let's just say. LNC verdict watch clock, it's, well, it's from now and not from when they actually started. So yeah, thank you, Paula. So that's, yeah, we'll go for by hours because they is that when they actually started deliberating, not with the 15-minute delay. Because what we're gonna do is, yeah, when I hear that there is a verdict, I'm gonna stop the clock and then we'll wait the time difference. So that's what we're gonna do, so we can have the most realistic thing possible. So that's why our clock is already at 16 minutes. But I want to talk about the defense closing for a moment, right? Because that was the most unhinged um closing ever. Because he started, right, by saying, yesterday Zachary Hughes told that he unalived Christina, but in doing that he did not tell you or admit to any crime. Okay? And I thought that I was the, not native speak English person here. By someone saying I unalived someone, you were admitting to the crime, right? I did not understand that because it's like, I'm being a bit sarcastic, but how can he say that? That by saying that he unalived someone, he did not admit to the crime? Because then he went saying that about the common sense that he says that, like, I hope you brought your common sense with you today. Huh? Okay, dude. And then it was just like, the evidence in this case has failed to show you that Zachary Hughes had hatred. Are you supposed to be helping your client, or are you supposed to be defending your client and saying that, like, he did not, or he had better reason to do it? It's like, I don't understand why. Oh, honestly, that closing, excuse me, that closing was and then the prosecutor was playing with his glasses on and off all the time. Like, that got my gears started, because that really grinded my gears, because that was very nerve-wracking to watch. And then there was at one point that he was gonna take it, but then he put it back on, and then he was gonna take it out again. I was just like, stop playing with your glasses. Like, I know sometimes it's like a nervous tick or something that they do, because it's not the first attorney, and it's definitely not going to be the last attorney we're going to be watching doing this sort of thing of putting the glasses on and off and all of that stuff. I'm sure we're going to watch many more, and we saw it with the Rush trial prosecutor, that she did exactly the same thing. But it's just annoying, and they keep doing this, and I don't like it. I mean, we did make a game out of it, but it was just, yeah, was absolutely crazy. So, oh, hang on, I just got the news that it's not verdict. Don't worry, it's not a verdict yet, but the verdict, it's gonna be in real time. So we will be getting the verdict in real time, and LNC just updated their clock to basically our time that we have, so that is absolutely fine. But yes, I'm not gonna have to hold the verdict anymore, even if we find. So no, there's not going to be any spoilers, which is awesome. It is fantastic, because I was going to say, like, ask please, not spoilers, but the verdict is going to be read in real time, and I'm celebrating because yay, that means it's like less 15 minutes of waiting time for the verdict. And apologies, my deepest apologies if you've heard Nightbot burping. My apologies, my deepest apologies. This stream is gonna be something else for the books, because I swear on it, Nightbot burps, and we might have a verdict for this crazy trial. Yay! That is gonna be one for the books. It's just crazy. What do you guys think about the closings? Did you like it? Was it pulling your hairs down? There was Woma. Oh, you're hilarious. This has been the most interesting thing ever. Sorry. Oh, Paula, thank you for understanding that. Because, yeah, I mean, I don't know, like, how sometimes this mic works, because I don't know how sensitive it is or not. But, uh, yeah, I mean, so it's just. Oh, another thing that I was just like, when the defense attorney, right, said that the victim did not suffer any mental anguish or pain, as she was booked 30 times and beaten to an aliving. What? Because um oh. So it's. Oh yeah, I imagine that case when I was trying to keep up with the counter, trying to listen to something, make note, and like pay attention to chat, and I was just like, no. It was just like a lot at the same time when they were like just going crazy for that. So it was rather interesting. So but yeah, so now we are almost half an hour mark on verdict watch. We are about 5 minutes away from that. Um shall we do parole hearings? Because I don't think there's many. Well, Judge Boyd is still on, but I don't know for sure what she's doing or she's about to go off. Yeah, her courtroom looks pretty empty. I think most. Oh no, it was hilarious. Case one, like doing that, as I was absolutely amazing. I loved it. But it's like it's giving me is giving me practice while I get very busy. So that was very, very good, and it was very entertaining as well. Um, I was gonna say we might jump to the Simonelli trial because it's out of California, so we might have to watch something. But I don't know how you guys feel about starting watching something we haven't watched. Even though yesterday, Zio watched with you guys a little bit, the case. What do you guys want to take? Do you want to jump to that one, or do you want to some parole hearings while we are waiting for verdict? I'm gonna be like scouting the internet for that, for any news, any jury questions. I think the jury questions would be live. It will bring by life. I don't know. There is no update on that, but I'm assuming so. I don't think we are gonna be on 15-minute delay anymore. I think the delay is over. Don't quote me on that though. So yeah. Um yeah, I think I'm gonna watch the Simonelli. I'm almost calling the salmonella trial. Sorry, it's not the salmonella trial. Tally. Oh, a good thing that we're not watching this one because I'm butchering um the the name for sure because it's not salmonella trial. Guys, please. It is not late, but it's been a long week and it's been I'm under the weather, so I'm allowed to say whatever. Not whatever, but pretty close. Let's just watch the trial. Oh, great. They are on break. Of course they are. Of course they are on break. It's why would they not be on break? Like why would I it's even what? Is it break or lunchtime? In that trial. What time is in Los Angeles? It is 10 to 1, so I think they might be on lunch. Yeah, because I think California takes lunch between half 12 and a half 1 of our. So let's just hear some parole boards then. Go back to the old faithful. Parole boards, but which ones do we want? Parole hearings, revocation, or let's hear about a parole hearing. That probably will do some good. Let me put just on the start of one. There we go. We've got quite a few on this one. So there we go. Make sure I'm muted now.
Good morning. Today is December the 5th, 2024. The time is 9:02, almost 9:03 in the morning. We're at the headquarters for the DOC. This is the board, the panel that's going to be hearing all of the parole requests today. My name is Steve Prater. I'll be acting as chairman. To my left is Carolyn Stapleton. To my right is Danny Barra. And the staff here, if you would introduce yourselves, please.
Jackson Thompson, Sherelle Haybright, Carla Williams.
Okay, thank y'all. And we're here today. Our first case is going to be at, let's see, Hunt Correctional. And we're going to be dealing with Mr. Raymond Calhoun. Is that correct? Are you Mr. Calhoun?
Yes, sir.
Okay. Could the staff or anybody from Hunt, would you introduce yourself, please?
Warden Tim Over, Joe Buttress, Assistant Warden.
Okay, thank y'all for accommodating us today. We appreciate it. Okay, Mr. Calhoun, today what we're going to do, I'll explain the process quickly. And the process is going to be that we're going to give you a chance to state to us why you feel like that you're deserving of a parole. And then after you get through, we'll go to your supporters that will be Zooming in. I don't know where Kimberly is, if that's a Zoom call or whatever. But anyway, we'll have Christopher Lecce, Michael Calhoun, and Kimberly Bigner. And then we will turn to the opposition, and we'll have 3 speakers and an assistant district attorney that will be speaking in opposition. And they are here at headquarters, except for the assistant district attorney who will be Zooming. Then the board will ask questions, then the board will vote. And that's how the process goes. You got any questions about that?
No, sir.
Okay, now's your chance, Mr. Calhoun, to tell us why you feel like you're deserving of a parole.
But first of all, over the 10 years of my incarceration, I'm not the same person that I used to be 10 years ago. I know I did a horrible crime, and once I came to Hunts, I involved myself as much as I can in the classes that they provide. First, I started enrolling in the sex offender class, risk management, which I completed all 4 phases. Once I finished that, I enrolled into the VOTEC class, which I have 2 certifications through Baton Rouge Community College in air conditioner and refrigeration. And NCCR, I have a certification through air conditioner refrigeration. I involved myself into the Christian community. I became a Christian in 2019. I joined the Catholic Church. I involved myself into the Catholic community. After that, I started taking all my self-help classes. I took pre-release. I took anger, living in balance, and then I'm involved with the Veterans Mentor Leadership Program that's housed here. I've been with that program for 6 years. Through that program, I learned I took several classes, including anger management, leadership skills, communication skills, relapse recovery, addiction recovery. And also through that program, I involved myself in community service through sandbagging at this facility for upcoming for the hurricanes. I get involved myself in as much as I can to better myself. And the one class that I took was most important to me is I took victim impact. I mean, what I learned in that class is what my crime did impacted my victims' family, not just emotionally, but physically, financially, and spiritually. And what I've done, I'm deeply remorse. And if I had the chance to be paroled, I would better myself in that community, continue to better myself in society, because I am not that person that I used to be 10 years ago. And I'm a changed person, sir. So thank you.
Okay, thank you for those words. We appreciate it. Now we'll move on to Mr. Christopher Leach. Christopher, would you say your last name for me, please? Christopher? You're on mute there. Try it again.
All right, there I go. I'm off. Yeah, my last name is pronounced Lease.
Okay. All right, Christopher, go ahead and tell us what you want to say.
All right, so I'm in favor.
Okay, I was gonna say before you get started, because we have so many speakers, then we divide them up the amount of time. And so if you would keep your remarks as succinct as possible.
Yes, sir. So I'm in favor of Mr. Calhoun getting released on parole. I didn't know Mr. Calhoun before he was incarcerated, but I know the man he is today. I met him at Elaine Hunt. I was incarcerated there for 10 years. And we were both involved heavily in the Catholic Community Music Association, and also the HVAC trades. If he's able to get released, and y'all grant him the opportunity for parole, I believe he'll have no trouble finding a job. I will assist him in that. I work in the refrigeration industry and have multiple contacts with different employers that can definitely facilitate in getting him a job. I'd like to see this man have a second chance. I believe in second chances, and I'm sure as Warden Hooper can attest to, second chances can be life changing, and I'm living proof of that. So I would like for Mr. Calhoun to be granted parole today, and I appreciate y'all for hearing his case today.
Okay.
That's all I got. Thank y'all.
Thank you for zooming in and saying that about your friend. Michael Calhoun. Michael Calhoun, you're next, please. Mr. Calhoun?
Good morning.
Good morning.
All right, first off, I want to tell y'all thank you for allowing me to speak on his behalf and giving him the opportunity to apply for parole. I appreciate that of y'all. Over the past 10 years, it's been pretty rough seeing him incarcerated. We've gone through as a family, a lot of stuff. Most recently, the loss of my father in May of this past year, in which it was tough, dealing with that loss without having him around with it to help deal with it. Over the past 10 years while he's been incarcerated, I've seen a change in him. He's become more active in the Catholic Church, or now he is in the Catholic Church. And he's done his classes and stuff, and visiting with him while he's been incarcerated, I can really tell a difference in him. Our mother is real sick right now as well too, so I'd like for him to be there if something was to happen to her. She's currently in a nursing home, and she's not able to visit him or see him or even speak to him right now. So it'd be really nice. I think he's a changed individual, to have him back in society, to be productive and to right the wrongs of his past. I think he's paid his debt to society. I think he's done everything that they've asked him to do while he's been incarcerated. So that's really all I got to say. I appreciate the opportunity to speak on his behalf.
Okay, Michael, thank you for zooming in and saying that about your brother. I'm sorry about your father and your mother.
Thank you, sir.
There. Kimberly Bigner.
Yes, thank you. Yes. Thank you guys for allowing me to speak. I just want to say I have known Raymond since 2006, prior to any of these troubles that he had. And just keeping in touch with him throughout his incarceration, I can say that he is definitely a better person, and he has learned from his mistakes and understands the severity of what he did and has really done what he can to do better. And I do feel that he would be great to, be released and be able to have a second chance, and be a productive member of society.
Okay, well, thank you very much, Kimberly, for talking to the board, and we'll take your comments into consideration when we get ready to vote. Thank you very much. Okay, we'll move on now to the those in opposition, and the ones in opposition that will be speaking that are here at headquarters. The first is Bailey Palmer. Would you like to speak first? Would that be okay with you? Okay, Bailey Palmer in opposition. Yes, ma'am, that'd be fine.
Mr. Raymond Calhoun, from the ages of 9 to 11, decided to anally rape me on a frequent basis, vaginally rape me on a frequent basis. Due to the vaginal rape, I now have a condition called endometriosis, which is scar tissue that grows all over my uterus. Everyone is saying that he deserves a second chance, and I don't believe that. I don't get a second chance at my innocence. I don't get a second chance at me not having nightmares when I sleep. I fight so bad in my sleep that it scares me. I wake up screaming because whenever I was asleep, I was not safe from Raymond Calhoun touching me. I would wake up to him raping me frequently. Mr. Raymond Calhoun forced alcohol down my throat, forced me to do drugs on occasion. I am 21 and it has been 10 years since he has last touched me, and I still remember it vividly. Every time I close my eyes, I get to see that all over again. My innocence being taken from me. I do not believe he deserves parole. I don't get a second chance at that. I don't get a second chance at that at university. And I'm sorry.
Yes, ma'am. Well, thank you for appearing before us. I know that's very difficult, and we appreciate it. Appreciate you being here. Okay, Miss Garrett Palmer. Mr. Garrett Palmer. Yes.
Yes, so I can see right now.
processes. I do feel that there are a lot of underlying issues and negotiations not to make. Just again, we as well, there was a place that I can get a lot of negotiating, even if he has learned about exactly what it so more time. And jail was something that was that he would actually be able to smell learning from all his mistakes and recently. So we should be and it's part of the issue.
Thank you. I know it's difficult being here, like I told you, sister, and anyway, thank you for your words. We take them very seriously, and we're sorry for anything that's occurred. Okay, Miss Layla Thompson, the mother, would you speak to us, please?
Thank you all for allowing us to speak on this. I did know Raymond before all of this happened, and I can tell you that everyone who ever met him thought that he was a great and wonderful person. And I do believe that he has that same guise on him now, that he is making these people believe that he has changed and that he can do great into the world. I don't believe it for a second. We thought he was great, and he still did these things. Anyone I believe that can do this to a child, I'm talking a 9-year-old and a 7-year-old child. My son is high function autism. He took the plea bargain for 20 years. This man should be serving life in prison for his crimes that he committed. 20 years is nothing compared to the lifetime of hurt and pain that my family is going through, our children especially. He can lie like no other. He made me believe that my children were safe with him, and I have another child with this man. Every day, we live this. Every day. And I believe 20 years, he can do that. Thank you.
Thank you, ma'am. We appreciate that very much. Okay, we have the Assistant District Attorney, 21st JDC, Matthew Belser. Is Matthew on the line?
Yes, I'm here.
Okay, yes, sir.
Thank you, members of the panel. Like I said, my name is Matthew Belser. I was the prosecutor who handled the case against Mr. Calhoun. I've been a child abuse prosecutor for 14 years now, and Mr. Calhoun's case is one of those that has always stood out to me. I know he speaks about being his faith, his Catholic faith, but one of the things that stands out to me in his comments is he makes no mention of any kind of penance. And sometimes, as a minister myself, I'm all for second chances. I do believe people can change, but I have not heard that in Mr. Calhoun's words. And sometimes the harm that has been done is too great to overcome that. And part of the penance that someone has to deal with is accepting those natural and legal consequences to their crime. As Bailey and Garrett both kind of mentioned in their statements, and I just want to say I'm very proud of them to see them have the strength to stand up, but they don't get a second chance at their childhood. That's what I'm talking about when I say that sometimes the harm is too great. And what about the help for the victims? Most of what he spoke about was his help for himself, self-help, but nothing about them. The thing that has stood out to me with Mr. Calhoun's crime is when you look at the facts of his case, the grooming process that occurred escalated very quickly from a inappropriate touching to full-blown intercourse. That happened very quickly. That was always something that stood out to me. The fact that his victims were of opposite sexes, that has always stood out to me. In addition, the manipulation that he did, because you not only saw grooming of the kids themselves, but grooming of the family and others there that were involved. And all of those things are warning signs that we pay attention to when it comes to prosecution and dealing with these kinds of crimes. All of these are warning signs to me and red flags saying this man is a predator and the state opposes his parole.
Thank you very much. And Appreciate those words. We'll take them into consideration also. For purposes of the record, Tamika White and Michelle Sparks are also in opposition, as is Ethan Cockerham, who is here with us today, although they're not going to speak. Okay, before we have our questions, and I should have done this probably after Mr. Calhoun originally spoke, but Warden, we're very interested in his behavior. I know you can't speak of the crime or what he did before he got there, but how is his behavior and attitudes and all that you and your staff have reflected on there?
Basically, like you said, he has 0 disciplinary reports since he's been here, and he is a mentor in the INVEST program. Other than that, we have nothing else to add.
Thank you, Warden. We appreciate it. We appreciate that very much. This case, although we all study them very, very diligently, all three of us, one of us leads in the questioning and votes first. In this particular case, it's me that votes. Mr. Calhoun, I appreciate all that you've done. I appreciate the fact that you've gotten close to the Lord and working so diligently with the Catholic Church and all the programming that you've been through. I've heard from the supporters, I've heard from the victim, I've read your file, and I've heard from you and the warden. So I really don't have any questions. I'll turn to my board. Do y'all have any questions? Mr. Barron, do you got any questions? Do you have any questions?
No, I'm just glad that we were able to hear from all the victims and the other side of the story concerning this, because that was very important too.
Okay, it's my turn to vote, and Mr. Calhoun, I know you're working hard and all of that, and I think you need to continue working hard. I think because of the seriousness of this case, because of the victim opposition, because of law enforcement, Attorney General, and the DA being opposed to it, I think only serving half of your sentence on such an egregious crime is not appropriate. My vote is that you be denied parole. Ms. Stapleton?
I agree with Mr. Prater. You made a plea bargain for 20 years versus the life that you would have gotten had it been charged. So you got a break on this. So my vote is to deny.
Sorry about this. So apparently there is a jury question already. I don't know if we are gonna be live for that, but there is a question from the jury on define malice. So they need more information. Is malice required for an unaliving charge? So that is the question coming out of the court. I don't know if they are gonna bring the jury out and live streaming, if we are going to be with a 15-minute delay. I was literally shutting my eyes for a little bit. I did actually fall asleep and come up with the phone buzzing, and oh my days, sorry about this. I needed a bit of a nap because this cold is not wanting to go anywhere, and definitely, yeah, they are thinking. The jury is thinking, guys. There is a question. So sorry. Before that, I was just on TikTok. Just TikTok sends me to sleep. So I don't know if they are gonna come up for it. If they're not, if they like not going live because they are already in court. So I think we're gonna be the 15 minutes behind, but we are 10 minutes away from the hour where they have started deliberating, and they already have a question about the definition of malice. So hang on, malice. So absolutely crazy. So been not at even an hour, and we've already first question. I think we are gonna have a verdict pretty soon. So apparently the judge is giving counsel the attorneys a minute to talk about it. So we will see. I think so. Wow. Yeah, I can sleep very easily. I'm still at my chair by my the computer where I am every day when I'm streaming and hanging out with you guys, and I literally can fall asleep anywhere. I even fall asleep at work in the middle of the canteen. I can just go to sleep just like that. I normally eat my breakfast, and then I just sit down on my chair, cozy and everything, and close my eyes, and I can just drift off. I can just literally go to sleep like there's nobody's business at any time, at anywhere. I can just close my eyes and just go to sleep. That's I think in a way it's a talent that I have, apparently. um but it's a very good one because, like, at work, sometimes by like 9 o'clock I'm already tired, so a nap is very well welcoming because then it gives me the strength and everything to carry on the rest of the shift. So I really like that one. Even when I was doing night shifts, I started at 10 p.m. and finish at 7 a.m. I used to take naps um during the night, so I would eat because we would have like an hour and a half break, and we I would eat in about like 10 minutes, and then the rest of the time I would just sleep. And I was sleeping like in the middle of the container with a bunch of people talking and noise and everything, and I was just asleep, like no problem whatsoever. And people were very impressed. It's like I was literally, and then the thing is, I did not even needed an alarm to wake up again when it was time to go to work. I would just wake up, so watch the times, like, okay, it's time to go. We go back and carry on working like nothing has happened. And it's like people was like, oh, how can you do that? That's like, I just can. And that was kind of what happened. Like right now I was listening to the parole hearings and everything and seeing what was going on, but at the same time I was also asleep and having aware. So we are just waiting for the jury to come back in because they have a questions, even though we already know which question, but we still want to watch and see what happens. Apparently we still, for that, we are still on a 15-minute delay, so we'll wait for that and see what happens. But for the actual verdict, apparently we will be live. There's not going to be delay on the verdict. So wow, I mean, so far everyone is in a race. Well, not really. I am not in a race at the moment. Because I've said 3 to 5. So if it is not between, so right now, I need to hang on. So there's an update. 1 second. So basically, what's gonna happen is judge is gonna bring the jury back to recharge them on unaliving and tell them yes, malice is required for an unaliving charge. So I think they are on a guilty. I mean, this gives me um an indication that they are on a guilty, right? Because if they're asking if malice is required for an aliving charge, that gives me the thing that they are on the verdict, correct? I don't know. What do you guys think? Um, Hang on. Let me read that again. My brain will bring to recharge them on aliving and tell them yes, malice is required for an aliving charge. And the question was, so define malice. Is malice required for? Okay, so yes, they have reached the thing on a murder charge, but they needed to see if there was malice. So malice is required for an aliving charge. So they just wanted the definition of malice to see if it would be included or not. So that is crazy. So right now we are just still waiting on the jury to come back. There is a question. It's not a verdict yet, but they are have a question about if they need malice to charge on an unaliving charge. So, and yes, it is necessary. So judge will bring the jury, recharge them on an unaliving, and tell them yes, the malice is required for an unaliving charge. So that's the point where we are. We are, I think, waiting. I don't know how long it was. Oh, okay. Apparently, the defense is very excited by this question. Hang on, am I thinking incorrectly? My brain is why is the defense very happy about this question? Hang on, I need to think. My brain, like, see, I had a nap. I don't know if it was a very good idea because now my brain is still asleep thinking about my nap. Or they are thinking that he did not had malice, and they don't know if they should apply on an unaliving charge. So, okay, apparently several jurors nod their heads up and down when the judge tells them that yes, malice is required for unaliving. Oh, I'm confused. I should not be doing this with my brain like this. I need Nightbot's input. 1 second. Sorry, I just need Nightbot's input or your guys' input because can you hear me now? Because I'm lost. So the the jury has a question of defining malice. Is malice required for an unaliving charge? The response from the judge is yes, malice is required for an unaliving charge. Is that good or bad for the prosecution or for the defense? So I'm just confused that because there's another person that is in the courtroom saying that the defense is very happy about this and they are nodding their heads. So I'm just that's what I was thinking, but then and the person was saying that several juries has nodding their heads up and down, like agreeing with what the judge is saying. So there is a conflict there on the malice section. So yeah. So the jury has been sent back to deliberate. So we are back at deliberations back again. So almost an hour with one question about the definition of malice. I think we're going to listen to it soon. But I don't know why would the defense be very excited about this. That's what I'm not getting at. So I'm just a bit confused. Confused.com. I don't know what that tells me. I'm absolutely like this trial, everything is confusing, like this is gonna be confusing too. Because like what I'm thinking is that they are stuck on the malice part. right? They cannot agree on the malice, and then they wanted to know because they have reached a decision on the unaliving, but malice needs either to be included or not. So yeah. Oh, I am confused. If there's an expert out there listening, please give me your input because yeah, because I just so they agree on an aliving charge, but they now need to agree on the malice part. Yeah. Yeah, exactly. That's malice, but they are not agreeing on that because several jurors were nodding their heads up and down when the judge was thinking. So they might be jurors thinking there has not been malice. What am I doing? I can Google this. Duh. So the definition of malice is the desire to harm someone ill will. So there is are stuck on this. So did the question that they have to ask themselves is, did Zachary Hughes have the intention or the desire to harm someone? Yes. That is a big fat yes. So I don't understand, why would the defense be happy with this? Oh yeah, that is definitely not self defense. I absolutely agree. Because it's like they agree on the unaliving. Now it was just the case that there was malice or not, and yes, there was malice. Oh, here we go. Now watching the jury question in live on a trial because we are at the 15 minutes behind. But I just yeah, it's exactly yeah. Exactly. He had the that intention and the desire. He planned it exactly of an aliving. So I am thinking that the jury is gonna come back soon. Um give them 10-15 minutes as well to come back. And yeah. So I'll give them 10-15 minutes to come back. And while they're doing that, I need to get it's just I think yeah. So my apologies. My brain was a little bit slow there in terms of getting the yeah the information. So I've got that. We're still waiting for sound to come through. Um I've got that one, don't I? I'm just writing down the responses that was sent. Oh, Paula, did you told me your guess for the game? I don't think I have noted down. I am so sorry. Would you mind just saying to me again, or did you do the form? Because I don't think. Because I don't think I've. Oh, oh, okay. Do you wanna? Do you wanna say it? I mean, I know it's past the deadline, but yeah. So I think we're just waiting. That's Nightbot. I forgot Nightbot. Nightbot. He said, I'm just writing on a piece of paper the guesses. So then I have 3 to 5. Guilty 2 to 4. Okay. Guilty 2 to 4. Okay, thank you. Oh, you have the same guess as case 1. Nice. And then where is it? Okay, I think they are coming in now. I don't know what's happening. I don't know if we are live, if we're not live. I've got no clue. Absolutely no clue at the moment what I've been doing. 2 hours in. Do you want, like, you can do 2 to 4, it's fine. 2 hours and 50 minutes. But yeah, okay, so that is done. I'm just writing down on a piece of paper, so when we can actually get to the time that it is, it's easier for me to look at the piece of paper. The form is good to gather the information, but then to look at it, I prefer to have on a paper. So I don't I well, I wanted to hear in a way the question, but yeah, I don't think they're gonna be deadlock. I think they're gonna be guilty. It has to be guilty. Come on, really? But to be fair, like, my guess is after the Colin Griffith case, mm, don't know. Because absolutely. Mm. It's like, no matter what Christina did or did not do, she did not deserve to go the way she did. And oh, the judge is there. Oops. I did not even see him. I was looking down and I didn't even see the judge there in the corner. And scared me. Oh my days. Oh, this is definitely a very unhinged stream. That is for sure. Um so we are just carry on waiting for this question to come in so we can carry on. I mean, we will be 15 minutes after they've asked this question, so we might almost live because the verdict is going to be called live. We don't know when is it going to be, but yeah, the verdict, but we know that the verdict when it comes in, it will be live. And I don't know what just happened there. I don't know if the feed went live, that's why it jumped. I'm gonna give them about 5 more minutes and see if anything happens. And if nothing happens, we know about the question anyway. You guys know the result of the question anyway. Because they might actually go live now and not being needed to be on the delay anymore. But we'll see. But I am still thinking that the malice question is going to be, it's not that like the defense is doubting it because they are wondering that to see if he had the desire to harm someone or not. And yeah, it's to especially increasing, yeah, wrongful intention, especially as increasing the guilt of certain offenses. So yeah. So definitely, I don't think this is good for the defense, but good for the prosecution. I don't know why the defense was so happy, but again, I am ready. But if I'm proved not wrong, and if he's not guilty, it's gonna be the second rage for the year. But we'll see. And that's the thing. So if Zach gets found not guilty by some kind of weird miracle or nightmare, if you will Mello get freed as well? So because Mello is in jail because of Zach, basically, literally, because of the testimony. So if Zach gets found out guilty, will Mello get away with it as well? Oh, here we go. I think we are gonna hear the question. No, we're just playing with the camera, going across to the witness stand, or no? We go. Here we go. I think this is the. Stop playing with the camera. Nuh-uh. Camera. Stop playing with the cameraman. It's just going backwards and forwards with the camera right now. But that's my question. So if Zach by some weird thing gets found not guilty, right? Will John Mello also be freed? I feel bad for the sister, for Christina's sister, that she might have to live with that that her sister wasn't alive, and the unaliveness got away with it. So the jury is coming in for the question, so we're just gonna listen to that.
Madam Foreperson, I've received a question from you. The question, well, it is define malice, and then the question is malice required for murder charge? And the answer is yes. Please listen as I recharge you on murder. The defendant is charged with murder, and the state must prove beyond a reasonable doubt that the defendant killed another person with malice aforethought. Malice is hatred, ill will, or hostility towards another person. It is the intentional doing of a wrongful act and with an intent to inflict an injury or under circumstances that the law will infer an evil intent. Malice aforethought does not require that malice exists for any particular length of time before the act is committed, but malice must exist in the mind of the defendant just before and at the time the act is committed. Therefore, there must be a combination of the previous evil intent and the act. Malice aforethought may be either expressed or inferred. These terms express and inferred do not mean different kinds of malice, but merely the manner in which malice may be shown to exist. That is, either by direct evidence or by inference from the facts and circumstances which are proved. Express malice is shown when a person speaks words which express hatred or ill will for another, or when the person prepared beforehand to do the act which was later accomplished. For example, any acts of preparation going to show that the deed was within the defendant's mind would be express malice. Thank you. You can return to your jury room. You can put that back in there.
Get your shit. All right, so that was the reading of what we were just been talking about. So basically, I don't know why the defense was very happy about that. So now jury is back in the deliberating. We'll carry on, listen to some parole hearings while, yeah. Well, we wait a little bit longer for the verdict to come in. I'm sure we're gonna be having a verdict quite soon. Keep your ears.
Okay, that concludes this hearing. It's 9:23 in the morning in this hearing, and we appreciate you accommodating us there, Mr. Warden.
Thank y'all.
You, we're giving your thoughts, and then the warden and his staff will give their thoughts, and then we'll move on to the board. We'll move on to the opposition and the supporters, then the board. But let's go ahead and start right now. Warden, before we do, would you introduce your staff that's there?
Yes, sir. Mr. Brady, good morning, everyone. I'm Warden Marcus Myers. Deputy Warden Stephen Bullon.
Deputy Warden Ricky Shinbear. Raven Heath Classification. Melissa Joshua Records.
Okay, well, thank you. And I think we're going to be with y'all all morning. So we appreciate you accommodating us and everything that you do to make things go smoothly or flow smoothly or whatever the word might be. Mr. Forrest, now it's your turn. You've been in jail for quite a while, and we need to know just exactly why do you think that you're deserving of being paroled?
Well, sir, to be honest with you, I don't know if I'm ready, because I'm going through a lot of things right now. I take responsibility for my wrongdoing. I take the full responsibility because I was raised with the family members of the boy I killed, Harold Sharon. And the class victim impact teaches me that to share everything I know about it, that's what I'm gonna do if I make parole. You know, teach other people not to do what I did, other children to do what I did. So, and my mama teach Sunday school and help them children too, the way I supposed to. And you know, I made a bad decision. And it cost me 30 years. I accept all the responsibility of my wrongdoing. And be a productive person in society once again. That's all I got to share.
All right, thank you, sir. We appreciate your remarks there, Mr. Forrest. Warden, would you tell us what kind of fellow he's been?
Well, Mr. Prater, as always, I conducted an interview with Donald yesterday before the hearings. You know, I like to talk to them, sit down and get a feel for them, go through their record with them, tell them the good and bad I see. And, you know, I'll be honest with you, one of my first ones. He was not very receptive to the meeting. He did not, he wasn't receptive to the recommendations I have for him, which is, you know, I believe he needs his GED. He has not accomplished that in all these years. I recommended anger management for him and he resisted that. And so, and he basically, what he just told you, he said he wasn't ready, and I agree with him. So, I mean, I don't have a whole lot to say. It doesn't seem like he's ready yet. I hope that he considers my recommendations. I hope he changes his mind, and I hope he, you know, begins a better path. But right now, I don't believe today's that day. So that's my comments.
Okay, thank you, Warden. I appreciate that. Now we'll turn to the victim to give y'all a chance to speak. You can make yours as succinct and brief as you would like, but I want you to have your data express exactly what you want to. So the first person I'm gonna call is going to be the victim's mother, Miss Darlene Drake. Miss Drake, would you tell us what's on your mind? Go to the podium and speak to us, please. Good morning.
I don't think Donald should be released. My mother used to be down. Donald used to have activities. And when Donald took my child away from me on that day, he walked past my child by. He shot my child in the chest. My child was in shit. He said, man, you tripping. And he ran.
Mr. Prater, I'm sorry, Mr. Prater, but we can't hear her very well, and I think he probably needs to hear this.
Yes, sir. Thank you for interrupting us, Warden. Staff, what can we do?
You can stay close enough.
Yes, ma'am, you can. Right, come as far right there. And we'll make ourselves, can you see it? As long as I can hear it. That's good.
My baby was at the store. He ordered a sandwich. And Donald walked past my child, walked past my child, walked past my child, walked past my child. Every time he walked past him, he shot him in the chest. And my child grabbed his chest and he said, man, you tripping. And he ran. And Donald ran behind him. And he shot my child down like a stray dog. For no reason. And to this day, it hurts. But it's so my child didn't even get a chance to see his child make his first step. Harold Jr. was on it 6-7 months when he took my baby away from me. And please, I beg of y'all, do not, please, for him not to be released. I don't think he deserved it at all. Because he did not give my child a second chance. And to this day, he have never tried to reach out to us to tell us nothing. I don't even know why he did what he did. To this day, I don't know why. He never tried to contact me or no one in my family to tell us why it happened. Even if he didn't say, he never tried to apologize at all. And it hurts. It hurts. I was in Liberia at the time. And when I got the phone call and they say who did it, I couldn't believe it for nothing in the world. Donald parents, Donald lived here and we lived here all our life. He used to be homeless. My mom used to feed him every day. My mom would feed him. And like I say, he never tried to apologize to me for reason why he took my baby. And I beg y'all, please do not release him. I think he's ready to be released.
Thank you, ma'am. I'm sorry. Sorry you had to go through that again and had to come down here and talk to us. Miss Tanisha Smith, victim's aunt.
Stand here.
Why don't you come forward? Why don't you come forward too? And before you start, let's position you where right there.
So they can see you.
Okay, is that staff? Does that look good? Yes, ma'am. Let's try that. We'll work on the optics later.
I'm Tanisha Smith. I'm Harold's paternal aunt. This has been quite a journey of life without him. Imagine I was a police officer at the time for the New Orleans Police and getting a call while I'm out protecting and serving the city of New Orleans that my nephew has been gunned down the very streets that I'm protecting. I didn't realize till this morning that I had been holding that in all that time because being a police officer, you don't always get to process things because you're right back to the same thing again, especially in a city like New Orleans. And today I realized I've been holding in that pain, that feeling of guilt that I wasn't there to protect my nephew the way I've done for other people. So I would love for you to take his mother's name and he stayed. The time that we've been without Harold is a long time. However, we still have a lifetime to go without him. And that's carrying that pain every single day. Thank you.
Thank you for your words and thank you for your service. We appreciate that. We'll take those to heart also. All right, the final person to speak is Miss Trinae Thompson. Miss Thompson, I'm probably said your name wrong, but I'm famous for that.
You did good. I'm closer there.
There you go, perfect.
I'm Harold's only sister. My mom born 3 kids. Older brother, self, and then Bird, my little brother. That day when they called and said that he had just been shot, they called right back and said he was already headed to the hospital. But I told my husband to bring me to the scene, even because I knew that he was actually just waiting for me. Because in situations, I always had his back, he always had mine. Bird was a protector, he was a loyal person, loyal to his dad, and think that Mr. Donald could give us that he won't. And he didn't give us that day. He may not even have to spend the time that he's spending if he will be honest about why he did it. Who put him up to doing it, because he's not the man who he had no reason to do it besides someone telling him to do it or paying him to do it. For whatever reason unknown. And like my mother said, she wanted answers and he never gave us that to this day. An even apology. When Mr. Donald was sentenced to time in prison, he passed my mother and us, our family, and made a statement that at least I still have my life, you know. Harsh is that to tell her, because again, he have had birthdays, he have had Christmases, he have had celebrations. And even though he's in prison, but we don't have my brother, like he's saying, he knew that. And even to have remorse to this day for that, he have not apologized for that statement that we had to live with, that he still have his life, my brother no longer have his. I do believe in redemption. I believe in second chances. But Mr. Donald made clear that he don't need that right now, because when you say that, it means that you're not redeemed. You may do that again. Your heart is bad. And I think that that he should not be released at this time. Not at this time. I do want y'all to know that my brother was the guy who just moved out of town, and he only was in town for just a day, and Mr. Donald took his life.
he was only in town to do something that was important, go to court and go back out of town. And he didn't get a chance to change his life, to do a better life for his son that he didn't get to raise. So we do ask that you would consider our family and the fact that Mr. Donald is not remorseful. As we can see, he only, want a chance to take care of what he wanted to take care of, but not give my mother the answers that she deserving of. And that is why he took my brother's life. I appreciate your time.
Thank you for your words. I know it's difficult, all of y'all coming down here and talking to us, but it's much appreciated. It's very impactful. Sorry it happened. Also with us, but not to speak, just for the record, Laurie Jerome, Gabriel Jerome, Yolanda Cardrish, and Josiah Thompson are here, but not to speak. Okay, that concludes the comments that we had. No one was for, and those were in opposition. Now, Mr. Forrest, it's time for the board. This particular yours comes before me. I studied yours as we all did, and I'm the one that's going to ask you questions. And Mr. Forrest, I got no questions. Okay. Board, do y'all have any questions?
No, I think he answered all the questions I got when he said he really didn't care.
I got a question. Why did you shoot Mr. Jerome? That seems to be what everybody wants to know, and I want to know too. Why did you shoot him?
He draw the gun on me. To shoot me.
That's not in the.
We had an argument. That morning, but that was on me. If I just kept quiet, it wouldn't have went that far. But we had an argument. It's easy to me to kill him.
Also, in the police report, it says after being shown the video, because the shooting was on video, after being shown a video of you shooting Mr. Jerome, you stated that you deserved an Academy Award for shooting the victim in such a manner. You still think you deserve an Academy Award?
I did not say that. The detective said that, not me. I ain't say nothing of a sort.
So basically, you're saying the police report is all wrong, pretty much.
Yes, it is.
Okay.
I got my statement. I gave a statement too. I took my charge. It's in writing. I should have brought it. It's in writing.
All right. That's all the questions I have.
Okay, thank you for those questions. I'm the one that leads the voting, and you'll need a unanimous vote here, but Ms. Forrest, because of the victim opposition, them coming down here and what they've said, because of your attitude, because of the warden's comments, because of the egregious nature of the crime, I'm hereby, my vote is to deny your parole.
I concur with Mr. Prater for the same reasons, but also list the prior criminal history of being a seventh offender as one of the reasons why I'm voting against you.
And I concur with both of my colleagues.
Okay. All right. I'm sorry to have to tell you this, but your parole has been denied today. The time is 9:48 a.m. on December the 5th, and this hearing is hereby concluded. And Warden will be with you in just a few minutes on another. Thank you.
Sir.
Marcus Myers, Deputy Warden Stephen Bordelon.
Deputy Warden Nikki Shinner. Raven Heath classification. Melissa Joshua records.
Okay, thank you very much for being there and for accommodating us. You are Mr. Coleman, is that right? Mr. Kevin Coleman, correct?
Yes, sir.
Okay, the way we'll conduct this morning, this is your day to have your say. And so we're going to, in just a minute, ask you why you're deserving of a chance of getting out today. And then we'll ask for the warden for his comments. Then we'll go to supporters, and I say there are none that have shown up here at headquarters or Zooming. And then we'll go for those of in opposition. And then we will have the board members ask questions and we'll make our determination. Do you understand that? It's pretty simple process. Okay, well, Mr. Coleman, I guess the question right now to ask you is for you to tell us why that you think that you are worthy of being paroled after having committed a crime.
Thank you for giving me the opportunity to be here today. I believe that I deserve a chance at being able to go home for the many changes that the prison has allowed me to have. It allowed me to find myself. It allowed me to understand who I was and the triggers that impeded me on making a lot of really bad decisions in my life. To recognize that my drug history wasn't exactly the whole true problem. It was within myself. A lot of struggles, and it was a lot. But being incarcerated really allowed me time to be able to work through a lot of family issues when I was a child and be able to understand the nature of what I did and how long it hurt, not just the victim, but so many people, including my family itself. Upon being here, I learned something about myself that I really love to give other people opportunity to learn from, not just my experience in life, but experience and knowledge and education and work ethic. Just recently, I took a course with the NCCR program to be a tutor mentor. That opened a lot of doors for me, at least personally, on how I want to be able to give back to society. We're talking with Doc that really seemed that I had an opportunity to be able to give back to the parish jails, to be able to be a part of working with those individuals that are serving sentences there, to be able to give them the knowledge and the skill set in the industry safety setting, working in the plants and working through construction. Another thing that I found was there was a time that came after my stepfather and my son's mother passed away, that it was a real eye opener for me. It was time for me to face the facts of why I was here. During COVID, they had a program here with an honor system to be able to prove why, to help you along your journey of why you're incarcerated, to give you a program that really opened the door for you to see the wrongs that you did in your life. So I was placed in living in balance. And during living in balance, it really opened my eyes to a lot of the pressures and triggers that I went through personally, which allowed me to be able to take the next step and go to Cage Your Rage and find out why I had anger issues and this and that. And then from there, I stepped in and said, you know what? It's more important, not just for me to grow as a person, but to also be that person, the right guy. And I wrote to Miss Morgan, that's over the Victim Impact Program. And I just, with a simple letter, it's time. It's time for me to face some of the wrongs that I did. And that right there was very heartfelt for me. It really expanded my idea of not just hurting one person, but the many people that it hurt, including my own personal family and friends. And I want to be able to have an opportunity to open another person's eyes and maybe give them a better opportunity in life that I troubled myself with.
Okay. Well, thank you. Appreciate those words. We'll take those into consideration also. Warden, what do you have to say about this man?
Well, Mr. Prater, as always, first and foremost, my sympathies to the victims and the families, as always. But you know, it's my job to speak on what Mr. Coleman has done here at the facility on his time being incarcerated. He's done well. He has not had a disciplinary infraction in almost 10 years, so that's impressive and a credit to him. Since his last hearing that he was denied at a couple of years ago, we recommended some things, and he's accomplished those. As he said, the Victim Impact Program, which is a very good program, a lot of certifications in our IC3 programs and educations. So, you know, he's been working towards doing the right thing. As of right now, he's on the right track. And, you know, our meeting yesterday was good. He did show remorse for his actions. And, you know, I do think the Victim Impact class helped him understand that a lot better. So he's on the right track. He's doing better.
Okay, thank you very much for that, Warden. Okay, we'll move into the opposition to his parole. We've got several people to speak. The first that we'll have is let's hear from Amber Barrett, the victim. That'd be the first place to start. Amber, I'm sorry you have to come up here and speak to us, but it's necessary and you want to. So let's see, Amber, would you step around kind of next to the post here? Just come around here and come forward. Right there now. Are you able to? Okay. You want us to shift down some?
Yeah.
Okay. Yes, ma'am. Go ahead and speak to us. Tell us what you think about this situation.
2 years ago, when I left, I found myself feeling bad for Mr. Cole. But then that just reflects the person that I am. What Mr. Coleman did to me.
All right, so there is another question coming out of court. So they are gathering troops. Let me change to the feed back again. It definitely keeps us working. I don't know if it is going to be live or not. So this is going to be confusing. So let's see what is this question now about. I'm sure we're going to get information pretty soon. So it is another question coming out, and this one probably will give us a little bit more insight of exactly what is going on. So but then that's the lesser included then, right, Toxic? Because that would make that be the lesser included on a charge, or is that the first charge as well? So here we go. Question number 2. See if there's any more information coming in. I think there's just gathering people, and so question, that's number 1. Now number 2. Question number 2. I don't know how to feel about this. Yeah, it does, doesn't it, Case One? They are struggling a little bit here. And why is the feed so weird? Let me do this. I don't know why the feed is so weird. There we go. Fixed. I don't know what could possibly be now. It's like I'm trying to update the feed as much as I can, so we know what is exactly going on live from the court. I mean, I think they're gonna bring the juries. So well, it could be, and that could be give us the basically their verdict. Oh, this thing is not live. Hang on, sorry. Um, I think we're still gonna be like in the 15 minutes, 15-minute delay. So that means when our clock shows 1 hour 55, we should hear the question live. Uh, my apologies. I tried to mute myself yeah, when I was sneezing, but I was not fast enough. Um, um, I don't know. Lesser charge. He would still be in prison for a while, right? What was the lesser? Was it man 2 or was it something else? I definitely showed malice and it was premeditating for sure. 100% agree, but because of the system and everything, even though they should not be considering, and they might be considering it, and that's what is making them not consider the malice or anything. So yeah, so we're just gonna wait a little bit, talk a little bit, and I need to ask Nightbot for something, but hang on, let me try to see if I can do this without destroying everything, which probably is not gonna happen. Hopefully everything is still working and I haven't disconnected everything just now. Give me 1 second, guys. I'll be back. Sorry, everybody. I'm back. So we don't have any information on the question yet. We're still waiting to see exactly what the question is. Second question of the day. Well, they either ask what's for dinner or they ask they can go home because it's past 5 o'clock now. It's the first day, actually. I think in this trial we have gone past 5 o'clock. Um, local time, so they might be asking to go home if they can break for the day. I mean, so it could be that we don't know, and they wanting to restart the deliberations fresh in the morning, and maybe they want to slip on it. 1 second. So they might want to be sleeping on it and just see exactly what, like, in the morning, how they feel doing at the poll, and maybe come back with a verdict. That could be it. I mean, that could be a very good possibility of how it is going. Because I don't know. There's no information yet out about what the question is. I've been refreshing X, Twitter, quite a bit just to see exactly what's going on. There's nothing. No, none of the court watchers have said anything. Could check. Uh, Yeah, so still nothing. Yeah, I was like, I get that. I mean, we could just move on, and it would be great to move on. And um, you want? Well, we had me and Nightbot had chicken curry that they did, and it was good. It was so good. The Nightbot did a very good chicken curry, which was delicious, and I am gonna have to make him. He is gonna have to make it again. Uh, so that's pretty much it. I mean, the thing is, right? I have a mini trial. We can start regardless tomorrow. I just need to check something tonight because they have finished for the day, and I just need, because it's the one that I was talking about, right? That it's that was gonna break until the until March, but I need to listen to it again just to see exactly what's going on and what's going on with that trial. But I'll do that after the we are finished for the day and see exactly what's happening in in the trial. But I guess I'm gonna keep an eye out for that. But a chicken, I don't know which sauce Nightbot used. I think Nightbot, which sauce did you use for the curry tonight?
Chicken tikka masala from Tesco.
Uh,
And,
uh,
and I used coconut milk.
so from Nightbot, he used coconut milk and chicken tikka masala sauce for the curry.
Chicken stock.
Chicken stock. I'm getting the recipe live.
And a couple of chilies.
And a couple of chilies, apparently. So that's what's the way Nightbot made the curry, and it was delicious. It was not spicy at all. It was very hot in temperature, but that's normal when you cook food. Uh, but it was a very, very nice meal, and I'm very glad. So there's still no word about this question. Is it there a secret question, or my internet's not working? Oh, is the church. Are we actually gonna listen to this live? We might be. Who? We actually might be listening to this question live for some reason. Oh, pastry for what? For oh. Question is in. So hang on, where did it go? Where did it go? Question: can you explain the difference between first degree harassment and second degree harassment? That's the question from the jury. I think that's we are live, and but we still not privy to listen to without the presence of the jury. So question number 2 is explain the difference between first. Okay, so they've moved on from the unaliving charge to the harassment charge, and that's both of the two charges, right? Between first degree harassment and second degree. So okay, so the jury's reply to it is going to bring back the jury out and read the charge on harassment to them again. So, oh, you know Tesco, Willow. Well, I can say I don't mind saying because there's a lot of them. I work at Tesco. That's the supermarket I work for. So oh, that is awesome that you know Tesco. That's so awesome. That's absolutely great. It is a really, really great job. I like it. Yeah, the harassment was that. So hang on. First degree harassment. I think, yeah, so they have Inga, we have time.
Okay, ladies and gentlemen, I received your question asking about first and second degree harassment. Harassment first degree. The defendant is charged with harassment first degree. The state must prove beyond a reasonable doubt that the defendant engaged in a pattern of intentional, substantial, and unreasonable intrusion into the private life of a targeted person that served no legitimate purpose and caused the targeted person and would cause a reasonable person in the targeted person's position to suffer mental distress. Intentional means willful, intending the result which actually occurs, not accidentally or involuntary. Intent may be shown by acts and conduct of the defendant and other circumstances from which you may naturally and reasonably infer intent. The state may prove harassment first degree by showing that the defendant engaged in a pattern of 1. Following the targeted person as the targeted person moved from location to location. 2. Initiating, maintaining, or repeating visual, physical, or verbal contact after the defendant was notified that the contact was unwanted. 3. Surveilling or the maintaining a presence near the targeted person's residence, place of work, school, or another place regularly occupied by the targeted person. Or 4. Committing vandalism and property damage. These are only examples of harassment first degree. You may find that other conduct of the defendant which caused the targeted person mental distress would be harassment first degree. A pattern means 2 or more acts occurring over a period of time, however short, evidencing a continuity of purpose. Harassment second degree. If you find the defendant not guilty of harassment first degree, you may consider whether the defendant is guilty of harassment second degree. A defendant is guilty of harassment in the second degree if the state proves beyond a reasonable doubt that the defendant engaged in a pattern of intentional, substantial, and unreasonable intrusion into the private life of a targeted person that served no legitimate purpose and caused the targeted person and would cause a reasonable person in the targeted person's position to suffer mental distress. Intentional means willful, intending the result which actually occurs, not accidentally or involuntarily. Intent may be shown by acts and conduct of the defendant and other circumstances from which you may naturally and reasonably infer intent. The state may prove harassment second degree by showing that the defendant engaged in a pattern of verbal, written, or electronic contact that is initiated, maintained, or repeated. These are only examples of harassment second degree. You may find that other conduct of the defendant which caused the targeted person mental distress would be harassment second degree. A pattern means 2 or more acts occurring over a period of time, however short, evidencing a continuity of purpose. Electronic contact means any transfer of signs, writings, images, sounds, data, intelligence, or information of any nature transmitted in whole or in part by any device, system, or mechanism, including but not limited to a wire, radio, computer, electromagnetic, photoelectric, or photo-optical system. Okay? You may return to your jury room.
All right, so the jury is back to deliberating, and I think we are only a couple minutes back to deliberating. So I think we're only a couple of minutes behind the actually live thing, so we're not that far behind of the real thing that is happening in court. So now the question, the difference between first degree harassment and second degree harassment. They wanted to know the difference. So basically the judge just read the instructions again, which gives them the explanation of such. And they're back at the deliberating. So they have appeared to move on from the unaliving charge and are now on the harassment. Sorry, I keep yawning. My apologies. So it seems, I think that's only the two charges, right? The unaliving one and the harassment one. And then obviously within those ones you have lessers, but I think that's the only two charges. Correct me if I'm wrong. So we might have a verdict pretty soon, because if they moved on kind of that quickly after the unaliving trial, that might have happened with this one, if this happened with this one. So I'm expecting maybe half an hour we could have a verdict, if that much, 15 minutes. What do you guys think? Do you think we're gonna have a verdict that quick, or are we gonna stay here a little bit longer? Are we gonna come back tomorrow? I certainly hope not, that we did not have to come back tomorrow for it. But yeah, if we have to, we will. I mean, there's no really other choice, I guess. Well, there is, but not a choice that we want to make. It's been almost 2 hours of deliberations today, and meaning that if when the clock ticks to 2 hours, there is new people that are gonna be in play for the verdict game. I am not in bed yet. No, case one. I'm gonna be here until um verdict comes, or the the jury is dismissed for the day. We are here for the long run. It is 20 past 10 at night over here, but we are here for the long run. It's okay. I am off tomorrow. I'm not working tomorrow, so I can slip in. And yes, I am off tomorrow, everybody. Thank you for the concern, but yes, I am off tomorrow. I don't work Fridays, and pretty soon I'm not going to be working Thursdays either. So that's very exciting. I can't wait for that. So yeah, no, Nightbot, I am not gonna work tomorrow, because actually I said to you guys, I have made an investment on our setup and for our stream. So I purchased a couple bits to improve the quality of our stream, and improving my comfortness in while I'm doing the stream. So because I've been struggling with my setup, right? I don't know if you guys have ever seen, but I can show you a picture of the before and the after tomorrow if the things come before the stream time. So I I have one laptop that I mainly use, where I have to literally split the screen with two things. Um, huh? Your list of favors is too long. So I have to split the screen into to be able to have the StreamYard and the YouTube and then the Google, and then I have one additional screen where I have the feed for court, and that's it. And I'm struggling in terms of like when we have the council, when I have to go to the how we do the counters that it is on screen. That is, I have too many things, and then it's complicated. So I need additional screens. But with the brand of the computer that I have, it's Mac, you only can have one additional screen. So I purchased one that is an extendable screen that gives me two screens plus the feed one. So I'm gonna have three additional screens to the one, and that I think that is gonna be perfect. And then another thing that I've been struggling is my vision, because the way that I have my computer, and because I'm using the camera that is in the computer, I have to leave the computer in a certain position. So from where I am, so I'm not like literally glued to you guys, and like you're not seeing my eyeballs. I have to be at a distance, and then I'm trying to type, but it's too far away, and then the writings on the YouTube page, it's too small, so I have to put the size up, and just for me to be able to see it better. So that doesn't work. So I need a camera that it is a bit far away, and I can put the computer a little bit closer to me, so I can actually see chat and see everything else. Because right now I'm like, I can't see what you guys are saying, and that's not good. That's not what I want. So I purchased a camera that will also follow the setup. So that is exciting. Hopefully it's a good camera. I did some investigation and reviews and all of that stuff. So fingers crossed. And then another thing was I struggled with the headphones that I have currently. I love the little, the Apple Air headphones with the wire, not the wireless, with the wire that I can connect to the soundboard. Those ones were perfect. But the ones that I had previously, they were old. They were about 5, 6 years old. So they were quite they literally needed retirement. They needed to go, and they broke and they were not working anymore. I could barely hear anything from the sound. So that was not good. So hey, happy days, Paula. So I purchased another pair of headphones of that I can get comfortable with and my ears won't hurt or anything, because the overhead ones that I've been using, first of all, they're not mine. They're Nightbot's. So, and he's been very kindful to let me use it while I'm on stream, and I appreciate it, but they are not comfortable for the length of time that I need to use it. So I need something a bit more comfortable. So yeah, it was a bit, yeah, but it will be okay because it's an investment for the future of our channel and for it. So oh, I will check it, boss. Oh, thank you very much. I appreciated this, Toxic. So, first degree unaliving, vulgarly harassment. The only lesser is the first or second degree harassment. Okay, so there's no lesser for the unaliving. Awesome, thank you very much. I just wanted to know, because if the verdict does overlaps for tomorrow or anything, I want to do some investigations on the possibilities of penalties. I know the first degree unaliving is life in prison with or without the possibility of parole. That I know. I think that's pretty much standard at the moment, knowing it. But then it's just the other ones that I was interested in knowing and doing some research. But yeah, so we are officially over 2 hours now of deliberations, and we're gonna resume watching some parole hearings while we wait for something to happen. Maybe a question, maybe a verdict. Who knows? We'll wait and find out. We'll hear for the long run.
Is a life sentence for myself. I was 16 when he drugged me in the woods and tried to take my life. I would not have made it out to the woods that day if it was not for Miss Janet to come along. Because no matter what I did, I could not break free from him. I fought him. I grabbed places and twisted. Nothing stopped him from bringing me from point A into the woods. I now have children, that my children suffer from this because I don't bring them to parks by myself. If my husband's not with me, if I don't have friends with me, I don't let my kids go outside and play with the other children because I was thrown into a world of crime. Like, it's a real thing. I'm not Mr. Coleman's first victim. And when I took the plea bargain for 40 years with no chance of early release or no chance of early parole, he stated that he was looking for a way back into prison and he was going to leave my body in the woods to be found. So he might want to get out of prison now, but what happens a few years down the road when he decides he can't cope with reality anymore and he wants back into prison? Is he going, and he thought I was 12, he did not realize I was 16. Is he going to try to take another young girl's life? And that's what I'm trying to prevent by being here.
Okay.
So that some other little girl don't have to go through the trauma that I still face today.
Thank you. I know it's hard coming down here and I appreciate your words.
And I got one tough question. Was he trying to rape you or just trying to kill you?
When he grabbed me from the back. Next thing I know, I was in the woods and he was on top of me trying to unbutton my pants.
Oh.
And I grew up with 2 older brothers. So I just need him, and all he told me, he had that nail gun in my side, and I grabbed it. He told me don't touch his shit. And then he started pulling me further in the woods by my legs, and that's when Miss Janet seen us and she yelled, and he backed away from me. That's the only reason why I got out those woods that day alive.
Okay.
Thank you so much.
Thank you. Okay, thank you, ma'am. Okay, let's hear from now, let's see, Barbara Wilkerson, the victim's mom. Or Amber's mom, I should refer to you as that, Amber's mom. Yes, ma'am.
This man, he changed my daughter. And the little girl that went out to do her little run that day, and he got her, she was never the same. Ever. We had a court date. The court date got put further up, original. That happened. She tried to kill herself. She had to go to the NOAA. She was there for, I don't know, 2 or 3 weeks. It affected my sons, my whole family. When we finally made it to court, we let her decide, but his sentence, his lawyer came and asked if we could do a plea bargain. We let her make that decision because she was old enough to do that. She's the one that had to fight for her life. And I think at first they came at us with 30 years and she said no. And then they came back at us with the 40 years and she agreed to that. And when we were in the courtroom, Judge Liljeburg said that he asked Mr. Coleman, did he understand what he was wanting to do with this plea bargain? And he said yes. He said, well, you will get no chance of early release and no chance of parole. Now, I guess laws changed or whatever, so now we have to do this. We were here it was 2 years ago in October. I understand that in jail, he's probably going to take in some programs, which is a good thing. But I also understand that a lot of times people will say things to get out of a situation so they can get free. And I feel like this man should have to serve the years that he agreed to serve to begin with. I'm afraid that if he gets out, he's going to hurt somebody else's child and ruin another family. It's what he did was not nice. And it's nothing about the whole situation is nice. My daughter's still being victimized by him through this, having to come up here like this. And she got the call in September, we had to come up here. She lost the baby. She was just found out she was pregnant and she lost the baby. Her nurse got sick. She's again probably pregnant again, so I'm hoping everything goes well. It's just a lot.
All right, thank you for coming, and likewise, just a personal note, we do get frustrated with sentencing when a judge will say that there's no chance of this parole or probation or suspension of sentence, and sure enough there is. And then we apologize that just 2 years ago you had to do this. This is not the parole board's decisions. That's the law, okay? I'm glad that y'all understand that.
Yes.
Okay, thank you for coming, and thank you for those words. Okay, we'll conclude with the remarks in opposition with Mr. Randall Meyer, who's Assistant District Attorney. Mr. Meyer, are you on the Zoom?
Yes, sir. I'm with you. Randall Meyer, Assistant DA Jefferson Parish, and thanks. We're strongly opposed to Mr. Coleman's request. As they stated, the offense occurred in 2003, and he's only served about half of that sentence. We think that's an insufficient time. The nature of this offense is very disturbing, the families are going through a lot of tough times because of what Mr. Coleman did to her. Mr. Coleman continues he's a medium custody. He's not a minimum custody, and maybe he's medium custody. There's no family support, and that's pretty concerning to me. There's nobody there that's appearing on his behalf to show any support for if he were to be released. Looking at his programs, after the last hearing, which I believe he didn't have many, if any, programming, He's taken a few programs since then, but nothing since 2022. So in the last 2 years, he's had no programming. He's had a couple of vocational certificates that I believe 6 of them that he's earned since 2022, which again we feel that is insufficient. And due to the nature of the offense, those items in a very strong victim opposition, we're also strongly opposed. Thanks.
Okay, Ms. Meyer, thank you for that very much. Now is the time that the board has a chance to ask questions. I think this is Ms. Stapleton's case to ask to begin the questioning. So I'll turn it over to her to ask.
Okay, to the victims and to Amber, I'm so glad that you came today. I know that it took a lot of courage. You pulled her in the woods, and this thing was pled down from aggravated kidnapping and habitual offender to the plea bargain of second-degree kidnapping. And so it said, everybody said that you agreed to the 40-year sentence. Is that true, sir?
Yes, ma'am.
So what do you think has changed in your life and her life that this should be a lesser sentence?
I cannot speak for the victim other than my condolences and me really hoping and praying that the things that she said while we was at court really held true. It wasn't until 2 years ago when I came up before y'all that I was really shocked. It was to be expected, but I really prayed that that wasn't to be. And it really hurt me and pained me to have to deal with that. It was a very troubling time, especially that first year after that parole hearing. But it pushed me to prove who I was and who I strove so hard for at least the last 15 years to be. I know she can never forget. My mom can't forget. I can't forget. I just ask that hopefully one day that they can forgive. That's what I asked.
Let me ask you something. I see here that you've taken classes that was living in balance. And I know, Steve, I mean, there is a sex offender class that's 4 phases. Maybe the warden can help me with this. Is that y'all's sex offender class, a living in balance?
No, ma'am, that's Living in Balance is a drug treatment program.
Okay, is there a sex offender class there?
Yes, ma'am. But since this wasn't actually a sex crime, this wasn't a crime, he really.
He didn't get to do what he intended to do by dragging her in the woods. So if it was gonna be a sex crime, he just didn't get to do it.
I mean, if it's the board's recommendation that we look at that, I mean, I will definitely take that into consideration, obviously, yes, ma'am.
I would ask you to please do that based upon what we all heard here today.
Yes, ma'am.
That's what occurred in the woods. So, I mean, I can't make you do anything. I'm just asking you to consider it for him.
Oh, we will.
So I don't have any other questions or any other comments.
No questions.
I don't have any questions either. I think it's time to vote.
Okay, so I'm going to vote to deny your parole based upon obviously victim opposition, law enforcement opposition, the violent nature of your crime. You did take a plea bargain for 40 years and you did understand what you were doing. It could have been life. So those are my reasons.
Okay, thank you.
I concur with Ms. Stapleton for the exact same and recommend to the warden that he go into all the sex offender classes before he comes back again.
All right, thank you, sir. And my vote also is to deny. And so therefore, as of this morning, your parole request is denied. The time is 10:17, still December the 5th, 2024, end of this hearing. Thank you.
Sorry, guys. Give me 1 second. I'll be right back. Sorry, I was eating, and perfect timing that I'm eating. There's a third question. So there's literally a third question in this case. So let me note down. So again, we're going through the same process as we've been for the last two questions. And yeah, so yeah, we are on the clock. I wonder now what is the question, because it's just, I think this is the question of going home. I don't know what you guys think, what they are gonna ask now. Um Sorry, all of a sudden I gotten very cold because my water bottle is cold and I went very cold for some reason. Um but yeah, so here we go. So I know it is crazy. It's like keep asking. Well, it is good that they are asking questions, but it's just keep us definitely on our toes. Can't just put the something for you guys to watch and walk away and or eat for that matter, because I was eating my Pringles and you can't eat it no more because I know case one. It's so, and apparently we're going live. We are live, which is normal because we are so used to not saying this live that here we go. But I think this one is actually if they want to go home or not. So question number 3, here we go. They, they have 30 to 35 to get a yes, they do, Paula. Yep. Oh my days. We'll see. I mean, if we love labs for tomorrow, you guys know that. Okay, question. Explain the difference between first-degree conspiracy to commit harassment and second-degree conspiracy to commit harassment. Was it not the same question we just had? So that's the question. So they definitely explain. Sorry, I'm just writing them down. First degree conspiracy. Conspiracy, harassment, and second degree. All right, what do we think? So, yeah, I will be bummed too, case one, if we have to wait until tomorrow, because I just want to get this done and dusted. He has occupied too much time and space in our heads for this, so now is hopefully we won't have. I know you told me 2 hours 50. It's getting close, Paula. So hopefully this will be quick. They will go back, sign the papers, and come back in time for you. So they have moved past the harassment to conspiracy to commit harassment. So they're going down. They are moving along pretty nicely. But in every single charge, apparently, they seem to have a question on it between the differences. And yeah, I don't think so. So it's definitely guilty. Or I don't think so. Yeah. Because otherwise they would not be on the harassment. If you would found not guilty, that would be it. It would be not guilty across the board. You are right, Paula. Actually, right? Nightbot. So I think that gives us a very pretty idea where they are. I did say earlier about the malice one that she was not good for the defense. My days. Hopefully Newt. What, my Pringles? Do I enjoy my Pringles? I can't eat my Pringles because the jury keeps asking questions. No, I'm joking. But yeah, I was like, I did told earlier that the malice and the life the malice and living was pretty telling. And as soon as they moved to harassment, I was gonna say that they yeah. Oh yeah, they literally toxic. They literally planned this out. They plan to send the pictures. They plan to the they planned it all because Zach sent the pictures in the post office in Greenville while Mello was in Italy. So definitely was planned out in advance because they resolved that issue of the locations of people. 1 second, coughing coming. My apologies. But yeah, so it's just quite interesting because I think now what's happening is the judge is hearing the questions, giving them the explanations, and then when the jury will come in, will be live because I think we are live right now. So the jury's not understanding the jury in question. Jury instructions, because all of this the judge went through the jury instructions, so either the jury instructions were very confusing, or this is a jury that needs a bit of help in understanding. So yeah, so that is question number 3. We are waiting for the how the judge is gonna read the instruction part again. So that is what is happening right now. We are just waiting on a third question and the explanation uh, on it. So we'll see. Because I think it's a case of the jury is not understanding or did not understand the instructions, because if they would have, we wouldn't come back with the third question in the essay. So oh, it's a friend. It's that's the Reddit. The our cases we follow that. It is the Reddit. Yeah, and that's the girl behind it. So that's the person behind it. Um, it's awesome. I would recommend definitely follow. Um, so yeah, so it's absolutely yeah. Third question. I think we are nearly done with the questions because I don't think there are much more charges to go through to yeah, to go through in terms of the verdict. So yeah, yeah, so we're just seeing exactly what happens now, because I think they are explaining what they are gonna say to the jury, and then we're gonna go live and just carry on. Um, yeah. So just like there's no like the people that are in court right now, they are not tweeting, so the instruction must be pretty long, or they are arguing that much about the instructions. So we're just gonna have to be a bit more patient. And yeah, it's almost at 2 hours and 25 minutes of deliberation time. Clock is still carrying on. At this point in time, everyone is still pretty much in the game. And yeah, so that is what is happening. I was eating my Pringles. My Pringles are looking at me saying, "Eat me," but I can't because I'm talking, and that would be very rude. It's already annoying when my yawns come through and I want to yawn, but I can't. That is already very annoying in happening. And there is a notification. So the judge is gonna recharge them on the conspiracy and also direct them to the verdict form. Apparently, the verdict form has that information. Who would it guess if they wouldn't read it? I don't think this obviously it's not their job. They're not lawyers. They're not well versed in the law. Well, not saying like us, but like the lawyers and the judge in this case. But they could have said that a long time ago to go to the verdict form instead of asking questions all the time. I mean, not that it's a bad thing because it's giving us a picture of where the jury is in terms of the deliberation. Because I think if they wouldn't have not said anything, we would be like a bit scared or like what's going on in terms of the deliberations. But is giving us a picture of like what they're kind of thinking of what's going on, which charge are they discussing, especially, well, not this case that has like a lot of charge like Megan Boswell had, but it gives us a way to think that they are moving on pretty quick. Oh, here we go. Pretty quick in terms of the charges. So, yeah. And we must be almost done with the deliberations if they are moving this fast and this quick on the deliberations, which is good.
Madam Foreperson, I've received your question concerning conspiracy and as it pertains to first and second harassment. Conspiracy. The defendant is charged with conspiracy. The state must prove beyond a reasonable doubt that the defendant combined with one or more persons for the purpose of committing an unlawful act or of committing a lawful act by unlawful means. There must be a mutual understanding, agreement, or common intention and plan. Mere passive knowledge of or consent to the criminal conduct of another is not enough to make a person a conspirator. There must be guilty knowledge and participation. Similarly, the mere fact that the defendant may have associated with another person or met with another person and discussed common aims and interests does not necessarily establish proof of the existence of a conspiracy or that the defendant was involved in a conspiracy. On the other hand, it is not necessary that the agreement be a formal one, that it be in writing, that the persons hold a meeting and expressly state the terms of the common plan, or that the agreement be stated in words between them. The agreement of a criminal conspiracy may come into being through an implied mutual understanding. The willful, intentional, and knowing adoption by two or more persons of a common plan is sufficient. No overt acts need to be shown to establish a conspiracy. A conspiracy may be shown by circumstantial evidence and the conduct of the parties. In order to convict the defendant of conspiracy, the state must prove beyond a reasonable doubt not only that the defendant knew of the unlawful conduct, but that the defendant agreed to combine with the other person for the purpose of accomplishing the unlawful conduct. That's the charge on conspiracy, and I would ask you to go back and then look at the verdict form for your direction. Thank you. You can go back, and if you have another question, I'm sorry, I just need to abide by procedure, okay? All right.
All right, so we might be back soon. We may be back soon with another question because they wanted to ask already another question. So we'll still go back to the hearings, but we might be back soon again with the questions. I mean, I can't even step away from the computer. So we'll go back to the hearings while we still have time. I am going to run to the facilities and I'll be right back. Hopefully we won't miss anything anyway, because I'll tell a nightbot to keep an eye out. I cannot go because they literally want to come back already for the fourth question. Oh my days. Like, I know this is so, oh my days. I need to laugh because otherwise I'm gonna cry. I agree with Banshee as well, Toxic, because I think he is guilty on our accounts. I hope they find him guilty on all accounts. They need to find him guilty. So I think we are gearing up for question number 4. I've lost my pen. Oh, it is here. It was in my pocket. like normally all my pens are. So question number 4. Well, 2 hours and a half, and we have had 4 questions so far. That's yeah, I think so. I that's what I said. Like it says, since they have now need to read the verdict form, I think they're definitely going to be within the next hour. I completely agree with you, Toxic. So while there is no movement about a 4th question, there is a possibility of a 4th question already. So we will see what it's coming out of it in just a minute to see what is the question is. Can we go home question? Because they, like, literally the 4%, they were leaving the courtroom to go back to the jury deliberation room, and they were saying, oh, I've already got a question already. And the judge was like, okay, but you have to follow the procedure. So basically sending the paper saying that they have a question or what the question is. So it's literally time for them to get back to the room, write the question, send it back out to the jury, the judge, and we will be back to the same thing of wondering what the question is, what is happening, and all the good stuff. Oh, it would be nice if I had the feed on working, wouldn't it, guys? Because like that, could be here for literally forever, and you would not listen to anything. Well, I'm gonna play some parole hearings while we wait, and we'll go from there. I'll be back very soon. I'm hoping, and I'm hoping no, I'm sure that I will. Just keep it into this part that doesn't really matters because they take forever. There you go.
Yes, sir. Good morning. How are you doing? Is your name Terrence Williams?
Yes, sir. Terrence Williams, number 487-561.
Okay. All right. Well, it's nice to see you, Mr. Williams. My name is Steve Prater. I'm the chairman of the board this morning, and we're in Baton Rouge. To my left is Carolyn Stapleton. To my right is Danny Barra. And the staff here has already introduced themselves. The staff there has introduced themselves, Warden, so we won't have to go over that again. I appreciate that. Time is 10:29 in the morning on December the 5th of 2024. Mr. Williams, what we're here to do is talk to you about your day, and I won't say court because you've been there. It's your day to tell us just exactly why you feel like that you are worthy and deserving of being paroled out of prison. And so that's what we're going to hear from you in just a minute. You got a number of supporters that we'll go over later. We'll hear from them after we hear from the warden, and then we'll hear from the opposition. You have one person in opposition, and then we will ask you some questions, then we'll make our decision. Okay, you understand that?
Sir.
Mr. Williams, tell us exactly why do you think that you're worthy and deserving of being paroled early from Raymond LaBorde Institution?
Well, foremost, I hope y'all had a good Thanksgiving. Christmas is approaching, the New Year's are approaching. I'm grateful to be alive. I'm grateful to have a sound mind, heart, spirit, body, and I'm thankful for the opportunity to address this fair, just, and honorable court. Today I shall deliver my truth. All I ask for is open-minded consideration. And at the end of this hearing, I pray that each board member determines that I'm worthy to be granted parole. You know, I'm granted this hearing pursuant to the Louisiana Legislative Act number 122, which grants me parole after serving 25 years of my sentence and upon reaching the age of 45. Parole would afford me the opportunity to continue paying my debt to society by continue to serve my sentence as a productive member of the community under supervision. I'm remorseful for the crime I committed against Ms. Jennifer Beasley. I apologize to Ms. Beasley for offending her. For financial gain, I victimized Ms. Beasley without considering the impact that it would have on her life. I never had any intent on the commission of my crime to physically harm Ms. Beasley. Nonetheless, I possessed a loaded firearm. Therefore, the potential dangers to her body was real. I'm thankful that no harm was inflicted upon Miss Beasley physically that day by my actions. Nonetheless, I understand the potential emotional, mental, spiritual, and financial impact that may have weighed on her. Sincerely hope that Ms. Beasley have found some healing from the experience I forced on her.
All right, apparently it's time for the fourth questions. I haven't heard any movement or anything, so I just decided to swap the feedback and wait on it, because don't know what is actually happening, because yeah, there is rumors of a fourth question, but I don't know if they have already handed to the judge or not. It was about 6 minutes ago, so they might have been even talking about the new explanation of the conspiracy of harassment and everything, and then just going back to it and see if they have questions. So I thought there was already, but yeah. So question number 4 is still probably in the pipelines. In the works. The question number 4, maybe. Yeah, true, but this, like, I think this is the first jury that has so many questions about the the every single charge, because 3 questions, 3 charges is just, yeah. Oh, I know. Willow is really buttering up to the parole board. We'll carry on listening to this guy,
The extent of
and then yeah, as soon as there's more movement in court, we'll go back.
my remorse runs deep. For my offense against Ms. Beasley, I committed my life to change. It's been a journey. However, my mindset is now aligned with my desires and goals. All I want to do is put some good into the world. Since information, I found out, is the foundation of intelligence, learning, survival, life, and existence, I pursued it. I've gained entrepreneurial skills, job hunting skills. I built people skills, social skills, critical thinking skills. I learned how to diffuse situations, neglect irresponsible actions, prevent conflict, solve problems. I became a better person. The information I obtained helped me gain a knowledge that enabled me to destroy the street mentality that induced my bad decision making. It says that a new creation is the initiation or beginning of a new thing, and a termination or ending of another thing. The information and instruction that I acquired from the programs, the classes, my involvement in the community, the books I've read, it helped me identify the defining experiences and influences that shape my character, the things that cause ruin to my soul. Simultaneously, that same information helped me go inside and reshape my inner dimensions and help me restore my soul.
Okay. All right. Would you kind of wrap up your remarks? I think I get the gist of it, or the gist of it, whatever the word is, and you seem like you've grown a lot.
I teach though. I teach the boxing team. I coach the boxing team. I facilitate boys to men. I facilitate Cage of Rage class. So I get to teach everything I learn, because I learn with the intent to teach. So I help out. This is what I do in this community. This is how I've grown. This is the amends I've committed to because of my actions against Ms. Beasley. because of the ignorance. You know, ignorance is a common enemy of the poverty stricken. This is where I come from. My emotions guided me. My emotions controlled me. Now I'm in control of my thoughts. I'm in control of my emotions because I'm in control of my thoughts. Now I'm in control of my actions. Images and ideals no longer guide me. I'm guided by truth and reality. I'm guided by righteousness. Because now I think righteous, I speak righteous, and I do righteous things.
Thank you, sir. Appreciate all those words. And it's almost like you're getting in teaching a class. And so I see that, but I take everything that you say to heart. And I appreciate all of that and all the growth that you've experienced. Warden, what's your comments?
Well, I told Terrence yesterday not to get out. I'm not mad at him though. He's no, I mean, look, he spelled it out for you. As you can hear, he's a good speaker. And he does. He facilitates my Boys and Men program that I created here. He's been doing that for the last couple of years, and I tell you, you know, that's been a wonderful program. It's a 6-month program. And he helps facilitate that. I listen to him on a weekly basis, you know, teaching and helping the young guys around here learn from not only their mistakes, but from his as well. He facilitates other programs. Again, good speaker, and he's learned, he's taken into account all the things that we've offered him here and absorbed it well. I hope he can apply it on the streets. I believe he can. I believe his time is coming, and he's on the right track doing the right things. So.
Okay, Warden, thank you. And his words and attitudes, a reflection on your staff too. And so we appreciate the work that y'all do. Mr. Williams, you have a number of people that are in favor of your being released on parole. They're not all going to speak, but I will let 3 of them will speak. Your son, who is there in the room with you, why don't we hear from him first? Terrence Williams Jr.
Hey, how y'all doing? I hope y'all having a great morning today. I'm here representing my father and his release of parole, grant of parole. He's been a great man in my life. I mean, a great man in a lot of people's lives that I've been able to introduce to him. I went through my struggles as a young man, 12, 13 years old, going through puberty, not having to understand and having anger issues and all. With the re-entry into my father's life at that age, he was able to guide me to be a better person and prevent me from going down a terrible path that a lot of my friends at the time did go down. And even as I've gotten older, he's been able to advise me to be better and go against anything negative in my life and try to just push positivity and stay positive. He has this thing called REAL, and what REAL stands for is re-educating love. And that's all he did for me since he's been able to be in my life, and others that I've introduced to him. From the ages of 8 years old, I've had people come talk to him and they've gotten better. I've even had people 30s, 40s come and talk to him and they've gotten better and been able to get a more positive mindset. I've seen a lot of change and growth in his life since I've been 14 years old to today, which I'm 25 years old. And thanks to him, I've seen a lot of people, including myself, go down the righteous path and do the right thing. He's helped mold me to who I am today, a hardworking young man. And if he re-enters society, he could help far more people, especially, I don't know if you guys are from Baton Rouge, but you guys know how Baton Rouge is possibly. I feel like he can make a change in that community as a whole.
Hey, Mr. Williams, thank you very much for those words, and we'll take those to heart also. And thank you for being out there to speak for your dad. All right, we'll talk to the Executive Director of Mental Health Services, who is a supporter, Miss Denise Williams. Is Denise here?
Can you hear me, sir? Yes, can you hear me, sir?
Yes, I can.
Yes. My name is Ms. Denise Williams, Executive Director of Operation Inclusion's Reentry Solutions, and having a great opportunity to meet Terrence and be able to talk to Terrence and being able to connect with him as an
Verdict is in, guys. Verdict is here. All right, all right, all right. So after 2 hours and 44 minutes on the clock, we have a verdict in the in the secrets and rose petal petal trial, whatever you want to call. We have a verdict. We are expected to be live for the verdict. It is the moment of truth. So far there is a lot of possibility of winners, and that would be the possibility. I'm saying possibility because I need to wait for the confirmation of the verdict. Time right now in terms of possibility of winners is Toxic, Lewis, Case One, and Willow. Nightbot is out. I am out. TCA out, so basically good. So right now it's, yeah. I'm so sorry, Paula. You were so close as well. I'm so sorry. So yeah, night. But you were 3 hours to 5 hours. The verdict was 2 hours and 45 minutes. So right now, those in play is Toxic, Lois, and Willow, and Case One. So if they guilty, you all are gonna be winners. So yeah, you were 1 to 3 hours on the Google form. Yes, that's what I've put down. Yeah, so that is still between the range, so that is, yeah. So it's so our cases we follow, we do a game in here in the channel that is the verdict game, that you get to guess the verdict, if guilty, not guilty, hung, or, and then the range of the time of the deliberations, and then you could put your form in or your guess in and you might win a prize. So yeah, maybe not. This while like on the Google form, I put the range of time. There's more possibilities of winning in terms if you put the range, because I want someone to win. That's the goal. I want someone to be able to win. That's why you can do the range of the time. So yeah, but the charges. Hang on, I have it. I have it. Give me 1 second to grab them. So first degree unaliving, burglary, and harassment, and the pew pew charge. So I'll put it there. So I know, I did see it, Paul. I'm so sorry. Maybe next trial. Hopefully, fingers crossed. It's, yeah. So yeah, so verdict should be read any moment now because we are live. um so we are going to be live for the read of this verdict. So yeah, I really hope there is guilty, because everything that is said so far, it sounds guilty. And I think Toxic or Banshee called it, because I remember you saying something, or he say something, that they were gonna come back really quick, and the judge is here. The judge is here, guys. I'm so excited.
Actually, hold on.
Here we go. Here we go.
Before the jury gets in here and the verdict's read, I say this in every trial, that there are a lot of emotions. And I would just ask right now, if you cannot control your emotions, I'm going to give you an opportunity to leave. Otherwise, you're more than welcome to stay. But I just, for everybody involved, please control your emotions. Okay? If anybody needs to leave, they can. All right, bring the jury.
Here we go. Just saying very quickly, I literally have my tweet ready saying that Zachary Hughes found guilty on all charges, ready to post as soon as they read it. I'm that confident that look at that, all that support. I think that's the family of Zach Hughes, the one behind the older gentleman. So it's yeah, maybe yeah. I am so nervous. I don't know why I'm nervous. Here we go, guys. Please let not be a Colin Griffith 2.0. I'm not ready for that.
Madam Foreperson, I understand that you have a verdict. If you can please hand it to the bailiff. Madam Clerk, please read this post.
Your Honor, these are case numbers 2024 GS 23 2194, 5425A, 5413, 5412. As to the charge of murder, we, the jury, find the defendant guilty. As to the charge of possession of a weapon during the commission of a violent crime, we, the jury, find the defendant guilty. As to the charge of burglary first degree, we, the jury, find the defendant guilty. As to the charge of harassment first degree, we, the jury, find the defendant not guilty. As to the charge of harassment second degree, we, the jury, find the defendant guilty. As to the charge of conspiracy to commit harassment first degree, we, the jury, find the defendant not guilty. As to the charge of conspiracy to commit harassment second degree, we, the jury, find the defendant guilty. Signed by our foreperson. Ladies and gentlemen, if this is a verdict you reached in your deliberation room and this is still your verdict now, please raise your right hand. Thank you.
Anything from the state? No?
Nothing from the state. Nothing as relates to the jury.
Okay. Ladies and gentlemen, I've told you this before, and on behalf of the state of South Carolina and Greenville County, I want to thank you for all of your service for the last 2 weeks. I know this has demanded a lot from you. You all have been extremely attentive. I know that this has not been easy. I'm going to ask you now if you will go back to the jury room, and I will be back there in just a moment to talk to you, okay?
Yes, sir.
Okay. You take these minutes.
Your Honor, at this time, I would just make a request that sentencing be deferred to give defense counsel more of an opportunity to present mitigation.
State.
Your Honor, we would oppose that request. We would ask that you would proceed with sentencing.
I'm going to give 15 minutes. Fill out them copy the sentencing sheets. Do you feel like you need a little bit more? But I'm going to sentence them within the next 30 minutes.
Thank you, Your Honor. The other thing I would, on behalf of the jury, for reasons articulated specifically that the state did not produce sufficient evidence on each and every one of the elements of the offenses for District Hughes, you for that reason.
Okay, and your motion is denied, you're protected on the record. The only other thing that I need to do is just, and I had discussed this with counsel, as far as the verdict form up at the top, it just needs to be amended to read, 2022 GS 23002194, and then it will be 2024 5425A, 2024 5413, and 2024 5412. I just wanted to make sure that that was on the record. It was just just more of a typographical, the four instead of the two.
Yes, sir. Yes, sir. We have no objection. No objection. Yeah.
What? And I'll just write on here. Thank you. All right, we'll be back in 30 minutes, 15 minutes.
50 minutes. We got it.
Okay, all right.
All right. So we've got here, so recap of the charges. Charge 1, guilty for unaliving. Count 2, guilty for the weapons. Count 3, guilty for the burglary. Count 4, not guilty first degree harassment, guilty second degree harassment. They went with the lesser. If count 6, not guilty on first degree conspiracy to commit the harassment, they went with the lesser on guilty of second degree conspiracy to commit harassment. Zachary Hughes is facing life with without the possibility of parole or with the possibility of parole. So apparently we are going to straight to sentencing. Yet again, and then we'll be done with Zach for a good time. So he thought he was gonna get not guilty. He thought that his excuse of unaliving someone was justified. I feel bad for the family. It is very sad, but at least justice for Christina Parcell was served. Even though maybe some people think that it was not due because of everything that has happened, but it doesn't justify the act. So that I think what is it here is the family of Zach, and I know it is very sad. It is heartbreaking. There's no winners in this whole situation. Um, so there's definitely no winners. It's not a win-win situation, but at least there is some justice for the victim, even though the victim might have not been the perfect victim. No one is perfect. So um so yeah. So it's very sad. So Zach is facing life at the moment, with or without the possibility of parole. But because he doesn't has, I don't think, any priors, it might be just life with the possibility of parole after a certain time. So we are just waiting for that. We'll follow through to the end. Even though it is 11:30. So now talking about something else. Toxic, Lois, K-Swan, and Willow. You all have won the verdict game. The punishment game with the judgment game, like Nightbot calls it. If you want to claim it your prize, just reach out to me. You can either do by email, DMs on Discord, or my email will be on the chat for those who want to reach out by email, and we can talk about things. If you do it tonight, I actually can kind of put it on the post tomorrow. So let me know. But just drop if you want to, obviously. There was no question for, I had to drop it down. I have the times because now I can update our lovely spreadsheet. Because we are doing a spreadsheet of all the cases that we are following in the channel, keeping it all that information on it. And before I lose the information, I better write it down while we're waiting. How long was the break? Did anyone notice? And I cannot find the folder. Because I didn't. Was it 10-15 minutes that we are waiting? So now I need to write that it was a criminal case. He got found guilty. And we will know probably the sentencing today. As yeah, thanks. Like, okay. And the deliberation times was 2 hours and 44 minutes. It gives us an average of an average of verdict watch of 6 hours and 1 minute for all the cases we have followed so far in this year. And the state case was what? 6 days? Yeah, 5 days. 5 days. And then the case of the defense was 1 day. So back. Oh yes. He has a hearing, I've heard, Toxic, on the 25th of April. I think, I'm assuming. I think it was 25th of April that he has. So yeah, so there is it. That's almost the end of the Zachary Hughes case. I mean, it's pretty wild. Yeah, 15 minutes the sentencing it's gonna be. So we gonna know what he's facing life with with or without the possibility of parole, and plus whatever he gets for the other charges, plus 6 months, because don't forget he has 6 months to serve for the contempt to court that he did throughout the trial. So he's gonna have to serve that too. So yeah, so 15 minutes from whenever they broke, which, because now we are live, and I don't think we're gonna have the jury anymore. Yeah, exactly. But because the thing is, Toxic, I don't think he needs any PSI, the pre-sentencing investigation, because he is a first time offender, and doesn't has any prior bad acts. So I think it's pretty much straightforward, and I think the judge, considering and everything, it's gonna give him life with the possibility of parole. Let me know what you think. uh what you guys think, of the what the possible sentence here, because I think it's life, first degree unaliving. Let me google first degree unaliving in South Carolina sentence. I think is life. Yeah. Okay. Oh, I don't think the unaliving penalty is in it, but yeah, so it's life with or without the possibility of parole. The minimum sentence would be 30 years. So yeah, so after 30 years, Zach might have the possibility of parole. I think that's what the judge is going to go for, because I don't see him giving a life without the possibility of parole, considering considering yeah. sorry, one second, getting a tweet saying that the jury has been dismissed, so they are free to go about to their lives. So 4 of the deliberating jurors have come back and sat on the gallery in the back row to watch the sentencing. So there's 4 of them that wants to know exactly how they end up this whole situation. So sorry, just dealing with something. Lois! Oh, Lois! Did you see the verdict, Lois? I did not have a way to reach you. We have a verdict. We are waiting for sentencing, girl. So, welcome back. You missed it. I mean, you can see in the screen that we are waiting for sentencing. So, all right, it's fine. I can read to you the charges. Let me go grab them again. So, yes, it was guilty, Lois. So guilty on the first of the unaliving, guilty on the weapons, guilty on the burglary, not guilty on the first degree harassment. They went with the lesser, so it was guilty on the second degree harassment. Not guilty on a first degree conspiracy to commit harassment. Again, they went with the lesser. On a second degree conspiracy to commit harassment, they found them guilty. So basically, guilty across the board with 2 lessers on the harassment charges. So now we are waiting on the judge to come back, and and then we're gonna go with sentencing, and he's facing life with the possibility of parole, which after 30 years he will be eligible to parole, or life without the possibility of parole. Yeah, guilty 5 out of 7 with 2 lessers included. So, and then he has all the other charges, but basically it's the life without the possibility of parole. Oh no, I am so sorry. I hope your daughter was safe though, and like to go to the train station and everything. But I'm sorry. That's yeah, I know. But and by the way, congratulations, you won as well on a verdict game. So you um so you, a toxic, Case Swan, and Willow all won the verdict game. So yeah, it's pretty impressive. We've had 1, 2, 3, 4 people winning the game, which is awesome. So now we are just waiting on the judge to come back, because he went to dismiss the jury, and then he when is going to come back. I'm having a bit of a break and come back in 15 minutes at the time. Apparently 4 of the juries that have been dismissed came back into the gallery to see the sentencing. So yeah, we know when the chicken dinner. Well done, congratulations to everyone that has won. It is really fun to do this with you. It kind of gives us a little bit, takes away a little bit of the heaviness of the subject. And yeah, so we are just waiting, but give your guesses about the possibility of the verdict. Sorry, just dealing with something. One second. So yeah, so now we're just waiting for the sentencing. I don't think it's gonna have any it doesn't I don't think they're gonna do a PSI, a pre-sentencing investigation, because the simple fact that he doesn't have has a criminal history, and is been in jail all this time. So yeah. So I was just been texting with Toxic. She has decided, I hope Paul is still here, that she is gonna give to you, Paul, her gift prize. So I will be in touch with you, Paula, about it, and I'll be in touch with everybody as soon as the stream is finished or in the morning. I will be in touch to just see how you guys would like me to send the price. Obviously, the price, as Nightbot I've already said, is the stickers that we have for this channel, and yeah. Oh no, we're still gonna carry on here, Lois. We are not going anywhere. We're still watching the sentencing. I mean, if you're going, sleep well as well, darling. But we are still carry on, strong, and I'm not going anywhere. We still have the sentencing to go through. We need to finish. We are gonna finish Zach. But tomorrow, I am gonna see about that trial. We might start a new trial that there is out there that I am keeping my eyes on. Then it's already going on day 3, but I think it's only gonna be a 3-day trial. So yeah, Paula, so I'm gonna get in touch with you. So ooh, Lois, are you sharing? If you got enough to share with the whole class? Because now I want some Reese's cup dessert. Oh. I want some too. So there's a possibility of a new trial starting tomorrow. Well, it already started, but we can catch up because it's been a rather quick trial, and we can skip breaks and lunches and all of that. But there is a possibility of another trial starting on Monday, right? And that one, I still need to do a lot of more investigation. Oh, he still have me on the big screen! Yay! So apparently, by the court documents, Lori Vallow's trial starts Monday. Apparently, by what the court says. I still have to investigate that. If Toxic is here, please let me know. If I can confirm that she is actually starting on Monday, I might hold off on this one and just to do the Lori Vallow on Monday and maybe take the day off tomorrow. But I don't know. So I need to find a way if Toxic is still here to confirm if he can confirm that the Laurie Daybell the Laurie I can't even say her name. Laurie Daybell Vallow or Vallow Daybell or whatever she wants to be called. I think her trial starts on Monday. I'm sorry, I'm just texting Toxic to see if she can find that, because if it is starting Monday, we'll hold off and definitely go for that one. If not, we'll do something else. So there's always something going on. There's always a trial to watch. So, ooh, tomato soup and grilled cheese for dinner tonight. That is definitely the best decision. I just say vomit. Oh, Lois, I'm like, it's like 20 to midnight here. I have been awake since 4:15 in the morning. I think I'm going a little bit delulu, but I am okay. I don't know why am I stuck on the on the parole hearings. Paula, I don't do fancy either. I like comfort food above it almost anything else. Comfort food, it's the best type of food ever. So yes, I would call that a toasty. Oh, Lois, you crack me. Like I will definitely call that a toasty for sure. Well, there is a bunch of possibilities. There is Laurie Day Vallow if she actually starts on Monday, and then there's a small little trial in Florida. I prefer not fancy too, because I can just, be myself and not having to pretend that I'm something that I'm not. And and there's another little trial that it might be a little bit more harsh, out of Tampa Bay, Florida, that is about, sadly, an animal cruelty. I can't even say that word. Animal cruelty trial. It caught my attention, but I've have 2 days, literally 2 days, because it started on Wednesday. This trial, yes, because today is Thursday. Today is day 2. So, yeah. So is that confirmed that Lori Vallow starts on Monday? Below. Because if she starts on Monday, we might do something small tomorrow. Might I just take the day off tomorrow, and we'll start with the bang on Monday with Lori Vallow, Daybell. So, I don't, because it's like, I don't want to start the trial and then stop it to go to Lori. I can't even say her name anymore. Vomit. Um, and then we wonder about it. It's just, if there was a way to confirm. Yeah. Well, I am having the weekend off anyway, because I wanted to work on the Lucille B case. And that is definitely my plans for Saturday, because Nightbot has a game of what he does. So he's not gonna be around, he's gonna be with his friend, which is absolutely fine. So I'm gonna have the day for myself. What I was gonna plan, it was to do a little bit of the Lucy Letby case investigation thing that I'm doing, and then do just play video games for the afternoon. Nightbot is working tomorrow. He's abandoning me. So it's not even gonna, like, if I take a day off tomorrow, I have to clean. No, I'm joking. That's absolutely joking, of course. But I don't know. We'll see. We'll see what happens. Not gonna lie, I could just binge watch my show. But to be fair, I don't have many episodes left on my show. I would have to find a new show to binge watch. I'm sure that is not a very hard thing to find. If you have any recommendations, by the way, of shows, that would be great, because the one that I'm currently watching, I have like, oh, that sounds interesting. I have like a season left, and I don't know if they are gonna do any new episodes. So right now I'm watching Scandal. The TV show Scandal. I'm watching several. So I'm watching Scandal because I'm like catching up on that one. Because the thing is, I am very impatient to wait every week for a new episode. So what I do is I go through phases where I binge watch the show, and then I leave it for a little bit so a few episodes comes out, and then I can just watch the binge watch the episodes. So because my patience is small. Ooh, really? So that's one of the shows that I'm watching. Another show that I'm watching that is actually quite recent. I don't know if you heard about, it's Hypertension. I don't know which network is on. But that show is amazing. I absolutely love High Potential. I am just gutted that they just had a break now. It was the season finale, I think, and they are between seasons, and that's gonna take a while now to come back again. But that show, it's really really good. Like, it hooked me up from, oh, Ozark. I've heard about that one. I might have a look into it, but I am definitely looking for a new show, because that's when, for example, I'm doing like my researches and everything, and I don't have any creative video or VOD or anything to catch up on. I watch my show, which lately I actually been very good. in terms that I've been up to date with my creative content, up to date. But I am sure I'm gonna find someone new, and I'm gonna fall behind, and then I'm gonna obsess with that person and just watch all of it, because that's what I do. I literally went through. I'll go through phases that when I don't have anything to watch and I don't want to watch a show or anything, I literally go to the farthest back that I can on a creator, and I just binge watch old videos, new videos, just something in the background. Um, I will put Ozark on top of my list. It will go definitely on top of it, and I will check it out. Hopefully, maybe tomorrow, if I do have the day off. If I decide to take the day off, we'll see what happens. But the court is still not back yet. It's been more than 15 minutes, right? Oh, me complaining. Oh, it's been 30 minutes. I'm gonna put something early.
Council approach.
Wow, the first time that we're watching a council approach. So apparently, Zach, when was getting into the courtroom for the sentencing, he entered. He looked at his parents and said, "Thank you." Thank you for what? Okay, that was weird. That's the first approach we see, guys. It's interesting. Now we were watching approaches, and I still don't know why I have the water bottle still with me, because this is more cold than I don't know. Okay, here we go.
Okay, I'll hear from the state.
Thank you, Your Honor. Please court. We're prepared for sentencing. So we're here for today. You've heard a long 2-week trial. You've heard the actions of the defendants. You've seen the extreme violence in this particular case. Calculated the premeditation. The jury's found him guilty. Your Honor, the state will be requesting a life sentence for the murder and for the burglary first charges. But before you switch over to the defense, I have Christina Parcell here who would like to address the court, which is the sister of Christina Parcell.
Thank you, Ms. Parcell.
Thank you, Your Honor. I will apologize in advance. I didn't expect to actually reach this point today. This is my second victim statement in 24 hours. Yesterday was reliving the 2 worst days of my life.
between hearing the step-by-step account of my sister's murder, Mr. Mello's 2 new charges, his bond hearing, and my niece being put into emergency protective care again. So I am exhausted, and I'm going to do my best to express myself appropriately. So with your honors, leniency, just give me a bit of grace. My understanding is this conversation is with you. This isn't with the defendant. This is not with counsel. This is not with the gallery. So this is a conversation with you. And I've had 3 years to try to articulate how this has impacted me, and I still have yet to find the words, and it won't happen tonight either. So I've decided instead to talk about what logically should be taken into consideration for any sentencing, which is remorse, rehabilitation, and recidivism. This defendant sat on that stand with full disregard for the authority of the law when it came to his actions outside of this courtroom, and blatant disregard for the authority of law inside this courtroom. He recounted step by step in excruciating detail everything he did. And if I may paraphrase the defense counsel's closing statement, did he cry? Did he shake? Did he look visibly distressed? He said the word repulsed, but did he once look repulsed? He said the word vomited. Did he ever once look nauseated as he described dragging my sister through my living room? Cold doesn't begin to describe the lack of emotion. And if I may be blunt, if we're going to argue somebody has to have malice and hate in their heart to be capable of murder, then one could also argue that anyone medically diagnosed as antisocial personality disorder is therefore not capable of committing murder. I think that is a logical fallacy, is asinine. In the fact that I'm tired, I will no longer go down that, but there has been no remorse once shown by this defendant in this courtroom. Without remorse, you cannot have rehabilitation. Rehabilitation requires acknowledgement that I have done a wrong, I have a debt to pay, and I can improve to become a better member of society. It begins with remorse. Without remorse, there is no rehabilitation. Without remorse, without rehabilitation, you have recidivism. This man, no, I'm sorry, this defendant wanted to kill someone. He joined the Marines, specifically the infantry. He wanted to kill someone. He was given a target on a silver platter. He was given an address, a date, a time, and he planned it. Because he knew that if he planned it just enough, he would never get caught. He planned it so much that he thought, well, even when I got caught, I got this. I can still get out of this. Without remorse, without rehabilitation, any person that goes through that effort to commit a murder would absolutely do it again to see if they could. You're left with either two options. Either he is a weak, easily manipulated man who would kill anybody that anyone asked him to, or he's not a weak and easily manipulated man. And if that's the case, then he absolutely would do this again to see if he's smart enough this time to see if he can beat it this time, because he has shown no respect for the law of this courtroom. The only thing that I will say about this situation overall is that all of these men did nothing but use my sister. John Mello used her to create a whole new family when he had a wife and children already. Brad Post used her. This defendant used her. All of them used her for their own twisted personal gratification. He would do it again. Without remorse, without rehabilitation, you will have recidivism. Thank you, Your Honor.
Thank you, ma'am. Anybody else in the state? Okay. Defense.
Your Honor, may it please the court, Your Honor's presided over this trial. Your Honor is aware of the evidence that was presented at the trial. Your Honor is also aware of the evidence that was proffered. We do believe that could go to mitigation, so we would ask Your Honor to consider that very carefully. Zach has no prior criminal history, and he stands ready for sentencing. Your Honor, I would ask for Mr. David Hughes, Zach's father, to have the opportunity to address the court briefly.
Just stand right there.
Thank you, Your Honor, for the opportunity to speak a few words on my son's behalf. The trial is over. A verdict's been rendered, and we accept that. What I want to speak to, because I understand this is the sentencing phase of the trial, where you have some parameter of your sentence. My son is probably, in my lifetime, and I've run into some pretty amazing people, and this is going to be seen as a bias from the father, but he has got such a strong moral compass and fortitude and desire for the truth in his life than really anyone I've ever met. He actually eclipses a lot of those things that I aspire to myself. It's what makes his music so incredibly meaningful, because as a musician, and there are some world-class musicians sitting here today, colleagues of Zach's, what makes a musician's art come through is what's the essence of who they are. It's not something you can fake. When you hear it, you know it's a fake. When you hear music that causes people in a room to weep, you know it's coming from something inside that person that you cannot describe. Zach was not born with a silver spoon in his mouth. I want to tell you that. I taught all my children, Zach being the oldest, the value of hard work. He might have been the only person at Juilliard to show up without manicured fingernails and calluses instead. He worked hard. I pushed him hard. Fathers and parents tend to do that with their firstborn child. And maybe I pushed him, a little hard at times, but it made him the man he is today. I want to address something, and Mr. Wilkins,
Just address the whole thing.
that Zach is a cold-blooded killer. I am sorry. Zach wrote his mother and I a letter delivered to us through his attorneys approximately a month ago. In that letter, he described basically what he did in that chair over there, only in a little more detail. Why he did what he had to do, what he felt he had to do. You heard him say in that chair, he wasn't going to go on a cruise ship to Bora Bora, where he was headed, and look at himself in the mirror at night after playing beautiful classical music for rich people. He couldn't do that. Zach has been brutally honest in his life. So much, sometimes to the detriment of his own career. Everybody in the piano world wants to be a soloist with an orchestra, but it's a very small amount of room on the head of that pin, and that's where he was headed. But he had people in his life, donors, rich benefactors, who made demands of him artistically in exchange for their financial benefit, and he walked away from it to the detriment of his own career. Why do I bring that up? He has such a strong moral compass and a desire for the truth that sometimes he actually hurts himself. His friends here, all these people in this courtroom for the last 2 weeks have been here day in, day out, some as far as from Seattle, Washington. They're here because they grew up with Zach in the music world, and they saw something in him they didn't see in anybody else. He has got a loyal circle of friends that I never had. I told my kids when they grew up, if you, at the end of your life, you end up with 2 or 3 people in your hand that are really there for you, that's the guy I want in the foxhole with me. Consider yourself lucky. Zach's got a dozen of those. Why? Bettina, I'm sorry for your loss. I'm not supposed to mention her name. I'm sorry. But I want you to know, Zach had felt compelled to do what he did because of what he would quote Edmund Burke on this. The only thing necessary for evil to prosper is for good men to do nothing. Okay. His desire for the truth and his truthful telling of what happened. I mean, he sat there and he didn't hold anything back that would benefit his portrayal to this court. He's just as brutally honest with himself as he is with other people. He has no criminal record whatsoever before this event. The only thing I know of is an outstanding traffic ticket in Italy. Somehow he rang up when he was there with Mello. And several of the guards in the detention center, where he's been for 3 years, he's been an exemplary inmate, have told him that they were going to come to this trial to support him. When you gain the silent respect of law enforcement officers, they see something in you, they see it all. And they see a guy that's respectful for 3 years without a single incident. I think that counts for something. So I'm just here, I'll wrap it up. As you determine your sentencing, I would ask you to consider what type of man he is. And take that into consideration. I love my son. I'm proud of my son. Thank you, Your Honor.
Anything else you say?
No, Your Honor. Yeah, just for the purpose of the record, I don't, would Your Honor want to inquire Zach as to whether or not he wishes to speak?
That is up to you. I'm sorry, I thought that you had indicated
I'm
that.
done. He does not wish to speak. I just want to put that on record.
Okay. Zachary David Hughes, indictment 2022 GS 2302194, indictment for murder. You're to be committed to the State Department of Corrections for life. Indictment 2022 GS 2302194. You're to be committed to the South Carolina Department of Corrections for 5 years. That is to run concurrent. Indictment 2024 GS 2305425A for burglary first degree to run concurrent is for you to be committed to the South Carolina Department of Corrections for life. The other two indictments, 2024 GS 2305413 for conspiracy to commit harassment second degree is 30 days time served. Indictment 2024 GS 2305412, harassment second degree, 30 days time served. You'll be dismissed.
Thank you, Your Honor.
All right, so that's an end. So goodbye, Zach. He is been sentenced to life and plus 6 months because of the contempt charge. So that's it. Don't let the door hit you on your way out. Well said. And it is an end to this. It's a very sad for the family, for the it's very sad for everyone, for Zach's family, for the victim's family, for the whole area, the case. It's a very sad case, but no matter what Christina did or did not do in her life, she did not um deserve to go this way. She did not deserve. She should have faced justice for her actions and for her mistakes and everything. She should have faced the consequences of that and not go like this. And yeah, so now definitely, Zio, you're gonna have to watch the Mellow Guy. For sure, we are gonna be here for that. Talking about that statement, that is just sorry, I don't think it was inappropriate, but anyway, it's done and dusted. It's gone now. Now obviously now that hey Pickles, hey you, I see you, hello Pickles. Yeah, you were slightly late to the party. They are already celebrating. No, I'm joking, they're not celebrating. You made it, that's what it matters. You made it, you are here. Here. So okay, so that thank you very much for this, Paula. So a life sentence in North Carolina, but we are in South Carolina, but should be the same. A defendant will remain in prison for the rest of their life. The only way a defendant serving a life sentence can be released is through executive clemency from the president. So, uh, you get here when you are supposed to be here, like Zio would say. Yes, it is South Carolina, but it should be the same. So it is an end to our friend Zachary Hughes, the second Zachary that we get to cover a trial. I hope the sister can now find a little bit of peace and closure, at least with Zachary. There is still gonna be Mellow to come. Which cutie? Which one with the red suit? um. Oh, the cop. All right. Okay. So basically that's it, the feed will be over. I was just like see, oh, you guys are hilarious. This was a great case. It was because oh my god, now the chat is gonna get confused now. um and no, Willow, it's not. um you guys are hilarious. You guys are the best people, and well, exactly. It that is true. Because see, there we go. Oh no, wrong one. Where is it? Oh, there. Um. So that's it. He's gone for life. I'm sure he's gonna appeal to courts, and he's gonna be back, but is done. We are done with Zach Hughes. I have updated our spreadsheet, so that is a closure. In terms for the next trial, guys, I still need to do research. um I need still to do research on what is happening. Because that's exactly what I'm saying, Pickles. There is two options. There is an option we can start a new case tomorrow, and do that, but there's a case that's starting possibly on Monday that I really want to follow. And yeah, so the one that I really want to follow is the Lori Daybell, Valo Daybell, that girl. I really want to follow that one. But first of all, I need to talk with Nightbot about it because it's Arizona. It's 7 hours difference than us, so that would be a little bit um more difficult for us. But then a part follow development, yeah. Ruby Frankie, she's already convicted, girl. She's gone. She's done. She's serving a prison sentence. So Ruby Frankie is gone and dusted. She's serving a prison sentence. Um, so that one is gone. The court docket only shows 2 days. Yeah. So I need to search that better. But whenever Lori Vallow comes around, if not Monday, we'll be following her. Getting confirmation that I think it's only March 18th. So we might start the new one tomorrow and do that one until wow. 673 books. That's yeah. Am I doing Kohlberg? No. Very. Oh, who is that one? Maxwell Anderson. Might do. Kohlberger, for the simple fact that it's Idaho. It's like very far away from for me to catch, but and the length of it is 4 months trial. I am not gonna be doing a 4 month long trial. I'm sorry. My ADHD or attention span or whatever you want to call it, I am not gonna have the patience to follow 400 witnesses. Like, there is Texas cases. I think there's plenty of Texas cases, but not televised. There is one um um there is actually one going on right now, and I am super upset that is not being televised. It's one about a twin brother, the a set of twins that a twin kill and alive the other twin, but that one is not being televised for some reason. So yeah, that one I wanted to watch, and is ooh, pickles. That would be amazing. I mean, find a case, and if it is televised, let me know, and we can sort that out. We can watch it. So, absolutely. Man, it depends on what areas pickles is in, but yeah, the twin killed this twin. That trial I want to watch, but it's not being televised. It's only shown bits and pieces by Core TV, like they do, and it's not being televised. And he's 17 years old. I really want to watch, and he's being tried as an adult, and I have been obsessing with that. But yeah, not being televised or streamed. So, which really grinds my gears, as you can see. Yeah. Yeah, so yeah, Law Vallow is March 18. So we might start a new one tomorrow. I know, Willow, 400 witnesses. That's the prosecution and the defense said on Kohlberg 400 witnesses takes 4 months. I don't have patience to be covering the same trial for 4 months. I have okay. All right, I will definitely keep my eyes peeled. Pay calls to that. Sorry, I need to take a thing of that, so I can keep Menendez. Yes, Menendez. I absolutely yes. Oh, good night, Paula. See you tomorrow. See you very soon, darling. I'll be in touch with you. I'll be texting you soon. Menendez. Yes, I am gonna be covering that hearing. That is gonna be. I think it's at the end of March. I think because it's at the end of March. It is on. It's on a Monday. Um, Oh, okay. Yeah. Oh, wow. It's guys, it's 20 past 20 past midnight. I need to get to bed. I need to shut up. I could talk forever. We can talk more tomorrow. I'll stream tomorrow, so not to worry. Have a good night, guys. I am so sorry about that. I get to talking, and it's Pickle's fault. I'm joking now. Thank you very much for everything, guys. It was a great day, a great stream yet again. Amazing. We finished a great trial together. Have a good night. Have a good afternoon, evening, wherever you are. And Pickles love you, man. It's fine. But have a good night, guys, and I'll see you on the flip side. Bye.